Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Dati mihi Anglican, or East Service Latino.
Is that correct?
That's literally not true. Oh, for Trump's sake.
Is that
All right, we're trying this. And it doesn't work. All right, that cut off the music, right? Why is there echo? There's still an echo. Okay, is that any better? Is that any better? I had the wrong. I had like a microphone on the chair turned on, and the chair mic is never. It's never a good idea to have your chair mic'd. Just for the record. Let's see. So now let me go back and change it the way I had set it up initially and see if that works. Let's see. Let's say we go this way. Is there an echo now? Sounds good now. No echo. I've got someone calling to complain already. Complaint hotline. This is Scott. Who am I speaking with?
No complaints whatsoever. Just support.
Okay. Okay. Can you guys hear who's on the call? Hang on a second. I just make sure that
I'm waiting for my feed to catch up.
Okay, can you mute your stream for a minute? Because that's going to just probably put me over the edge this morning. This is driving me nuts. I've been fighting it all morning.
So, yes, everybody's saying that they can hear me.
They can hear Amber. Okay. Okay. So far, so good.
And you're not echoing now, which is fantastic.
No, I had a chair mic turned on. It sounds like this. Isn't that just great? Yeah. I don't know why I even have that button. Why is that button there? we never use the chair. It's actually the GoPro.
Why do you have a chair mic?
It's this GoPro mic, but it just hears like the squeakiness in the chair. If the chair ever makes sounds, and it's always the chair, it's not me, right? If the chair ever makes sounds, it picks it up. So that mic never should be on ever. Good morning. How you doing, Amber?
Good morning. I'm fantastic. How are you? Do you need a minute?
I might. I'm like half an hour late, and I couldn't get things figured out this morning. I don't know what you guys heard this morning. If you heard anything, might have been absolutely terrible. But
everything has gone flawlessly.
How do you demote? Just asking for a friend. How do you demote mods? Is there a way to? What's the procedure for unmodding? Amber,
I have another request, by the way, for the exclamation command for shame, because I already sent you the audio for that. I was just called out, so I have to call you out.
Did you send it again this morning? That
no,
helps.
But I can.
It helps when you send it again. Not that I lost it the first time, but it's just a reminder.
I got you. I'll send you your reminder.
Okay.
And then Greeners will leave me alone.
Yeah.
Or I'll time them out. One of the two.
Oh, Greeners, by the way, first in chat this morning. Let's see if I can do this correctly. I can put them on screen right there. There we go. I'm trying to use StreamYard and my mixer, which is always, it's a nightmare because StreamYard wants to manage all the audio. Like they think they're in charge. And I'm like, no, I've got it covered. But then the two fight and I lose in the middle. So
yeah, and I noticed that the delay from calling in to airtime is a little bit longer too.
Yeah, they won't let me do a ultra short. I've got the 2 gigabit high speed internet for that reason, just so I can have the shortest delay YouTube allows. StreamYard does not allow you to shorten that.
Nope. All right, I'm gonna hop off here and let you.
It's my biggest bill every month is StreamYard. You know that? It's every month. I pay more for StreamYard than any other service which we use on the program.
That's nuts.
And it's killing me. It's killing me, Smalls. Quick question for you, Amber. Of all the things that happened yesterday, what was your favorite? I'm not talking about me messing up. I'm talking about like true crime events.
I don't know. It's a toss up between the transcripts from Young Thug and Michael Proctor getting
rehomed.
Yes.
That was crazy. The transcripts showing up were a lot of fun. I think we were sort of overshadowed by the Michael Proctor thing going on, but like 10,000 people have watched that already. I think maybe 9,000. I might be a little overzealous in that, but a lot of people watched it overnight, which was really cool.
Yeah, it's been. I've been watching the comments and stuff too. It's been really crazy, and the misguided approach that the judge gave everybody as far as what was discussed, and there was no witness intimidation. I want to know how that's not witness intimidation. Like,
it is so bad, and I cannot wait. I think Friday Night Frenzy, Rob's gonna run with this. He's been talking a little bit about this on Twitter. He's like, this is so much worse than the judge made it sound, and how so much worse than the lawyers made it sound in their filings.
Yep.
And yeah, we have major issues of the state knowing that the witness has an attorney and talks to him outside the presence of his lawyer anyway, and he's just I'm like, ah!
So I want your opinion. Mm-hmm. Do you think this is going to cause a mistrial for the entire Young Thug case?
Well, when you say entire, you're talking about all these 6 defendants.
Correct.
There are 12
this
more.
Current case.
But this current case is looking like it's going to get a restart. And it's going to get a new
I don't
judge.
see how they can't. I don't see how they don't completely declare a mistrial and start all over with a completely different judge because of that ex parte meeting, of course, among other things. But that ex parte meeting, to me, just null and voids the entire trial.
I can see where they tried to keep the ex parte meeting right, but there were, I mean, the times where you say, "Judge, plug your ears, you don't want to hear this," and yeah, there's some things that they knew they probably shouldn't be saying in that meeting, and even when they started talking about specific testimony, they're like, "Oh, we probably shouldn't talk about that. Let's use an example." Yeah, there are some things that were wrong, very, very wrong there. This is something so foreign to me as watching true crime that I want a lawyer's take on this. I think Miss Bumpus did a phenomenal job interjecting and just pointing things out. Mr. Copeland,
I think,
is a lot smarter than he lets on. And but wow, the frustration of somebody who, he's caught up in something crazy he shouldn't have been involved in. I'm not defending him in the slightest, right? It looks like he was involved at least with a criminal enterprise. And
yeah,
and so he's wrapped up in that, called as a witness. Well, guess what? One of the great things we have in this country is the ability to plead the fifth and say, I'm not going to testify because this incriminates me. Right. And he goes and he tells the prosecutor, he says 3 times, I told you Tuesday, I told you Wednesday, I told you Thursday. I said, I'm going to plead the fifth. I'm going to plead the fifth. I'm going to plead the fifth. Then surprise, surprise, on Friday, when he gets up to testify, along comes the state and says, by the way, we've got you this gift. It's immunity. That means you can't plead the fifth. And we got this for you. He says, I don't want it. It doesn't matter. It's yours now and you own it.
Right. Like, how can they impress upon you an immunity deal that you didn't want and then turn it into an order to force you to testify and say you can't play? You can't force somebody to give up their Fifth Amendment right. You can't do that.
Yeah.
So
I would say he needs to develop the only thing available to him, and this is frustrating. And normally I would say everyone should tell the truth, the whole truth, and nothing but the truth. But man, this guy got worked over dirty, and he lost rights that are spelled out in the Constitution by the way he was treated by the state. Okay, and that is frustrating. And they did it in a way that is apparently legal.
You don't want people to know what you did to me.
Yeah, I want to be there in jail stripes. Drag me out there in chains. Yeah, let them see. Let them know. Like, yeah, we'll get you a suit coat. No, that was absolutely phenomenal. Loved all 56 pages of that transcript.
You did really well. You did really well reading. And even though you didn't take my suggestion of the different voices per person, because that just would have been phenomenal.
You know why I didn't? I would like default to some very poor Southern drawl, and I would get like hate mail, like why are you making fun of this area, or why you don't sound like them at all. Like the best I can do is just tell you who's talking, and that's I'm pretty sure there are whole ethnic groups that would be offended by my attempt to make a voice for somebody, and I don't want to do that. I'm not. That's not the purpose. I'm not trying to.
That makes sense.
Yeah.
But just taking it back to juror number 1 in Maya's trial, can you put on some wigs and change your voice up a little bit?
I was thinking sock puppets is the next best thing, but I needed a few extra arms is all.
Are you going to decorate the socks?
Oh yeah, a little button eyes in the mouth and everything, and I'll even do the motion right.
That'd be a great project for the kids.
I think why not throw ventriloquism in there as well, and then have them like, my mouth doesn't move at all. Yeah, we'll make that happen next time. That'll be a lot of fun. Oh my goodness.
All right, I'm getting off of here so you can actually get your show started.
Good morning, Amber. Thanks for calling. Appreciate you.
Morning.
All right, we'll see you. Bye. We have to officially welcome Greeners, who was first in chat, almost first with a super chat again. But once again, Neezy came in and thwarted your efforts to be the first in chat with a super chat. I don't know how that worked, Neezy. I think you're just obviously I need to give you a kickback because apparently Greeners is going to keep paying as long as you keep thwarting his efforts. So let's go ahead and promote that little iterate. What is it called when you repeat something over this iterative cycle? That's it. So Greeners, thank you very much for being first in chat. The internet's all yours, my friend. Appreciate that. Lana JM says, can you please sing happy birthday to my daughter Shanti? Pronounced Shantae. I'm sorry, I should read this before I say it. She's 33 today. We will add her to the morning sing-along song. And Vicky comes in with "Get off my lawn." That's we used to think that was like a Clint Eastwood line, but no, that was apparently originally proffered by Mr. Proctor. Thank you very much, Vicky. Fun little clip there that's going around on social media and the normal media as well. So we have, there's the buffer sounds. Well, it should have gone. Let's see. We have Shantae, Joshua, and Warren also celebrating their birthday. And then Helena and her hubby are celebrating their 19th wedding anniversary. That is just really cool. Congratulations on 19. We're going to, hopefully everything's going to work. Please, first, can you hear this? I'm going to use some demo music. Can you hear this sound effect?
Because he's the guy.
Can you hear that? I need some confirmation that that's working. Because with the delay and everything else, I don't want to be the only person singing. I'd really not like that to happen. Did you hear because he's the guy? Man, this delay is killing me. Yes. Okay, we got yeses. That means you're going to hear the music. So I need you to imagine that we're all singing in time. Because in reality, what's going to happen is I'm going to sing, and 10 seconds later, you're going to sing, and it will sound perfect. It will sound right. That's just the way it works with StreamYard. But we're going to sing to Joshua, Warren, and Shantae. Shantae 33. Happy birthday, Shantae. All right, here we go. Let's sing together. Warm up with me, if you will. La 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 la. There we go. Blend your voices with mine. Stand up, deep breath, project your voice to the back of the room. Sort of blend in with your neighbors. Makes the sound best. Dancers at the ready. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Joshua, Warren, and Shantae. Happy birthday to you. Joshua, Warren, and Shantae, I hope this Tuesday is the happiest birthday you've ever had. I hope it's wonderful. I hope it's great. I realize there are a million places you could be, a million people you could be with, but you've chosen to be here with us. The privilege and pleasure is all ours. Thank you very much. Make sure you help yourself to free pancakes at Denny's or IHOP or wherever it is they give free pancakes before they stop giving out free pancakes. My lawyers have told me not to say before they go out of business, because apparently that's something businesses don't like hearing people say about them. so I won't do that. Dancers look great. Thank you very much. The Hawaiian, you've been practicing for sure. You guys are amazing. Happy birthday. Chair mic is terrible. It is. We're not going to use chair mic again. It's not going to happen. But I'm glad I found what was. I don't know why I even turned it on. I don't. It seems strange. All right. As the birthday song is fading out, apparently we have a phone call coming in. Let's see who this is. Hello.
Call from Bree.
Bree.
Good morning.
How are you doing? How are you doing?
Good. I'm good. So I'm kind of going through a little bit of withdrawals. I don't have an OnlyFans this morning.
Oh no. I could probably bring one back if we need an OnlyFans.
Do you know that there was a Reddit stream that was counting like the revolutions of the fan during the trial?
Oh my goodness! It counted the revolutions.
Yeah, they were there was people on Reddit just going through counting the revolutions of the fan, and
there's somebody going 1, 2, 3, 4, 5. I'm sure they probably use some AI bot to track. They're like, we're going to place a tracker on this pixel, and we're going to follow it around and get the RPMs and do the math and calculate it. It must have thrown them off completely when she says she's going to turn off the air conditioning, because then it's like, is the fan spinning or not? Now we don't know. Is it accurate? That's funny. That is something very, very Reddit to do. That's Reddish. Reddit-ish.
So the withdrawals usually causes me to go shop for something. So now, based on Amber's phone call, I can't tell you what it is, but you have an option. You can have option 1 or option 2, and that's all you get told. You have to pick.
I think option 1 is probably what you chose first, and then you had a second option, which is probably
that's how things go.
lesser, meaning lesser over the top. I'm going to go with 1. I think if it was your idea first, we're going with that one. So let's go with option 1.
Okay. I just need you to keep your eye on your PO box in the next week.
Okay. All right. I will do that.
Amber, this will be a great day.
Oh my goodness. So apparently we have to do an unboxing live as well. Okay.
Oh, for sure.
All right, Bree. It is good to hear your voice again. It's been a while since we've talked. How are you doing?
I know. Good. Getting ready for good old Alec Baldwin coming back up.
Yes, on the 10th he's starting that. So we've got about 8 days before that one. That's going to be great. We're going to be there enjoying that in all of its glory. Until then, I'm
scared to see downtown this time, because I'm sure it's going to be nutty. I don't know if they're going to even. I mean, I know it's still open to the public, and depending upon my schedule, I'm going to try and get down there. But I don't know how it's going to go, if it's going to be as easy to get in as it was with Hannah. Yeah.
And did the judge rule that Hannah doesn't have to testify? Is that what I heard?
That's what I heard, but I haven't got to look. I've been so kind of stuck in Karen Reed world that I was trying to catch up with Alec Baldwin and all of that.
It seems strange that we wake up and we don't have a fan. We don't have Karen Reed. We don't have anything. It's going to be till July 22nd before we hear anything else on that. But honestly,
and Proctor got rehomed like the rest of the stuff in the case. So, there's always that.
I need to know where he got rehomed to. I'm sorry. Somebody should get a warning. Like, there should be announced in the paper. Just FYI, we've got a new trooper on the beat. His name is Proctor. If you see him, don't do anything wrong, or just don't look. Don't see him. It's going to be the advice.
Don't give him your phone number, and you might be safe.
Oh my goodness. I want to know where he went. Yeah, I'm guessing that they probably put him on a desk job somewhere in another area, so he's out of the public eye while the investigation continues. That would be the smart thing to do. If they put him somewhere higher profile where he's out actually involved in police work, especially after they know that they have some serious behavior issues. Whether or not
somebody had said too, they're like, oh, let's just wait for the retrial, because when they put Proctor on the stand, been like, so after the last case was retried, what's your position now?
Do you still live at that address, or did you move? Why did you move? Oh, your job
Where's
changed.
your phone?
Why did your job change? Yes.
Well, for the next version, I'll have to send you that good old Karen Reed starter pack that we got everybody else at CrimeCon. It was an adventure.
Oh, I've got my Stop and Shop bag right here.
Yeah, I met Pants, and that's how we got it to Brandy.
Oh, yeah. So
it was so much fun.
They're awesome. I think Brandy's going to be at Sarah Boone. I think I'm going to go down to Sarah Boone as well.
Oh wow.
Lawyer you know is going to be there. It's going to be a lot of fun at that one. Although I do anticipate it's going to be a shorter case, because honestly, cross-examination is. There's not going to be an extensive list of questions from Sarah Boone. That's not her forte. She doesn't know what she's doing there unless she gets a lawyer. It's going to be a pretty quick case. It's going to be all state and then one witness for the defense, because she doesn't know how to call people. And it's going to be her, and that might take a day or two. But
well, she's going to write her letters, though, with all of her questions on it in advance. She's going to be herself practicing with all 58 pages.
The thing, you bring that up, but I'm serious. I think that her case is going to be more about how she was treated than the actual crime. The how long it's been, how many lawyers, her lost evidence. That's going to be like the underlying theme throughout the case. Every time she talks, well, I would have this, but my lawyer lost it. I had this paperwork, and somewhere in between lawyers 2 and 5.
And that would have let me off. If I would have had that, I would have been found not guilty right now.
Yeah. So
it's gonna be a wild ride this summer. So
it'll be
here
crazy.
we go.
Bree, buckle up. Here we go.
Exactly. Well, I'll make sure that you get your gift for the rest of the summer, because we're gonna need it, I'm sure.
All right, I'm excited. Thank you very much, Bree.
You're welcome.
We'll talk
to you guys later. Bye, chat.
Bye. Bite Me. Rebecca says, RA is the greatest. You rocks. Buttercup sends butter sugars to everyone. Thank you. Bite Me. 17 months. Thank you. That is amazing. Lenova sending birthday cake and birthday unicorns, I believe, all around. So thank you very much for that as well. Going back to our live chat, I think we have a buffer sound in there, so I missed something. Shame. I could make it live, or we could let's do this. Let's find a quick court case that we can pop in on. I think Judge Simpson was live this morning. I think he is. Let's jump in on Judge Simpson, and when we do that, I'm going to start trying to make this shame audio. I'm not sure if I can do it like that, but we'll try.
That has a next court date of July 22nd. So
on 14B matter.
Yes. And so once that matter is resolved, we believe that we can resolve this rate.
So why don't I put this to the 25th then?
So yes.
Well, that makes sense. The 25th.
Absolutely.
Probable cause conference in these matters will be adjourned July 25th, 2024, 9 a.m. Bond continue.
And just briefly on bond, very briefly.
Yes. Go ahead.
She does need to be able to take care. She's the caretaker for her brother. He has a traumatic brain injury. I'm sorry, fiance. And she is the one who basically is his kid.
Brother, if
missing his
that one
appointments
right
now. She'd like to be allowed to have a bond so that she continue to help take care of her caretaker.
Well,
welcome, Ian.
I think I'd like to give her a bond too, but when I look at the offenses, I have no way of monitoring her or her conditions, because I've got tampering with the electronic monitoring devices when we let her out. So I don't need a response from the people motion for bond reduction or any changes denied. Thank you.
Thank you.
Apparently StreamYard's audio is a little bit, or video quality is a little lesser than what we normally have. I apologize for that.
Calls the case, People versus Zachary Burlett.
We're ready now. Warren Brown, Deputy
Just disappeared.
Deputy Chief Public Defender, being on behalf of Mr. Burlett. Mr. Burlett he's at the home of New Vision. He was on the screen. I can only.
He was. I saw him. Mr. Burlett.
I'm betting a restroom break.
Oh, there we go. He's making a grand entrance.
He's coming in. Mr. Burlett, there he is. I think you were right.
Good morning. I apologize.
All right.
Mr. Burlett, could you state your name for the record, please?
Zachary Thomas Burlett.
Thank you.
Your Honor, today is the date and time set for probable cause conference. I do believe that we're able to work out this matter through a misdemeanor resolution of retail fraud. Second, however, the prosecution will need some time to be able to write that up. So we'd ask for an adjournment, as brief as can be given, so that we can go over the plea agreement with our client and have the prosecution.
Well, we didn't have to rid him, so I'll do July 11th, 2024.
Thank you, Your Honor.
Bond continue.
Thank you.
Thank you all. Have a happy holiday.
You do the same, sir. Court does call the case People versus David Mayor Quinn.
And good morning, Your Honor. Assistant Public Defender Janelle Carey, really on behalf of Mr. Mayor Quinn, who is approaching.
Hello.
David Merrickman.
Thank you. All right, what are we doing?
Your Honor, Mr. Mayor Quinn is currently scheduled for competency. I did confirm that hearing or that exam is going to be held on the 26th of July. So we'll be needing
Is when his exam with them.
That is correct. His yes. Evaluation, I guess that's the better.
Yeah. On the 26th.
July 26th.
Okay. Tell you what I'll do then. Let me put this out. Do I have the 22nd bonus?
Yes.
All right. I'll adjourn his comp hearing then to August 22nd.
Shame on you, sir.
2024 at 9. If we get the report earlier, we'll move the date up pursuant to the statute. That way. Okay.
And we would like to address bond, Your Honor.
Go ahead.
Your Honor, Mr. Mayor Quinn is asking that the court consider a release, hopefully on a GPS tether or in the alternative to a treatment facility. He is a mental health recipient. I've reached out to the mental health court who he had completed a particular probationary period with. They can't do anything right now while competency is waiting, but he'd like to see if he could get into some type of substance abuse. I know that one of the bond violations does stem from an allegation of substances found on his person during a routine stop. So he'd like to see if the court would consider at least letting him be released into a treatment facility to start getting treatment.
I normally would not have any objection to that. However, we're pending the report. So at this point, I'm going to deny the request for the bond modification. Thank you.
Thank you, Your Honor.
Calls case People versus Jeffrey Gibbs.
Ready in that matter, Your Honor. Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Jeffrey Gibbs.
Mr. Gibbs? Have they checked it?
Well, Your Honor, I have paged the courtroom. I've received no response. I understand that he's been released from the Washtenaw County Jail. I do not know if he had information for the new date. So I will respectfully request an adjournment.
He seems surprised.
Oh, he got it.
An adjournment.
I gave him the new date. I gave him the date before.
Still makes you forget things, Judge.
I forget things? Oh, that'd be you. Bench warrant will issue bond, but we said 10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you.
Court calls the case of the People versus Rebecca McCree.
Why is that not working?
Hello.
Hi.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Rowe. Would you state your name for the record, please?
Rebecca K. McCree.
Oh, I'm so sorry. Your Honor,
Shame on you,
at
sir.
this time, we are requesting an adjournment. We have some additional discovery requests that we'd like to make of the prosecutor.
July 25th, 2024, 9 a.m.
Thank you.
Thank you.
Thank you, man. Court calls case People versus Brian Haney.
Andrew Phil is appearing on behalf.
Yeah.
He's out of custody, Your Honor.
Yes, he is.
Public.
You want me to change that or no?
I'm just surprised. Assistant Public Defender Ben Denowith on behalf of Mr. Haney.
How did my client?
Your name, sir?
Get out of
Brian
custody?
Haney.
All right. So what do you want to do?
We'd like to adjourn. There is some body camera video that we have not received yet, which would be crucial to our decision as to waive or hold.
Probable cause conference, July 25th, 2024, 9 a.m. You want me to continue with bond, right? You want him to fill out? Okay.
Yes.
Bond continued. Sir. Court calls case People versus Franklin Melton.
Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Melton. Mr. Melton, state your name for the record.
Franklin Joseph Melton.
Thank you. Come on, people.
Yeah, Jeff Clemens on behalf of people standing for Amy Reiser, who's next to her, and taking a waiver real quick.
Okay, so what do we do?
Well, we need to verify a plea offer that we believe has been made. So we need her to be able to come in and say, yes, that is it.
I'm sorry, Your Honor. I'm just trying to stand in and help out here, but I don't have.
Yeah, fine job you're doing. I'll pass it. I don't know.
That was a little harsh.
Court does call the case People versus Marquise Trice.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Trice. Mr. Trice, will you please state your name for the record?
Marquise Trice.
Sorry. Thank you. Your Honor, we're asking for an adjournment. I believe there may be some additional discovery that we're waiting on.
July 25th, 2024, 9 a.m. Without objection, bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Sterling Paris.
On behalf of the people.
Two cases.
Edward Drukas on behalf of Sterling Paris and 4-2 matter.
The public defender in this other matter.
If it was Mr. Denowith.
I did speak with him and we were looking for 2 exam dates.
In your case, Mr. Drukas, all your discovery is complete.
Yes, Your Honor.
People would have their witnesses available on that case, the one ending in 0042. Would you have your witnesses available on the 9th?
That's fine, Your Honor.
Preliminary examination in that matter in person, July 9th, 2024, 9 a.m. That is before Judge. For me.
Before
I'm
Judge
sorry,
me.
they should be the 16th. I apologize about the date. Should be July 16th, 9 a.m. before Judge Balvo. That was my mistake. I apologize. Bond on that matter will continue. Mr. Simpson, you're welcome. On the other matter, what are we doing?
Yes, Your Honor. Mr. Paris's matter ending in 1150, Assistant Public Defender Ben Denowith on behalf of Mr. Paris, we're also demanding an exam.
Yeah, all discovery is complete.
I'm sorry?
Is all discovery complete?
Yes, Your Honor.
People would have their witnesses available the 16th.
Yes, Your Honor.
Preliminary examination in person, July 16th, 2024, 9 a.m. That is before Judge Bravo. Bond continued. Thank you, sir.
Thank you.
Court calls the cases of the people versus Mark Austin. This isn't a random.
Yeah, that is also out of custody.
Mark Austin.
Ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Austin. Mr. Austin should be in the lockup.
Should be where? In lockup?
No, I'm sorry, Forensic Center.
I'm sorry. I thought Mr. Brown said he was. Shame on you, sir.
No, I'm sorry, that was Maurice. I'm sorry. But I said Mark Austin.
Okay, I think I finally got shame working. So the first person to test it.
So what am I supposed to do? Nothing? Brown messed this up? Brown messed it up? Yes, here. Take these back. Don't listen to him. I told you don't talk to him.
Nothing's Ann's fault.
Oh, I know. Very clearly, but I want the world to know.
Maurice Anthony. That's
the one that he wanted me to call?
Not that he wanted you to call, but he indicated he was out of custody.
He's out of custody.
And I was giving you the last out of custody.
That must be him standing up ready to come up.
It worked. I just need to change the audio.
Court calls the case people versus Maurice Anthony.
We are ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Anthony.
Your name?
All right, I'm back.
Maurice Anthony. Thank you.
So, Your Honor, today is the date and time set for
Shame on you, sir.
preliminary.
There it is.
I'm sorry, probable cause conference. Your Honor, Mr. Anthony had been in the Livingston County lockup. He just recently got out. We haven't had a chance to really talk about what's going on in this case. He is here today, so we're asking for an adjournment just to be able to have a conference with our client.
Hearing no objection, July 25th, 2024, 9 a.m. Bond continued.
Thank you very much, July.
Court calls the case of the people versus Corey Peters. That's my last out.
Greeners, thank you very much.
Morning, may it please the Honorable Court, for Richard Johnson from behalf of Peters, who stands to my immediate right.
Your name, sir?
Corey Peters.
Thank you. What are we doing?
I'd like these matters to be set for a preliminary examination.
All discovery is complete.
Yes, Your Honor.
Shame on you, sir.
We'll have their witnesses available the 16th. Preliminary examination in person, July 16th, 2024, 9 a.m. before Judge Fresh Hour.
Your Honor, may I please address my client's bond?
Briefly.
My client is charged with 2 low severity felonies. He does reside in the Washtenaw County area. Do not believe he is a flight risk or dangerous. Allegations are that there were dumpster fires that he was responsible for. No one was hurt. No
there were
real
dumpster
estate was
fires.
damaged. Ask court to consider and release him on a PR bond. He has been declared indigent, cannot afford to post monetary bail.
I think he's talking about literal dumpster fires.
Thank you. The defendant's bond is denied in circuit court. His next hearing is not until July 17th, after our next date on this file. Also, he was on, I'm sorry, I don't know whether it was bond or probation. I believe it was probation at the time that he set these dumpsters on fire. And so he's now in violation of his circuit court bond as well.
So he's been denied bond in circuit court.
Apparently.
She's sorry. Yes, his bond is denied in circuit court, and he's held until after this preliminary exam.
Motion for bond reduction is denied. Bond continued.
Okay, if we get a dumpster fire
Court
soundbite,
calls case People versus Milton Ray.
we need it from court. It needs to be a court soundbite. So,
Morning, may it please the Honorable Court, Kareem Johnson, here on behalf of Mr. Ray. It's coming to my immediate right.
Your name, sir?
Right. Right.
Thank you. What are we doing?
And we ask that this matter be set for some examination as well, and I'd like to address Mr. Ray Bond.
All discoveries complete.
Yes, Your Honor.
People would have their witnesses available on the 16th. Preliminary examination in person, July 16th, 2024, 9 a.m. That is before Judge Valvo. As to bond.
I do not believe my client is a flight risk or a danger to the community. He has likewise been charged with a low severity felony. I am not aware, I was just appointed yesterday, I'm not aware of any prior felony conviction of my client. Based on the nature of these accusations, I believe my client is entitled to a personal bond. Magistrate who set the bond started with the presumption that my client was entitled to a personal bond as the court rule mandates. I don't see any factors that would have convinced the magistrate to require my client to post a monetary bill, Your Honor. So he'd be released on personal bond.
Bond.
The defendant has 13 open cases, most of which were open and pending at the time that he committed this offense.
So he was on bond at the time.
Yes.
Go
and
ahead.
He has bonds in all of those files. He would have to post himself.
Motion for bond reduction denied. Bond continued.
lawyer forgot to mention he's got 13 open cases.
Court calls case People versus Roberson.
For the people.
Good morning, Your Honor. Sydney Rushing on behalf of Mr. Roberson, who appears to my right. Will you please state your name for the record?
Carter Roberson, sir.
I have before me a plea form. Is that what we're doing?
Yes, Judge.
Plea form indicates that the defendant will be pleading no contest to the charge of attempted possession of a loaded firearm in a vehicle, the 1-year offense. Upon a successful plea to that, count 3, counts 1 and 2 would be dismissed. There's a sentencing agreement to no upfront jail. I cannot bind the sentencing judge to that, but also there's an agreement no delayed or deferred. That supports full understanding of the agreement.
Yes, Judge.
Yeah, I have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Carter Roberson.
Sir, it is this court's understanding that you're going to plead no contest to an added count 3. Is that your understanding?
Yes, sir.
Is it double parking?
Is the charge of attempted possession of a loaded firearm in a motor vehicle.
Yes, sir.
Attempted
Indicated
possession?
that's a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs and mandatory forfeiture of the firearm or device. Do you understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about a no contest plea I have to make sure that you understand. First of all, I need to make sure that you understand that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
You understand also, sir, that while I'm taking the plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
Basis for the no contest plea.
Civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Yes.
Now, you
First
understand that by
try.
pleading no contest, you'll not have a trial of
Usually
any
they say
kind.
guilty.
You signed an advice of rights form today? Any question regarding any of those rights? Look at paragraph 5. You'll see a copy on the podium. Those are your rights that you're part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights in that form.
Yes, sir.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
Going to be reinstated. Probation.
Pardon?
Probation, sir.
You're on probation. Okay, the court does have
Welcome
to
back, Ian.
advise you that your entry of a plea in this case could be considered a violation of that probation. If it is, that court could sentence you to the maximum allowable under that other charge. You understand that? Yes, sir. And you still wish to plead no contest? Yes, sir. Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest? No, sir. Anybody threaten you or coerce you? No, sir. You're doing this voluntarily of your own free will. And I want to ask that last one. Court has been handed and has reviewed Washington County Sheriff's Office report for their case number 24-41314. Any objection to the court having reviewed that report?
No objection, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be August 8, 2024, 10 a.m. before Judge Washington.
Thank you so much, Your Honor. Your Honor, may I briefly address bond?
A lot of these are public defenders.
Mr. Roberson's bond is currently set at 10,010%. He is unable to post that bond. Now that he has a conviction in this matter and we do have a sentence agreement to no upfront jail time, I'm asking Your Honor to consider lowering that to a personal bond.
He's on probation at the time this offense was.
Your Honor, they are aware of it, that he had the 2 hearings and his bond in those matters were lowered to personal bonds as well, while the pendency of this case happened. So this is the only case holding him in.
I understand, but at the time of this offense, he was on probation.
Yes, Your Honor.
Anything else?
No, Your Honor, other than he does need to get out to help his family. He did have a employment as well that has been held, but they're not going to hold it much longer. So, Your Honor, I am asking that you consider that he's already been incarcerated for 30 days. It has been lowered to a misdemeanor, and there is a sentence agreement to no more upfront jail time.
Any response from the people?
The best way to help your family is not commit another offense while you're out on bond or on probation. But is what it is.
I think because he was on bond, he's going to have to post something. I'll lower his bond, but it'll be 1,010%.
Thank you so much, Your Honor.
That's a huge reduction. That's $900 off.
We appreciate that.
If he doesn't show, we're going to take you, Ms. Risher.
Please don't.
He doesn't show, we're taking
That's
you.
how it works these days. Court does call the case. The people versus Carter Scale.
I think Ian has some pending court appearance.
Good morning, Your Honor. Samuel Beckman with it on behalf of Ms. Scales, who's standing to my right. And Your Honor, may Ms. Hughes and I approach, please?
Briefly, yes.
Thank you.
While they approach and talk about something off the record, we did have the other day, there was a gentleman that owed the court about a quarter, I think it was just over $254,000 in restitution. Now, restitution might go to the victim as well. So I don't know what happened. Did he burn down somebody's house? I don't know how you get that much restitution. The guy had not paid, and I don't know, it'd been like a year. And before that, he'd only paid like $90. So he agreed that he was going to pay $100 a month to start paying off that. This is worse than a student loan. It sticks around forever. Hey, Ian, how are you doing? Are those bars? Are they bars on a window? It's funny, I guess, going to court, you've already got the bars on the window. Judge, can I just have home confinement? I've already got it set up. Anyway, that was a funny one earlier this week. We might have another document to read here in just a bit. Oops, I don't want that one. Let's close this one out. I want this one. Amber, are you super busy? I have a really hard time taking documents from Twitter attachments to make it something that I can read.
Shame on you, sir.
I know it's one of my failings, but I'd like to look at this Young Thug. I don't need all 114 pages. But if somebody has, or maybe Samantha, if you have that, you got it. You got it. Okay. That's what I'm looking for. Brian Steele, your studio is really dark. Pam, it's very dark. Even this one's very dark. This is my studio. Obviously, I'm not actually physically in all the courts that we visit, but I'm waiting for Ian's court case to come up any moment now. The judge is seeing somebody at sidebar right now. Thought we had another judge going here, Judge Wolf, but it looks like he just finished. Maybe he'll be back on in a bit. I'm hopeful, got my fingers crossed for maybe some action out of Thurston County, Washington today as well. It's been a while since we've been up to court there. We're hoping that something's coming up. Let's see, Judge Boyd. Judge Boyd is live. Let's see if we can jump to her really quickly.
That's awesome. Those were the days.
I know, there was like a better sense of community.
All right, is your client Crystal?
Let's see her purse
The
today.
mother is Crystal.
Ooh,
My
it's quite
client is
yellow.
actually in custody.
All right, so she's on Zoom. So as soon as I call the docket and she comes out, we'll take care of it.
Wonderful. Thank you.
Is that a vase
Ace
purse or is that her
Cantu.
purse?
Ace Cantu. Jose Sanchez.
You stand up and you hear your name.
Victor Garcia is in custody. Dominique Nicholson.
She's calling roll. This is Judge Stephanie
Christopher
Boyd
Esquivel.
in Bexar County, Texas.
Thank you. Orlando Medellin.
She takes
Custody.
no crap.
Audrey Bash. Audrey
While she
Bash.
continues calling roll, we're going to jump back to Judge Cedric, who is back here without any audio. Judge, can you fix that for us? Audio's off. All right. Mouse. Do we have a mouse? Was the mouse on the screen? Sorry, that was my bad. I can move that. I'll fix that. I want to see what happens with Ian. Obviously, if the judge audio is off, Ian will not be able to hear her case be called. So we're hoping that it does. Sheriff in Thurston's been making a lot of busts lately. He does quite well at that. And then the press conference. Oh, I was thinking Florida. Do you think the sheriff has found Mr. Farag? I need Ian to type in chat. I can't hear the judge.
Shame on you, sir.
Yes. She typed something. She's quite pleased with herself. All right. Let's see. Document, steal proffer. Thank you, Amber. You were a lifesaver. 114 pages. We're not reading all 114 pages. 56 yesterday was near my limit. Beep, 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 beep. Okay. Why did that not work? I've got 8 pages from you.
Shame on you, sir.
You guys like that shame soundbite. Okay. We might look at this really quickly. This is from Attorney Steele, who was the attorney who brought to light the Young Thug issue with the ex parte meeting. And he's adding some more stuff to the record. It did this late last night, filed at 5 p.m. So while the judge is trying to fix the audio, can we get a speak up command? Esbar, I'm cool with all those commands, but I do request that all the commands, I don't want to like pull things from like movies, like Hollywood movies and things like that. So when something happens in court that we watch, we think, oh, that's going to be a soundbite. If you can give me, like, send me a link to the burner phone with the timestamp URL that will take me right back to that video, and just a brief, hey, can we get this soundbite? Maybe even a suggestion of the command, what you want it to be. All the commands start with an exclamation point. Then we can see if we can get it created. I can't do all of them. Some of them they have to be very clear audio. But the burner phone, the email address, we actually have if you have a video that you've downloaded, like there's a court case that's not up any longer. Some courts do delete their live streams right when they're done. I do have a Top Mark WeTransfer page where you can upload those and it can go straight to me. That's an option as well. I think it's just, let's see, I don't know what my WeTransfer page is. Let's see, it is topmark.wetransfer.com, and you can upload files there, both audio and video. All right. Let's see. Well, the judge is still muted and doesn't know it, which is a little frustrating. We're going to jump to quick court doc read. This is only 8 pages. This will be a quick one, but it says page 1 of 114. Ignore that. It's actually not. That was the screenshot. I'm going to read this very quickly for you all, because this continues with what we read last night with the Young Thug. This is the state of Georgia versus Jeffrey Williams, also known as the Young Thug trial. This document just barely became public, I think either last night or first thing this morning. Notice of attorney proffer. After being prohibited from cross-examination and presenting a full critical defense at trial. He's trying to get more on the record before this goes ahead. Why can I not see that? I can't see it that way either. Let me click this way. Shark says, I'm at work, so this is me paying RA to ask someone to chat to send you the Pac-Man ghosted timestamp for soundbite purposes. Pac-Man ghosted. He ghosted us. Was that in Cedric's court? I think we watched that one live. Was that yesterday? Why am I hearing something? Let's see. Why am I hearing anything? Oh, it's because it's Judge. We're going to pause the judge down here for a minute. Don't need her right now. This was just the one page. We're going to get rid of that. Freeing up all these extra windows. It's beautiful. Okay, here we go. So the Judge Glanville, he had his complete 180. He allowed an outside judge to consider his ex parte meeting and the request for accusal, and that's moving forward. But in the process of this happening, they are asking that well, this attorney wants to get more on the record, probably for consideration in that same batch. He says, comes now Mr. Jeffrey Williams by and through undersigned counsel, and hereby files the notice of attorney proffer after being prohibited from cross-examination and presenting a full critical defense at trial in the above referenced case. In support of this notice of attorney proffer, Mr. Williams, undersigned counsel, show as follows. Background and attorney proffer. On Tuesday, May 14th, 2024, during the direct examination of Agent Riesi, lawyer Hilton represented the state of Georgia on behalf of the Fulton County District Attorney's Office played over confrontation clause and hearsay objection an October 22nd, 2015, 9:33 p.m. recorded jail call of Mr. Jimmy Winfrey and a person known only as Rashad. During this October 22nd recorded phone call, Rashad explained that he had heard from another unknown person that a Porsche vehicle as well as $250,000 was waiting to be given to Mr. Winfrey once he finishes serving time in custody. The prosecution theorized that this vehicle, come on, continuous scroll, please. The prosecution theorized that this vehicle and money were rewards for Mr. Winfrey's silence, not to speak with law enforcement about who, if anyone, was supposedly the person or persons responsible for the April 26, 2015 tour bus shooting and other gang-related crimes. Here's a link. To date, and based upon information and belief, Rashad, the other unidentified known person, as well as Mr. Winfrey, have not and will not testify at trial. Undersigned counsel does not know the identity of Rashad or have the unidentified person, and therefore cannot locate, interview, or call any of these persons as witnesses. Mr. Winfrey is a served, in custody, co-defendant, and based upon information and belief, he has or will exercise his constitutional right to remain silent. Careful, we know how that ends up. After playing this above reference recording for the petite jury, admitted into evidence as state exhibit number 140 EAB, the prosecutor questioned witness agent Raisi and elicited that within approximately a month of this recorded jail call, Mr. Winfrey pled guilty to indicated charges in Cobb County. Wow, the formatting just got away from me there. Dated May 14, 2024 at 5601 through, those are the timestamps. I like that they have YouTube timestamps in court filings. The prosecutor's clear import of this testimony is to persuade Mr. Williams' jury that shortly after being promised this vehicle and money, Mr. Winfrey accepted responsibility for this crime in order to show loyalty to the supposed gang. Thus, Mr. Winfrey did not fight his then pending Cobb County indictment by proceeding to trial, and instead sat mute in prison because he sacrificed himself for the betterment of the supposed YSL gang by entering this guilty plea. On Tuesday, May 14th, lawyer Hilton and everyone connected with this case knew or had a duty to know that Mr. Winfrey's guilty plea entered after this recorded jail conversation was deemed involuntarily tendered, as was withdrawn as the Cobb County trial court, specifically Cobb County Superior Court Judge Staley, was found to have coerced Mr. Winfrey to enter this guilty plea involuntarily. Thus, the involuntary guilty plea was not knowingly, freely, intelligently, and voluntarily entered. See Exhibit A, attached here too. Winfrey v. State. We've got a lot of case law attached to this one. In reality, this above referenced recorded jail call had no impact on Mr. Winfrey's decision to plead guilty, as the truth is that Mr. Winfrey was desirous to go to trial. In fact, on the date of the tendering this involuntary guilty plea, Mr. Winfrey maintained innocence and intended to exercise his constitutional right to a jury trial until the trial court coerced him to enter this involuntary plea. Based upon the above, the prosecution has manipulated facts and put forth knowing false information before the jury. That's a bar offense. Undersigned counsel immediately objected to this questioning by lawyer Hilton, and responses of agent Raisi and at a bench conference told the court that it was wholly shocking, untruthful, and misconduct for the prosecution to knowingly use a coerced involuntary guilty plea against Mr. Williams at trial. The court denied undersigned counsel's request for any relief or admonition to the jury to ignore, exclude, and remove any testimony regarding this month later guilty plea. Further, the court ordered undersigned counsel to not cross-examine agent Raisi on this false and misleading topic wrongly introduced by lawyer Hilton. There's a reference for YouTube. Later in the trial day on Tuesday, May 14th, undersigned counsel made an attorney proffer concerning his desired cross-examination of agent Raisi, since the court ordered undersigned counsel not to cross-examine agent Raisi on the topic of this coerced involuntary guilty plea. The Supreme Court's opinion in Winfrey v. State, supra, the fact that Mr. Winfrey wanted a jury trial, that lawyer Hilton's use of this coerced guilty plea was misleading and introduced knowing impermissible testimony, and that there was a Cobb County judicial misconduct that birthed Mr. Winfrey's involuntary guilty plea in 2015. And timestamp. Because of the court's order, undersigned counsel forfeited his cross-examination of agent Raisi regarding the accuracy and completeness of his testimony, and undersigned counsel was prevented from correcting the prosecution's intentional use of the coerced, withdrawn, vacated, involuntary guilty plea. Undersigned counsel intended to cross-examine agent Raisi to challenge this above-referenced trial testimony and to use the transcript of the Cobb County November 20th, 2015 involuntary guilty plea, attached here too, to admit, attached here to admit a copy of the opinion in Winfrey v. State, supra, whereby our highest court held that the guilty plea was not voluntary. Further, undersigned counsel intended to call 2015 trial lawyers for Mr. Winfrey in the Cobb County indictment, specifically the Honorable Lawrence Zimmerman, Esquire, as well as the Honorable Manny Aurora, Esquire, to explain the conduct leading to the entry above the involuntary and coerced guilty plea and their observations during this coerced guilty plea. Also, this is just a list of grievances he's going through that have led up to this point. Also, undersigned counsel intended to call Mr. Winfrey's appellate lawyer in Winfrey v. State, Supra, the Honorable Steve Shadow, Esquire, to testify about this coerced guilty plea, as well as the August 7th, 2020 Alford plea, wherein Mr. Winfrey maintained complete innocence and only entered an Alford plea because he received a time-served sentence. As all of the above would permit the jury to intelligently consider whether the October 2015 vehicle/money recorded jail call had any impact on Mr. Winfrey to forfeit his right to trial and or silence. Mr. Winfrey did not cooperate against Mr. Williams or others. This truthful evidence would also unmask the prosecution's use of untruthful testimony. Instead, undersigned counsel has been denied Mr. Williams' right to defend this case, introduce evidence, confront witnesses, and have a fair trial and right to due process. Mr. Williams has been denied his constitutional right to present his defense, has been denied his constitutional right to cross-examine on this relevant material issue introduced at trial by lawyer Hilton, has been denied his constitutional right to a fair trial, his constitutional right to correct the testimony, his constitutional right to introduce highly probative evidence and call a witness at trial, his due process rights, all under the below provisions of the United States Constitution and Georgia Constitution. And he says due process clause, 14th Amendment, the compulsory process clause of confrontation clauses of the 6th Amendment. The Constitution guarantees criminal defendants meaningful opportunity to present a complete defense. This attorney proffer is made to ensure that these topics are properly preserved. A mistrial would have been and should be declared based upon this court's ruling that denied Mr. Williams' constitutional right to cross-examine, his constitutional right to present a defense, his constitutional right to call witnesses, his constitutional right to a fair trial, and his constitutional right to due process. This attorney proffer continues. There's more. But wait, there's more. On Friday, June 7th, 2024, witness Copeland asserted the Fifth Amendment in front of the jury. That should never have occurred, as, based upon information and belief, the prosecution team, as well as this court, knew that witness Copeland was going to do the same before Mr. Copeland was called to testify in front of the jury. Before same occurred, undersigned counsel did not know that it was Mr. Copeland's intent to refuse to answer questions in front of the jury. Once Mr. Copeland invoked this constitutional provision, undersigned counsel immediately moved for a mistrial, which was denied. The court then denied Mr. Williams' counsel request to call witness to prove that the prosecution team knew that Mr. Copeland intended to invoke the Fifth Amendment in front of the jury if and when he was called to testify by the prosecution. Undersigned counsel desired to call Fulton County District Attorney Investigator Long and Lieutenant Langsquat, who is also employed by the Fulton County District Attorney's Office, to memorialize their knowledge that Mr. Copeland expressed that he would invoke the Fifth Amendment in front of the jury. Moreover, undersigned counsel intended to call reporter George Chitty to testify that he was ordered immediately prior to Mr. Copeland taking the witness stand and refusing to testify, not to video Mr. Copeland if and when the court ordered him to be arrested for refusing to testify. This is the proof. That was the court TV cameraman who was told to turn off the cameras and not film him being arrested. Based upon information and belief, reporter Chitty was given this edict by the Fulton County Sheriff's Office deputies based upon an order of this court. If true, this court had knowledge that Mr. Copeland would likely refuse to testify in front of the jury once called as a witness. From whom did the court receive this information? Why did the court not reveal same to undersigned counsel before permitting Mr. Copeland to testify before the jury? Attorney David Botts announced in open court that before Mr. Copeland took the witness stand, Mr. Copeland uttered, in close proximity to members of the prosecution team, that he would go to jail and would refuse to testify before being called a witness before the jury. When Attorney Botts announced this proffer to the court, this court stated that it had a problem with Attorney Botts. The blame belongs on the state for the calling Mr. Copeland, knowing or having reason to believe that he would refuse to testify in front of the jury. The same blame is attributed to the court if it knew the same information before Mr. Copeland testified before the jury. Mr. Williams and his counsel were in the dark about Mr. Copeland making it clear that he would refuse to testify in front of the jury. This court did not permit undersigned counsel to call any witnesses to support his timely voiced motion for mistrial. Hence, This proffer is hereby in place. Moreover, on April 29th, 2024, during the cross-examination of Detective Gaither by the Honorable Markswell Shart, Esquire, sorry, man, it's not your fault, counsel for Mr. Stillwell, Detective Gaither improperly injected her expert opinion that the criminal street game YSL committed a shooting of another person. Immediately, undersigned counsel objected and asked for a mistrial, and at the bench conference, this court found that the demeanor of Maxwell Shart Esquire goaded Detective Gaither into giving this unsolicited, prejudicial testimony in front of the jury. As proven in the trial audio and video, Attorney Shart never goaded this improper prejudicial testimony by Detective Gaither, and therefore the court's observations to perfect the record are hereby challenged. Wherefore, this attorney proffer is made to correct the supplement the record this first day of July, that's yesterday, 2024, signed by Brian Steele and Keith Adams Esquire, who are attorneys for Mr. Williams. So they've added this to the record to show the other times when this should have ended in a mistrial. It should have been a mistrial a long time ago. All right, let's see if the judge has figured out his audio issues.
In the 15th District Court.
We're back with Judge Simpson.
Yes, sir. You understand that?
Yeah, yeah.
Okay. Now, understanding all
Do
of
I have
that.
to get down there?
Pardon?
I have to get down there?
To the 15th District Court?
Yeah.
I think we'll probably provide transportation for you.
Uh,
But yeah, you need to be there. Okay?
Sure.
All right. So any other questions regarding that?
15th district, is that down in?
That's downtown Ann Arbor.
Oh, okay,
Okay?
yeah.
All right. You have any other questions about the plea or the charge?
No, sir.
All right. So to the charge of assault and battery, how do you plead?
No contest?
To the charge of attempted resisting and obstructing, how do you plead?
No contest?
To the charge of attempted resisting and obstructing contained in count 7, how do you plead?
No contest?
And to the charge of disorderly person, obscene conduct, how do you plead?
No contest?
Now you understand that by pleading no contest, you'll not have trial of any kind.
Yes, sir.
All right, you signed an advice of right to him today, is that correct?
Yeah, yeah.
Any questions regarding any of those rights?
No, sir.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights. Those are your rights which are part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest to these charges?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided Ann Arbor Police Department report for their case number 23-30258. Any objection to the court reviewing that report?
No, Your Honor, the basis for the no contest plea is lack of memory due to inebriation at the time.
I was too drunk to
We
remember.
would ask that that be marked and admitted as exhibit 1 and the basis for the plea.
Sure.
So Ashley Benefield goes to trial on July 9th
Okay,
or July
yes.
11th, the day after Alec Baldwin. So we're going to have to try to cover one on Top Mark Media, I think.
Right, right. I got a list. I'm sorry, sir.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule?
The defense is satisfied, Your Honor.
The people are satisfied.
Court will accept the
Defense is
defendant's
satisfied.
pleas of no contest to counts 4, 5, 6, and 7. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be July 19, 2024 time, 10 a.m. before Judge Perry.
Thank you, Your Honor. My client would ask that I just address bond briefly. He has a lot of arrangements that he needs to get up housing. He needs to get his Social Security benefits back in place. He's asking to be allowed to be out today so that he can start that process. Part of this is part of the plea agreement is that he not stay in the city of Ann Arbor. He needs to arrange that housing.
Is not stay in the city of Ann Arbor?
No go to city of Ann Arbor.
So where is he staying?
He needs to arrange that. He can arrange something Ypsilanti, but he needs to get that in place.
But he doesn't have an address at this point.
Not at this point.
Motion for bond reduction denied. I don't need a response bond. Will continue. Thank you. Court calls case People versus Devin Miller.
Good morning, Your Honor. Ashley Lonnie for the people.
What time does 14th District Court start?
And my name is
We watched
Craig.
the jury
Here
selection.
on behalf of Mr. Devin Miller.
All right, what are we doing today? Your name, sir?
Devin Miller.
Thank you.
Your Honor, there are some preliminary matters that are still ongoing under discussion. The parties are requesting an adjournment to July the 18th if possible. I asked for that date because that is when the co-defendant has also set this case.
And we're in agreement, Your Honor.
Probable cause conference will be adjourned July 18th, 2024, 9 a.m. Bond continued.
Thank
Thank you, Your Honor.
Thank you.
Yeah, right now.
Okay. Court calls the cases of People versus Mark Austin.
You're ready. Warren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Austin, I believe. The forensics.
They are not they're in the forensic center, my understanding. They have not signed in.
So the note here I see is for 11.
Pardon?
The note I see on the docket is for 11 a.m. They may be waiting till that time.
Oh, is it set at 11? Again, your fault, Mr. Brown.
No, it's not. Nothing is Miss Whiteling's fault.
I know that is absolutely your fault. You should have known that and should have been able to inform the court of that. I'm appalled at your lack of preparation.
This judge is hilarious.
Pardon? Oh, he had to have somebody else read it. He doesn't read it. Anyway, I think that's it. We can clear the way and let Judge Washington take over. All right, preliminary examinations before Judge Washington will start momentarily. Those of you that have non-in custody PCCs, we will be down in courtroom A shortly. Court is standing recess.
So apparently, judge is vacant in his courtroom. We're going to jump over to. We're going to zoom. We're going to zoom over to Judge Brantley Clark, who's down. I believe he's in Florida, right? I think he's in Panama City, Florida area. We watched the jury selection in this trial yesterday. The jury right now is getting instructions from the judge. I was fine with missing some of those. Let's jump down there and see where we're at. This should be a short one-day jury trial. Let's see how long it takes here.
He or she persists, leave that person at once and immediately report the matter to the bailiff, will advise me. All cell phones, computers, tablets, and other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of these proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside of the jury room. You cannot have in the jury room any cell phones, computers, smartwatches, and other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. The case must be tried by you only on the evidence presented during the trial and in your presence and the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're at the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. If you would like to take notes during the trial, you may do so. On the other hand, of course, you're not required to take notes if you don't want to. This will be left up to you individually. You have been provided a notepad and a pen for use if you wish to take notes. Any notes that you take will be for your own personal use. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you've completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. Take notes. Do not get so involved in note taking that you become distracted from the proceeding. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence and should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on the internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to assure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present arguments with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity. Our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings. A mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or held by me, you must not speculate on what might have occurred had the objection not been sustained, or what a witness might have said and he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. Mr. Sullivan, whenever you're ready.
Thank you, Your Honor. Counsel. On October 21st, 2020, this defendant, Gregory Stutler, traveled from his house to Pensacola, Florida, where he picked up a large quantity of methamphetamine. He then drove from Pensacola to the Lowe's on Back Beach Road out on Panama City Beach, where he thought he was going to be selling that methamphetamine to an individual. Unfortunately for him, when he got to Lowe's, the person that he was meeting to sell that methamphetamine to happened to actually be the Bay County Sheriff's Office. You're going to hear from a couple witnesses today. You're going to hear from Investigator Philip Hill, the Bay County Sheriff's Office. He's going to tell you that on October 21st, 2020, he was using a confidential informant who placed a couple of phone calls to the defendant, Gregory Stutler, and ordered up a quantity of methamphetamine. Those phone calls were actually recorded, and you're going to get to hear those today as well. You'll hear the conversation, what Mr. Stutler said, what he was going to do, and how he had to go to Pensacola to get that methamphetamine. There's a couple other conversations where they're kind of talking about where he's at in the process of getting from Pensacola to the beach. And then you'll hear that once Mr. Stutler arrived at that Lowe's parking lot, law enforcement surrounded the car, eventually searched the car, and in backpacks, there's an orange and black backpack in the front and a black backpack in the back of Mr. Stutler's truck. Suspected methamphetamine was located. You'll hear from a couple of law enforcement officers, Sergeant Jeremy Head and Lieutenant Kevin Francis, both of the Bay County Sheriff's Office. They're going to tell you that after finding the drugs, Mr. Stutler made some admissions. He said that everything in the car was his, and Lieutenant Francis said, "You mean the drugs?" And Mr. Stutler said, "Yes." You'll then hear from an analyst from the Florida Department of Law Enforcement, and she's going to tell you that she analyzed some of the substance and that it, in fact, is methamphetamine, and that the methamphetamine that she analyzed weighed over 800 grams. We talked a little bit yesterday during jury selection about what trafficking is, and we're talking about possession and delivery in this case of that methamphetamine, but the important thing is that it's more than 14 grams. That's the threshold for trafficking. And you'll hear from the analyst from the Florida Department of Law Enforcement that it is in fact over 14 grams and is actually over 800 grams. After you've heard all the evidence in this case, the judge will give you the law, and that includes what I have to prove beyond a reasonable doubt for you to find the defendant guilty. And I told you that yesterday. I have to prove three things. One, that the defendant knowingly possessed the substance. Two, that that substance was methamphetamine. And three, that the methamphetamine weighed more than 14 grams. After you've heard the evidence in this case, there will be no reasonable doubt. And at that time, I'm going to come back before you, and I'll ask you to find the defendant guilty. Thank you.
Okay, if all that is going to be proven, the defendant has an uphill battle here. Let's see what defense says.
Good morning. My name is Joe Turner.
His
This is
shirt's
Gregory
untucked.
Stutler. And today's case isn't about everything that I tell you. It's not about everything Mr. Sullivan tells you. It's about what you hear from this witness stand. Okay? And it's also, as he pointed out, the three things that have to be proven. It's about what you won't hear from that witness stand. There may be things at the end of this trial that you don't hear. If you don't hear the evidence that he's telling you about, then I'm going to need you to remember that and consider that. Because as we talked about yesterday, you agreed that you would want to see the evidence. You would want to hear that it was analyzed. You'd want to see a chemical analysis. If by the end of the trial you haven't seen that, I'll be back here to ask you to vote not guilty for Mr. Stutler. Because it's the state's burden the entire way through the case to prove each element beyond the exclusion of every reasonable doubt. That he possessed it. That it was a substance controlled by Florida law. That substance tested to be that. And that it weighed over 14, or in this instance, I believe 200 grams. Members of the jury, there will be several witnesses here. Some of them are going to tell you what Mr. Sullivan told you that they will, and some of them may not. But I want you to ask yourself, what evidence didn't I hear? You're not going to hear from that confidential informant today. If at the end of this trial, there are still questions in your mind, I'll be here pointing out what inconsistencies I see in the evidence and what lack of evidence I see. And as the judge will instruct you, lack of evidence is a reason to find Mr. Stutler not guilty. So we'll talk to you at the end. Thank you for your attention. Some state calls Philip Hill.
This is gonna be a quick one. Did he say remember what you didn't hear? I think he did. This guy had a large quantity. What's the street value? How much meth did he have? Just I don't want anyone to get in trouble Googling the current price of meth on your work computer. But if somebody could just give me an approximate value, because I do not know. 8675309. That number comes up again.
solemnly swear or affirm that the testimony about yes, is the truth, the whole truth, nothing but the truth, so help you God.
So you have a seat, speak to the microphone. Mr. Sullivan, you may inquire whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Good morning.
Can you please introduce yourself to the jury?
My name is Corporal Philip Hill with the Bay County Sheriff's Office.
How long have you worked with the Bay County Sheriff's Office?
I've been there since September 2017.
Prior to working at the Sheriff's Office, where were you employed?
The Panama City Police Department from 2014 to 2017.
So you've been in law enforcement since 2014.
Yes, sir.
What do you do currently with the Bay County Sheriff's Office?
I'm in the Special Investigations Division.
What does that mean?
We primarily focus on narcotics trafficking and vice crimes, prostitution, things of that nature like that.
How long have you been in that unit with the Sheriff's Office?
Since January of 2020.
I want to take you to October of 2020, specifically October 21st. Did you have occasion to arrest the defendant, Gregory Steller?
Yes, sir, I did.
Where was he arrested at?
The Lowe's parking lot on Back Beach Road in Bay County.
I want to, before we talk about
there no Walmart close
how he got to Lowe's, I want to talk about the investigation kind of leading up to it. Were you involved in placing phone calls between a confidential informant and Mr. Steller?
Yes, sir, I was.
Can you tell the jury kind of a little bit about that process and why you do that?
Right. So, an informant or a source of information will provide a suspect as the person that they're going to purchase illicit substance, typically drugs in my field of work. We'll vet the information of who that person is they're calling first. We try to identify who it's going to be before we even begin communicating with them. Once we do that, we make the phone call. We'll record it. It's planned what's going to be said. In this specific occasion, the informant requested the delivery of an amount of methamphetamine.
Were there several phone calls placed in this particular case?
There was, yes.
And they were between your confidential informant and Mr. Steller?
Yes, sir.
Were you present for those phone calls?
Every one of them, yes.
And they were all recorded?
Correct.
On this time, the statement that seeks to publish what's been admitted into evidence as State's Exhibit 2.
You may publish whenever you're ready.
I only need the sound.
Okay.
Here we go. We get the sound from the recorded phone calls. You guys can be the judge of this evidence.
The following is a controlled phone call to phone number 850-520-2994.
I'm sorry, but they gave the number before.
Present is Investigator Hill, the Bay County Sheriff's Office.
I would not call that number.
The date is
it's being monitored just for your
October 21st, 2020. The time is 9:12 a.m. And we will be making that phone call. Just one moment. Let that call go out.
It's a trap.
No lady.
You're wondering where you are? The confidential informant that's about to make this phone call is actually receiving a phone call from his
significant other, yes.
So you gotta wait till that kind of plays out before you.
Sorry, I'm so tired. Can you put it on call? Or will that be weird?
I need my,
You need glasses?
yeah, yeah.
Where they at?
They didn't even check it.
Oh, here you go.
Yeah.
So we have another phone call coming in when they're trying to record an outbound phone call.
You receive that one?
Oh, it ain't it. That was it. It was it.
Here we go.
That voice there, that's your confidential informant.
Yes, sir.
Hello?
Hey, where's he at, baby? This is Crank. Where's he at?
Hey, Crank, hang on for a minute. He's right here.
Okay, baby, thank you.
Crank.
What's happening?
Hey, what's up, my brother? What are you doing this morning, man?
Oh, just working a little bit here, and then I'm going to take off the Picola.
Okay, come. I need you to take off and come see me, baby.
Say again?
I need you to come see me, man. My bike's tore up, but I need you to come see me this morning.
Right?
I need 2 of them things. You know, big ones like you talked about yesterday morning.
Yeah.
You got cash money, baby.
Let's see. You talking about the whole pounds? What?
Yeah. I need 2 of them this morning.
Really?
Yeah, brother.
What kind of a price? I mean, what's kind of a price?
I told her the same thing. $5.50.
Say again?
The same thing I've been paying you.
Really? Okay. Okay, yeah. 500. That'd be fuck. All right. 2 of them.
I mean, if you knock a little off, that'd be great, man. You know, if you come down, that'll be great for me.
And okay. For one of them would be. I just ordered and fucking and have it delivered there. But you know, it's in Pensacola, so I could only have 2.
Right. I need 2 of them. I need 2. I need 2. They won't.
No shit. 50. You know what? Well, at 100. I mean, you know, I'd go. I think I have to go. I think I can go. Let's see. 60. When we do the math on what I'm paying these things now on the brick, it seemed like I could go. Let me do the math on that, and I'll give you a hard number on it, and just make sure if you're good to go.
Yeah, I got the money, baby. The money's here.
Really, I wish.
Yeah.
I wish like hell. You know. Well, I can do it. I can get it. I can deliver it.
Yeah. That way, I got a bike then I want to show you too, man.
Oh.
Yeah. Yeah. I mean, it's something to sharp here, buddy. Yeah, you like this. You like this. It's a custom built Harley.
Okay.
It's got that 1340 Evo motor on it, like something like mine. It's nice, man. It's lowered. You know, it's real. You know, it's lowered. It's got mags on it, spoke rim, mags. It's got. I mean, you just got to see it, bro. You just got to see it. If you see it, you'll get it, and they don't want to be 35 for it. But man, it's a showpiece, bro.
No shit.
Yeah, bro, for real. Yeah.
Man, oh man, I'll have to look. Well, let me get my ass going here then, because what I got to do is really, I got to go re-up then to get 2.
Yeah.
I got I don't have 2. I was sitting here doing it up to go just do my little drops and that's going. Then but I can order up almost immediately because I can cover it.
Right.
But
right.
So I'll order
the sooner the better, man. Because I don't want to, I don't want the money to go nowhere else. You know.
I hear you.
I mean,
let me shoot you back with it. Let me put it. I'll put you on the fucking priority here. I got to get the fuck out of here. Then I'm in the Funiac. I was gonna hook that trailer up and fuck a load, but I guess I ain't gonna do it. I'll just go ahead and like I said, no way. I got to do that.
Yeah, but we need to do this right here first thing this morning, man.
Right. Okay.
I mean,
it's an hour and a half fucking run in, and then I got to pick up a little cash and fucking shit. I'll order it up. I ain't have to pick up cash.
Yeah.
Order this motherfucker up. All right. Well, let me see. I'll call you. Let me give you back some hard numbers because I can come off that what you was paying a little bit. Considering you're getting basically the 32 brick.
Yeah. Right. Yeah. I mean,
and so I'm sitting here thinking, I'm getting it. See, I'm paying 14.
Right. I know.
But I mean,
But this will be every week thing, bro.
Huh?
This will be every week thing right here. I mean, it's be an every week thing. They will get this every week.
Really?
Yeah. Yeah. Not more.
Okay.
Yeah. It's some people I was telling you about over there, You remember? Yeah, it's him. Yeah, I finally got up with him. Yeah. And they need it now. I mean, as soon as possible.
Okay.
I don't want them. I don't want. Okay, I don't want them to go nowhere else. You know what I'm saying?
Let me get on it because listen. I mean, we'll see. If I'm paying the 14, fuck. I mean, if I can listen, and then to get this thing rolling, I'll tell you, bro. I'll do it. I'll do it for the 15 one. To get it rolling.
Yeah.
The 32 for 15.
Yeah, that'll work.
Okay, and I'll just make my fucking stack off the top, and that's it.
Yeah, that'll work, bro.
Okay. Well, fuck, let me put it together there, bud.
Okay, okay. How long do you think we're looking at total in time wise?
God dang, man, it's hard to say.
Okay, yeah, I know how it is, bro. I know.
It's just going to be a few hours.
Okay, yeah, I know, bro.
It's an hour and a half in, and then I have another hour and a half back over to you. If I went, if it was Wayne, so you know what I mean.
Yeah.
I'm going to say 4 or 5 hours.
Okay, that's great, bro. That's great.
It gives him time to give me, I can meet him there and grab it and turn around and come back. Going to Panama City, right?
Yeah. Panama City, yeah, just right in the edge, right there off, 98 there at Lowe's, right there.
Okay.
Yeah, so come down 79, same thing.
98. That bridge closed over there, it fucking shoots you all the way up. You got to go up through Crestview to get the fucking there,
Yeah, I know it. Yeah. But anyway, listen, bro, this is a good deal right here because these people ever get consistent every week.
Right on.
Every week, bro, every week.
Fucking make sure let me know, make sure they, I got to fucking have one myself.
Hey, listen, bro, yeah, but give them one too, yeah. Yeah, they got to have two. And the way they're doing it, man, they got to have two. Really, you wanted more? And I said, no. I said, just wait, he said, no, let's just do this one time. But you know how people's funny, man,
you do that, and then, the fucking sky's the limit.
That's what I told them. That's what I told them too. Yeah, you know I got it. I mean, I just seen the money, had it in my hand. There's the money saying right here, baby, right here.
I mean, it's a lot of. I'll let it go for that. I'll let it go for that. And see if we can't get a ball rolling on some way. Then fuck it.
Yeah.
Well, fuck it. Let me get it going and get on this mother shit then.
Okay, my brother. Yeah, get it going, man. Let's do it, baby. I mean, I got the cash right now, my brother. I mean, I got the cash right now.
Right on.
I mean, I got it. So.
You got the 15, huh?
Yeah. I mean, I'd have it in. Shoot, just a few minutes, man. The dude just lives up the road from me.
Okay.
Yeah. I know him real well, but this is the same people.
Listen, I'm going to tell you something.
Okay.
If you want, let me do it this way.
Huh?
I think I can do it this way. If you wanted one, say you want the 16, give me the fucking 75. 100.
Yeah, right.
100. Just do a 16.
Yeah, just break it in half.
Get the ball rolling. Do one to get the ball rolling so I get comfortable.
Right. Well, see, you were saying, brother, look, he just got that insurance money. You remember I was telling you about, you got fucked up and got the insurance money.
Yeah.
So he's just got the insurance money. So while he's got that money, man, we need to get what we can get.
Well, that's what I'm saying. I can drop this on the way by.
Yeah, that's what I'm saying.
I mean, I can drop one on the way by. He wants fucking 2 more. I'll bring 2 more back. I'm just saying I can drop you a 16 a pound.
Yeah. Right.
Or do you want, or do you, I can drop you 1 pound. It's a 16, it goes at 70, same price, 7,500,
Right.
Okay. Let's say it's a 15 for the 32, but for the 2 pounds. But I'm saying, so, if you call me and tell me you got cash in fucking hand,
yeah, I got cash,
and I can either drop it on the way by. I was just trying to expedite it for you.
Yeah, I understand, bro. Okay.
One of them I can do in 2 hours, and then the 2 I have to takes me about 5. See, because I got to go down and get more.
Man, they'll hang on for the wait. I mean, they ain't that big a hurry. I mean, I told them I have it to them today for sure.
Well, fucking, that shooting stone, and just call them with them hard numbers and make sure it's all good.
I will.
Because I'm gonna call my guy right now and set it up.
Okay, call save it up, baby.
All right, buddy.
All right, my brother. Bye. Thank you, man. I'll holler at you here in a few minutes.
Okay.
All right, bye, bro.
That ends this call at 9:20.
Your Honor, the
second
prosecution
control
arrest.
phone call to the aforementioned 850 phone number.
Oh, there's another call.
Date is still October 21st, 2020. Time is 9:42 a.m. Go ahead.
And the audio is phenomenal. These guys, this is not recorded on a potato. This is good stuff. Could you not trim down the recording to when it started?
Hey, brother.
Hey, bro, man.
Yeah.
Hey, what'd you find out?
Say again?
What'd you find out, my bro?
Fuck, I'm I'm set. I was just about to call you back.
Okay.
I'm set. I've arranged it. Craig, listen, this business, you gotta be careful. You know what I mean?
Yeah, I know, brother. Yeah, I know.
And,
No
and
shit.
so, I mean, there's a little bit of different protocol on this, there he is ringing back in. There's a little protocol on it, but it isn't too bad. You know what I mean? I'm gonna, come verify the money, then, just keep money in the dope shop. You know what I mean? Here's what I do. I verify the money. I take money in 5 minutes. Then the dope comes in, minutes, less than 5 minutes, the dope comes.
He wants the cash first.
I'm away with the money. You know what I mean? If you have any reason someone don't like it or whatever, you see what I mean? Then I get then I come right back.
Yeah. Yeah, no,
So, in
listen
other
here,
words,
brother.
there's no
There ain't no way we can just meet, and do it all at one time, baby. Huh?
Say again now?
We can't just meet and do it all at one time.
Well, I'd love to, dude, but like the Mexicans, they got a protocol, and they got a fucking, they do it for a reason. They do it for a reason. So, because people get killed for this kind of money. And
Yeah,
stuff,
shit, bro. No shit, bro.
People get killed for it, and so like for instance, I'm gonna, if I have to leave the money for 5 minutes, they look and verify, the dope it comes. Everybody's all good. If for whatever reason, brother, you call me back, I come, that didn't work.
Yeah, I know, brother. I hate that. I don't want to spook these motherfuckers neither, man. Goddamn, everybody gets spooked. Goddamn, we all fuck.
Sure, I don't want to spook them either.
Yeah, because this is a good deal, man. This is a good deal every week, my brother. You ain't even better see nobody but me.
Are they your brothers or?
Yeah. You ain't gonna see nobody but me, man.
All right. Oh, okay.
Yeah, they're gonna see nobody else but me. Ain't gonna be nobody else there but me.
Okay.
That's what I'm telling you.
Shoot me a physical address. I ain't left. I ain't got out of here yet. Okay. Did you want and also, just verify that 15K. So.
And that's what I done seen that. I done had it in my hand. It's there. I've done seen it.
Okay.
But what I'm saying is, if I go over here and just want the money, tell them we got to do all this shit. People's getting ripped off there so goddamn bad, man. It's unreal.
Really?
Yeah, man, it is. It's hard.
See, I just don't want to be a victim like that. It's too hard of a hit for me right now.
Yeah, no, but you ain't gonna be no victim. You know that.
Okay.
You know that. Just like yesterday, I brought that money to you. And if I tell you,
I'm just gonna trust you as a new brother.
Listen, my brother. Listen, brother. If I tell you I got that money, I got that money. The money, I got the money.
Okay.
I just need you to. But what I'm saying is, listen. What I'm saying is, they'll probably be so much close by. You know what I'm saying? He will anyway. But what I'm saying is, brother, listen to me. What I'm saying is, it's a go deal. The money's there. But if I don't want to spook them, if you want to come down and see the money and all this shit, I just want to spook these people, man.
I don't either.
Because this is good for me and you both. We can make a lot of money with these people. A lot of money.
It's no problem. It's no problem.
But what we need to do is we need to meet. Listen, bro, we need to meet together at the same time and just do it and be done with it. You won't see nobody but me.
We'll make that happen then. Give me a physical address where you want me to meet you.
It says, this is what we're gonna do. You come down 98 there. When you come into Panama City, just keep coming down 98. Okay. And then there's a Lowe's there. Right down on not 4 or 5 miles down the road from 79. And when you take a left on 98 there, 79, and you go down to the Lowe's. Lowe's is like 2 or 3 red lights down. There's a Lowe's on the right.
Okay.
And that's where I meet you at right there.
That's what?
Yeah, I meet you at right there. Right there, that Lowe's.
Okay. Well, you see the Lowe's, you said?
Yeah, yes, it's Lowe's. Yeah.
Okay.
Yeah,
it's on 98. The Lowe's on 98 in Panama City.
Yeah.
Okay.
But listen to me, bro. We need to do it all at one time, though, baby. We can. You know what I mean?
I'm gonna do that. I'll do that with you, bro. I'm just testing the water here, bitch. I like to be careful.
I know, bro. I know. Me and you both, brother. But I got you, baby. Believe me.
I don't want to die. I don't want to lose 15.
You ain't gonna lose nothing, my brother. You ain't gonna lose nothing. I'll have it in my hand, and then I'll walk right over there, and it'll be, and just like yesterday, my brother. I guarantee you. I put my face on it.
I gotta make it. Okay, best case scenario is if I'm out of here in 15 minutes,
okay,
I get to Pico in an hour and a half. So 2 hours from now, I'll be meeting up with him, and then I'm another hour and a half back over there because of that. I gotta go.
Yeah, I know.
All the way up to Crestview or whatever.
Right, I know.
So
I know.
Anyway, God dang, the best case scenario here is for about 4 hours, right? I'm gonna take off right now, Craig.
Okay, so you take off right now, brother, and I take everything. And I got all my handwork there. You just get that and give me, baby, and we can go. And this is every week thing.
And normally, Craig, listen, I'd have it. It's just fucking bizarre that I don't have it right now.
I know, man.
It's, hey man, I mean, I have one, I just don't have two, see?
I know.
That's why I gotta go do that. I gotta go re-up first, so that's why it's gonna take time. Otherwise, I'd have it to you within the hour.
I know, brother. I know that's why I called you first thing this morning, you know. I was gonna call you last night, but I said, well, they might be resting or something or other, you know.
I'm gonna take the book off, Craig.
Okay, brother, but it's like you told me yesterday, man. You told me you wanted me to do that, you know, to get rid of some of that like that, so I did. You know?
Yeah, I'm thinking that. Let's roll with it. I like it.
I know it, brother. Yeah, okay. So about 4 hours, you'll be down here with me. You be here to see me about 4 hours, right? About 4 or 5 hours.
Yes.
Okay,
and
brother.
you better call it 5 to those people, you know, because I don't like people waiting. It's
It's good.
I'll keep you posted. I got you. This is your new number.
Yeah, this is a new number. I'm on the new phone, yeah.
Okay.
Okay, brother. Okay. All right, man. Okay, my brother. Listen here. Let's rock and roll. Let's do it, baby. Okay. Later, brother. I'll be waiting to hear back from you, okay?
That concludes this one at 9:40.
Okay, I'm not sure why the court killed the camera here.
Phone calls that were placed as well.
Yes.
And they were placed as Mr. Sutler got to Pensacola and started his way back towards Panama City.
That's right.
And again, when he was closer to Lowe's.
Yes, sir.
Eventually, are you part of the sheriff's office team that sets up in the Lowe's parking lot?
Yes, sir.
Waiting for Mr. Sutler to arrive?
Yes, sir.
Does he arrive to that parking lot?
He does.
And what do you do at that point?
Then Mr. Steller sends a text message. First, he sends a text saying that he's going to be there. I think it was at 6:55. Then he texts 1 minute after his arrival time and says, "We're here." I see the truck registered to him pull in. It pulls in and parks. And there was a takedown team that pulled in and just did a block on the vehicle. They were already stationary, but pulled in and blocked them. And yeah.
And eventually, there was a K9 that was run around the outside of Mr. Sutler's vehicle.
Yes, sir.
It alerted on the vehicle
It did. Yes.
for the odor of some narcotic.
Right.
And the car was searched.
Yes, sir.
If you could look at that book in front of you.
Yes.
There are several photographs which have been admitted into evidence already as states exhibit 1A as an alpha, 1H as an hotel.
Hoping we
Yes,
get
sir.
And those photographs depict what was found during the search of Mr. Sutler's vehicle.
They do.
I was trying the state would seek to publish what's been admitted into evidence in states 1A through H.
Why can't we
Publish
have?
whenever you're ready.
Why can't we have good video at the same time we have good audio? Coach Karen, we covered the proffer. We read that this morning.
One alpha, 1A.
It's
What are we
first
looking
8
at?
pages.
This bag it's a black bag with an orange zipper. This one was sitting in between the two front seats, and it had
I want to see
the largest amount. There were numerous bags with meth in it, but this is the one that had the most in it. It was like over 800 grams.
Looking at states 1B as in Bravo, is this what you find as you start to open that bag up?
Yes, sir.
One, Charlie, is this the bag that was pulled out of that?
That's right. Yes.
Cameraman approach.
Yeah.
It's when I mentioned that it's marked 32 ounces, which is what the informant ordered.
And remind me if I don't, we'll come back to that in just a second.
Okay.
I'm showing you what's been pre-marked for identification in states exhibit 3 and 3A. If you could take a look at those.
Yes.
Do you recognize those?
I do. Yes.
States exhibit 3, is that the
They did
bag
this to
of
this last
suspected
time as well.
methamphetamine that we see in this particular photograph?
Yes. States Exhibit 3.
Yes.
This methamphetamine came out of this package. This is what I.
I'm gonna get there in a second. So, but states exhibit 3, that suspected methamphetamine, that's the same suspected methamphetamine that we see in this photograph.
Yes, it is.
Now 3A, the other exhibit that I handed you, what is that?
This one, sir.
Yes.
This is the bag that I initially packaged it in.
Okay. So when you collected it from the vehicle, you packaged it in that bag 3A.
Yes, sir.
Is that standard protocol?
It is. Yes,
And ultimately, did you send that package 3A to the Florida Department of Law Enforcement
I did.
with what is in States Exhibit 3 inside of it?
That's right. Yes, sir.
And you did that for scientific testing.
Correct.
At some point after it was sent to FDLE, did you receive it back at the sheriff's office?
I did, yes.
And at some point after it was tested by the Florida Department of Law Enforcement, did it get sent to the Drug Enforcement Agency, DEA?
Yes, sir.
And they're a branch of the federal government.
Correct.
And they are the ones who took it out of your packaging of 3A
Right.
and put it in this particular bag.
That's correct.
But when you collected it and sent it off to FDLE, it was in that bag.
Yes, sir. This bag.
All right. Now you said that 32. You mentioned 32. What was the significance of 32?
As you all heard in the phone call, if you could understand, I know it's hard to hear, but so he orders 32, which would have been 2 pounds, approximately a kilogram or 2 kilograms in total. He specifically says 32, and that's what's marked on the bag, 32 ounces.
And when he says, in that phone call, when they say 32 for 15, he's ordering 32 ounces of methamphetamine for $15,000.
That's correct, yes.
And during that conversation, Mr. Stover says, I've got 1 pound or 16, kind of interchanges that a few times.
Yeah, he's saying he has 1, but he needs to get another one since he was ordering 2. Sorry, he was ordering 2 pounds, not kilos. He said he had 1 in his possession, but he needed to get the other one from Pensacola, which was the whole holdup.
And there's that kind of discussion about I can do 1 for 7,500 or 2 for 15.
Yes, sir.
But when they're talking about 1 or 2, they're talking about pounds.
That's correct.
All right. Now moving to the next photograph, I believe this is 1 Delta. What are we looking at here?
I think this is the bag in the back seat.
Okay. Was there more suspected methamphetamine found in this bag as well?
Yes, sir, there was.
All of this in the next photograph. E is an echo. Was that all taken out of that back in the bag in the back seat?
Yes.
I want to focus on this kind of notebook down at the bottom.
Mhm.
Is this that same notebook?
It is, yes.
What are we looking at here?
It's a ledger, an O sheet.
What is an O sheet?
That's what he uses to, typically drug dealers use it to keep track of what someone owes them. Different customers on the left, you can see he crosses out amounts as they pay or take on a new debt.
And this photograph here as well? That's
Yes, sir.
sideways, but
Yeah, same situation. You'll notice if you go back and forth that it's got some of the same names or nicknames on this as well.
here at the bottom where it's on the 28th, is that what we'll get here? Is more
Yes, sir. That's right.
names and O's, yes.
Yes, sir.
And last photograph, 1 H is in hotel. What are we looking at here?
Right. So this is a title with the Mr. Stutler's name on it. This was also inside of the vehicle.
So this is just documentation showing that it was Mr. Stutler's vehicle.
Right. Well, just that it was inside of the vehicle. This one wasn't for the car he arrived in, but yes, sir.
I'm gonna open the question this time.
They might be trying to protect the identity of this witness, who we've already seen. Sounds like he works undercover
Good morning.
narcotics. The crank that we heard
all
on the
failed
phone
phone calls that we heard
was a
they
confidential
never talked
informant.
about what the substance was, correct?
No, they never specifically said meth. No, sir.
So they talked about alleged weights and alleged numbers, but not necessarily what.
Right.
And you said there were several different bags, and all of those were sent off to FDLE.
Oh, yes, sir. That's true.
To your knowledge, were they all tested?
No, sir. The only one that was tested was the Exhibit 7 for 892 grams, which is State's Exhibit 3.
And at the point that you collected it all, it was just suspected methamphetamine.
Right. I mean, I did an initial field test, but we can't 100% conclude until FDLE sends a test back or analysis back.
And you said at some point after FDLE, did it come back to you?
Yes, sir, it did.
And then that's when it went to DEA?
Right.
Who did it go to at DEA?
His last name was Rodriguez. He's a special agent here at the Panama City field office.
Okay, and how long was it there?
I honestly can't remember. I can't remember.
Do you know what happened to it while it was there?
Yes, sir. It was sent to the DEA's lab where they did another test just because, I don't know if I'm allowed to say this, but they were going to do a federal indictment. But it never went anywhere because Mr. Stetler bonded out and disappeared for 3 years.
Okay, so there was never a federal indictment?
I'm not sure if I'm allowed to say
because there was no
this,
defendant
but
to indict.
Here we
And
go.
when was it returned from DEA?
So we got it brought back this week. Yep. I'm sorry, the end of last week, and then it's been held at local DEA.
So it came to local DEA at the end of last week?
Right. It's been locked in their vault.
All right, who did it go to at local DEA?
Kevin Miller.
And then when did it get turned back over to the sheriff's office?
This morning.
All right, and got turned over to you?
Yes, it did.
Dude, does everyone need a drug deal nickname? How do you get your drug deal nickname?
All right, thanks.
I'm asking for a friend. I don't know.
Briefly, Your Honor. It was brought back from DEA for the purpose of this trial.
That's right.
May I push on? This bag that I'm showing you here.
Yes, sir.
This consists of all of the other suspected methamphetamine that was collected from these backpacks.
Yes, sir. So everything that I initially seized and was sent to FDLE and then returned back to the sheriff's office all went in this bag to DA, and it all was returned back to us today. The only reason it was ever even unsealed,
welcome to the gallery,
is for the purpose of this trial.
And so Mr. Turner asked you about all of this was sent to the Florida Department of Law Enforcement for testing.
Correct.
They did not test any of these items, correct?
No, sir.
They only tested that bag.
That's correct.
Are they waving around 2 pounds of meth in court?
Nothing further, Your Honor.
Excuse?
I'd ask that you remain under subpoena, Your Honor.
I sure you're telling the suspended and leave the courtroom.
Sir.
May call your next witness.
Your Honor, this time the state calls Sergeant Jeremy Head, and at this time, Your Honor, the state would also move into evidence State Exhibit 3 and 3A.
Any objection?
Yes, Your Honor. Can we approach?
Yes, we object. We don't want the jury to take 2 pounds of meth back to the jury room. Your Honor, we think that would be highly inappropriate. So Big Dill is my gang name. If I had ever been in a gang, I would have been called Big Dill. But I don't know. Is that the same as your drug dealer name? Lilith Geist, welcome to the gallery. Awesome to have you here. Love your sense of humor. Love your commentary. Welcome. You're one of us now. You can never leave. It's a one-way door. Let's see. Suspended Trooper Procta, furiously scribbling notes on documenting evidence. Oh, that's how it's done. He said evidence bag. Hang on. How do you spell evidence bag? I think they need to let the jury. Most of it has not been tested. They've got 2 pounds. They sent one little bag. I'm not sure how much that was, but one bag was tested positive. This phone call, the whole idea, oh, we never said meth. I'm sorry. That was a drug deal. That was a drug deal. There is no other reasonable explanation for what they're doing. I don't think it's any stretch of the imagination to say that, yeah, we're, wow. Yeah. Bigger deal. Bigger deal. The dill pill. Oh, man. Good stuff. Let's see how long this little sidebar. Hopefully they'll turn the camera back on now that our undercover officer is off the stand, which we got to see for a little while. I'd like to be referred to as Mega Pint. Regina Crawford, thank you very much. Glad KR is over and happy to be watching fun little trials with RA.
Stand by the chair, please, until the clerk's breaking.
Sir.
be the truth, the whole truth, and nothing but the truth to help you God.
Yes, ma'am, I do.
Thank you.
I'm not sure if we can watch this whole thing
To the
without
microphone and
cameras.
something you may inquire whenever you're ready.
Morning, sir.
Good morning.
Please introduce yourself to the jury.
My name's Sergeant Jeremy Head,
And where are you employed?
the Bay County Sheriff's Office.
How long have you been with the Bay County Sheriff's Office?
Approximately 14 years now.
And what do you do with the Bay County Sheriff's Office?
I'm currently a sergeant with the Special Investigations Division.
And that is the narcotics unit?
Yes, sir.
Were you working on October 21st, 2020?
I was an investigator at that time.
And were you involved in the arrest of Gregory Stetler?
Yes, sir.
What was your involvement in that arrest?
Well, now Corporal Hill, Investigator Hill at the time, had called me to assist. He provided us information that Mr. Stetler would be coming to the parking lot of the Lowe's there on Back Beach with a large quantity of methamphetamine. We set up surveillance and awaited him to arrive.
And were you present when Mr. Stetler arrived?
Yes, sir, I was. Corporal Hill called out that he'd arrived, gave us the vehicle description. Through coordinated surveillance, we were obviously watching the vehicle come through the parking lot. When it came to a stop, Corporal Hill asked that we move in and take Mr. Stetler into custody, which I did. I moved up to the driver's side of the vehicle where Mr. Stetler was sitting.
And at any point during this interaction, did
The judge turned the camera off briefly.
Yes,
We
sir.
don't know why.
I got him out, started patting him down, placed him in handcuffs, obviously, and I advised him of his Miranda rights as I was doing that.
And at any point did Mr. Stetler make any comments that you heard?
He did. While I was patting him down, unsolicited, he said something to the effect of, I believe it's all mine. She had nothing to do with it. He had a female passenger and he indicated her.
And then I hit him,
So Mr. Stetler wasn't the only person in the vehicle when he arrived?
No, sir.
There was a female as well?
Yes, sir.
The statement he made to you was that she didn't know anything about it.
Yes.
Was there another law enforcement officer standing near you when this was said?
Yes, sir. Lieutenant Kevin Francis.
Did he hear that comment as well?
He did, and he replied to that, asking if he meant the drugs in the vehicle, to which Mr. Stetler said, yes.
No further questions, John.
So now we have an apparent confession to a police officer. We already have the phone call with the setup,
Has it been found yet?
and then the delivery.
No, sir.
This seems like an open and shut
Did you ever
case.
hear Mr. Stetler request an attorney?
No, sir. I stood with him for pretty much the duration. We didn't really talk after that.
Did you have on any body cam at the time?
No, sir.
Did you have any other recordings?
Not that I made, no.
All right, thanks. No redirect, John.
Can the witness be excused?
Yes, Your Honor. Yes.
So you may go about your day.
Thank you, Your Honor.
You may call your next witness.
State call, Kevin Francis.
The jury is thinking this, not that.
What more do you need to see?
Yeah, they've got everything right now, I think. Just to test that the drugs were actually meth, that their weight was over the amounts indicated in the law. We've got possession. They've got the setup. They've got the intent. They've got everything in this one.
This way, sir, and if you would, stand by the chair, please, till the clerk's raising it.
Swear or affirm the testimony you're about to give the truth, the whole truth, nothing but the truth to help you God.
I do.
Thank you.
All right, sir, you have a seat. And Mr. Sutton, you may inquire whenever you're ready.
Thank you, Your Honor. Morning, sir.
Good morning,
Please introduce yourself to the jury.
Lieutenant Kevin Francis.
And where are you employed?
Oh, did they kill the feed? Did it crash? It looks like it crashed all the way down. Okay, we're gonna see if they're gonna refresh this. I'm gonna keep hunting for it. It's the only feed that's down. It's not the internet. It's just them. Fun fact, closed captioning was turned on for the duration of this video, but it just didn't seem to pick up that call very well. Oh my goodness. Let's see. Live. We're in the 14th Judicial Circuit of Florida. Looks like it did go down. Somebody not pay their bill down there? Who's in charge of paying the internet bill in 14th Circuit? Okay. While we wait, we're going to jump back to Judge Cedric Simpson.
Were you on probation at the time of this offense?
I'll keep an eye out for this and see if it comes back.
You need to understand that plea in this case then could be considered a violation of probation.
Yes.
I like this
It is
courtroom
considered
better.
a violation. That court could sentence you to the maximum allowable term.
I do.
Still, okay.
Yes.
Anybody promised you anything? It's gonna say here today on the record.
No.
Anybody threaten you with harm?
No.
You're doing this voluntarily
Yes.
of your own free will.
Yes.
Because you believe that you're indeed guilty of this offense.
Yes.
He had to think that one over.
March 8, 2024, at the location of US 23 near Barker Road in Northfield Township, Washington County, State of Michigan. Did you have methamphetamine in your possession?
They found methamphetamine in my truck. Yes.
Was it yours?
No.
Was it yours? No.
Did you know it was there?
No.
You can't plead guilty.
Hang on, there's no sufficient factual basis. That's okay. Can't take it straight. We want this done.
We'll set up for exam, Your Honor.
And I'll just make it clear that offer is withdrawn.
Can we adjourn the PCC for 2 weeks to think about it?
Think about what?
The offer's withdrawn.
Think about the facts of the case and what we would like to do,
Your client just
and perhaps leave the offer open.
But as Mr. Alford was doing it, I almost stopped thinking earlier because when I got to the point, because he was guilty of the offense, he paused. I let him get out the answer, but then when I go through the factual basis, I don't know what's gonna change to also create a factual basis.
Your Honor, I'm not sure either, but in the grand scheme of things, 2 weeks is not much. My client having a felony record for a while is a big issue. So if the court would give us 2 weeks and the offer would be left open, that would be ideal. If not, we do understand.
You need 2 weeks to talk it over with my client.
Okay, discovery's complete.
Yes.
Witnesses available on the 16th.
And
Set this
the offer
for
was withdrawn.
preliminary examination in person, July 16th, 2024. 9 a.m. before Judge Bell.
Thank you, Judge.
Phoebe says, excited to receive jury citation today. Though I'm in Scotland, it will probably be an argument over whether the stray sheep belong to Douglas.
Court calls the case before versus Lorenzo Paddock. Andrew Phillips, appearing on behalf of the people.
Assistant Public Defender Chinazi Carey Akinwumi, Your Honor, on behalf of Mr. Lorenzo Patterson, who is approaching.
State your name.
My name is Lorenzo Patterson.
Your-
Dr. Patterson.
Yes. Your Honor, today is the date and time set for a probable cause conference in this matter. There has been an offer extended by the people. Mr. Patterson and I need just a little bit more time to go through the offer. I'm also going to be submitting a referral for mental health court on his behalf as well. But we hope that the offer will stay open.
That's fine.
Okay.
July 25th, 2024.
Thank you, Your Honor.
Thank you.
Trying to call the court right
Set
now to see if we
Lorenzo,
can
I'm
get the
going to
camera
call you,
fixed.
okay?
Okay.
Wow. Court calls case People versus Aaron Point.
On behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Points. Mr. Points, will you please state your name for the record?
Aaron Point.
Thank you, sir.
Your Honor, if we could have an adjournment of this, we have some additional conversations that we need to have with Mr. Points before proceeding.
July 25th, 2024, 9 a.m. Continue.
Thank you.
Thank you, sir.
Thank you.
Courthouse case, People versus Gibbs Spencer. Andrew is appearing on behalf of People.
Judge, which case did you call?
Pardon?
Which case was that? Oh, Spencer.
You left.
Oh, I'm so sorry.
You don't know?
Sorry about that. Sorry. Your Honor, we are asking for a 2-week adjournment. In my discussions with Mr. Joy Gaines, Senior Assistant Public Defender, representing Mr. Spencer. Your Honor, in my discussions with Mr. Spencer today, some additional issues came to light, and I would like an opportunity to investigate those. And especially given the seriousness of the charges. So we are asking for a 2-week adjournment so I could look at that.
Further out, July 25th.
Thank you.
9 a.m. Thank you.
Thank you.
Court recall versus Greg Smith.
We'll use on top of the people.
I have to say that report that I had, just want to make sure, that report that I had did not belong.
All right, we've got a camera feedback. Just 1 second.
So
Let me just say that
There you go.
Thank you.
their court system is terrible.
I got a BB gun.
I think they took a break. Their phone system. Oh my goodness! I wish I could. Okay, I've been calling numbers, and you've called the first number. It's like for the court technology specialist. You call the number. You've reached a number for the court technology specialist. Please hang up and call one of these other numbers, which is probably the correct number. And then it gives a list of numbers. I kid you not. That's what the recording is. And you call the other numbers, they go just to voicemail. And I remember we've had to call this court before because we had a problem with their cameras. And they're the worst. I don't know what it is. They just do not answer their phone, period. Okay, let's zoom in, see what's happening here in court. Defendant's taken out for the break. Allie B from Tennessee says, love this channel, but I don't think anyone likes me much. No one answers my questions, but it's okay. Allie B from Tennessee, wait, where are your questions? So is 1 pound, so 1 pound is a lot of methamphetamine. Sorry, I was focusing on court. Let me turn them down just for a minute. Allie B, for perspective, yes, 1 pound of meth is a lot. In February in Utah, they stopped a car that had 240 pounds of meth in it. That street value was between $5 and $7.25 million. That's a lot more, but 1 pound is a lot. I'm sorry, I didn't see your question there earlier. I was busy calling court, trying to get everything set up. It's a trap. It's a trap. Let's see. It's funny. No, there's no big trials going right now. That's why nobody's playing anything. But everything's going to start at the same time. Ashley Benefield's going to start the day after Alec Baldwin starts. So that's going to be busy. Both of those are big. Ashley Benefield, I believe, is the Black Swan trial, which is going to be fun. Let's see. Maybe you need to help them out with the tech. I think what happens is the judge hit the wrong button, and he's got the mute button, and now he came back. What I'm worried about is that he's inverted his we're live and we're mute, we're turned off button. And so now when we come back and he starts, he's going to go back to the mute. So he probably bumped it accidentally, or a court clerk bumped it accidentally, and they just hit it out of habit to switch. Hopefully they pay attention and see that they are down, because there is no number that reaches Found the right number. Thank you, Greeners. 8675309 gets through every time. Danielle, thank you for admitting to being an addict. You thought you just clicked the subscribe button, but that's actually what it means. Welcome. You're one of us now. You can never leave. Ali B, we love you, by the way. There's just a lot of chats, and I missed them. Let's see. Ivy Berlin, hello, RA and friends. Friends cannot hang out here long as I am going to the opera. Don Giovanni, Mozart. It starts with a murder, though, so it's like true crime opera. That should be a thing. The mini trial helps with the withdrawal of the Karen Reed trial. It does, and I can also, if you need be, I can put the fan up. We can play the fan. Let's see. Let's jump to that. It's relaxing. I even feel cooler when it's going. But let's see. Let's jump back to a 2-box. We could do 3 boxes. Let's do 3. How about this one? And then box source 3 will be the fan. There we go. Now we can wait like this. Does that help? Does that help does it make the shakes go away a little bit? Thank you, Ali B. Appreciate the super chat. You're very generous. BSD, bad squirrel decision. Says, I missed my addict family. Welcome back. Did a great job with the internet. Keep it up. First in chat yesterday, right? I think during our the read through of the Young Thug, 56 pages. That was important duty. What trial are we going to cover next? Alec Baldwin's a big one, and Ashley Benefield, both of them. So we're working to see if we can get one of them on our Top Mark Media channel so we can actually run both trials simultaneously. The most I've ever done is 3 at a time, so 2 should not be a problem. We'll run one through StreamYard and one through my switcher. We're not muted. It's just a lot of court chatter, and it's not related to the trial, so we turned it down. Ooh, a juror from Karen Reed spoke out. I saw an alternate juror that was dismissed. I think it was juror number 3 who spoke out and apparently appeared to be pro Karen Reed. I haven't seen anything beyond that. Was it an actual deliberating juror that spoke out? Pamela Campbell, I love to read documents, so we're a good fit. If you see a big document that you'd like read, let me know. We have a solid year of trials. Misty, I kid you not, it's going to be really good. All the way up through Brian Koberger, which is now the middle of next year, I think. What's the date they ended up with? There's actually a document. Let me turn this off for a second. There's actually a document that the judge released in the Koberger, let's see, Orange County, Lee County. I have to pull it up again. But the judge released the trial setting document, but it says Latah County and it's got times and dates and everything. It's going to change, but we think it's going to be about that same time period. Let's see. Lilith says, I was listening to your reading on the YSL stuff in the morning on my commute. Like, this was horrible. It was bad. Lilith, if you didn't catch the one last night, there was 56 pages of the actual transcript of that ex parte meeting. We read every word of it. And it was bad. It was terrible. Let's see. There are some big trials coming up. I think, let's see, Corey Richens is in August. So that she's in about 2 months. I'm going to be in Park City, Utah for that trial. It's just a 3-day hearing, but we're getting close. I'm not sure if I can return to Park City for the trial itself, but we're going to be there for the hearing. We'll definitely be in the media pool for that one. So it's going to be great. Corey Richens, the next hearing, the 3-day hearing.
You are unmuted.
Oh, sorry. That's the wrong thing. Okay, we can't show that. We can't show that because that was old. We can't show that either because that's not court. All right, here we go. Here we go. Okay, that one's not done anymore. I think we're about to come back from break. I forgot what I was saying. Corey Richards is coming up, and it's exploded. I mean, the last thing that happened, there's the defendant brought in. Oh, he's being pushed in by somebody in stripes. Did you see that? The defendant was wheeled in a wheelchair by an inmate. Anyway, Corey Richards is crazy. That's the wife accused of poisoning the husband with fentanyl overdose in a Moscow Mule drink. And then she went ahead to write a children's book and went on a national book tour. The children's book was all about grieving. Are You Still With Me was the title, I think. Yeah, Corey Richards is something. That whole family looks interesting. It's a trustee doing his work. Paula, it was a pure coincidence they lined up with my son's wedding, but I'll take it. The bailiffs are just like chatting. Okay. Looks like we're about to come back. We're just waiting for the judge now, and we should be good to go. Just a reminder, in this case, the jury is shown on the screen. This is how the court operates. Some courts are like this. Juries are public, unless under special rule the names are not released like the judge did in Karen Reed. Normally the names are released of the jurors who serve. Zins. We haven't plugged the pickles in a long time. Walmart, not a sponsor, by the way. They have spicy maple bourbon pickles, which will change your life. If you're a pickle lover, they're unbelievable. It's like a sandwich pickle, but it brings some heat, and they are so good. Spicy maple bourbon pickle. These are good flavors. Anyway, I highly recommend them. I think they're like $3 or $4 for a jar, and a jar is a single serving. I think they're so delicious. Not in Canada yet. Hope RA fixes that. Let me know what the rules are. I might have to talk with Ian Runkle and see if we can get set up. Let me tell you a little bit. I have some big plans for the Brian Koberger trial. I realize everyone and their dogs will be covering it because the judge is putting it down on YouTube. So everyone's going to be covering it. We want to bring something a little bit different and a little better. I'm looking at deals to get some camera feeds, external camera feeds that I have access to and can control remotely. So I need first of all, I need the venue decision to be made so I can map out locations, so I can contact companies and look at hardware and setup and what it would cost to pull it off. If we can do it, Latah County had a great one. We had in the works with a bond bailsman company. But anyway, we'll see. We're going to see if we can get you a little more something special from court than what everyone else is going to have.
Remain seated, come to order.
Oh, we have to be quiet now.
Record. Think we take up prior to bring the jurors in?
Yes, Your Honor. Sidebar. Previously, Mr. Turner basically represented that he's objecting to me calling my next witness, and her testimony is an expert on the substance of what we're dealing here. She's the FTLE analyst in this case. So I'll let Mr. Turner make his objection, and then we can handle it from there.
All right, Judge, my objection is based on Court Rules Criminal 63.220 B1A17, which states that disclosure of an expert witness would be provided through a written report and a CV or one who's going to testify, and that should be disclosed. I've got the state's initial discovery disclosure And Judge, I've already given Mr. Sullivan all these cases, so I'll give you a copy as well, along with the initial discovery disclosure, which doesn't designate Ms. Spiegel as anything other than a category A witness. There is no indication there that she's going to be an expert. Thus, at this point, Your Honor, I believe that that brings us to a discovery violation, which would trigger a Richardson hearing.
Judge, I don't believe there's a discovery violation, and I'm prepared to argue that first, but I think because he's alleging one, I think we have to have a Richardson hearing. But that's how I think we need to proceed.
All right.
But I'm gonna have one. I don't really need one. The witness has been disclosed. You know what the witness was being disclosed for. It wasn't a fact witness here in Panama, that she wasn't in Panama City, that she was part of any chain of custody, that she wasn't part of any part of the control, or I don't even know, the control by or the phone calls. It's obvious what she was there for, but we'll have a Richardson hearing.
Judge, I'll just jump you down to D Board v. States, which should be at the back of your packet. This is 152 Southern 3rd, 788.
Go ahead.
In that, the first DCA cites the Florida Supreme Court stating the defendant is presumed procedurally prejudiced if there's a reasonable possibility that our trial preparation would have been materially different. In that case, along with Wilson, there were expert witnesses who were not disclosed, that were even deposed by defense during those cases, but found that the lack of disclosure would have materially altered the preparation. Had I known this was going to be an expert witness, we may have sought our own expert witness. I would have deposed her, find out what equipment she used, find out its reliability. And accuracy.
You know good and well that this was an FDLE analyst, that she was there to analyze whatever controlled substance. You wouldn't have got an expert witness. You might not even enter. Was she ever deposed?
No, just to point out, there was not a single witness deposed in this case.
So, I mean, it's not that, I mean, you're not, I mean, you can, I mean, that's an argument that, yeah, we'd have got our own expert to cross-examine her how she tested. If you wouldn't have.
Well, Your Honor, there's not an exception to the state's ongoing discovery obligation based on the experience of the other side.
Mr. Sullivan, I mean, Mr. Turner, anything else?
No.
Judges can allow this.
Your Honor, again, my position is that there hasn't been a discovery violation. Ms. Spiegel was listed as a witness on January, I believe, 15th, 2021, over 3 years ago. Her FDLE report was provided over 3 years ago, and all of these cases that Mr. Turner has provided, all 5 or 6 of them, it specifically deals with expert witnesses who were listed as category A witnesses, like Ms. Spiegel was in this case, but didn't provide a report. There were officers who were called as expert witnesses, and there were no expert reports provided. That's the key to the listing, specifically listing a witness as an expert, is to put the defense on notice that this particular witness has expert testimony when they haven't provided a CV or a report, because otherwise the defense has no way of knowing. In this particular case, Ms. Spiegel provided her expert report over 3 years ago.
Your Honor, and it's not a CV or a report, it's a CV and a report under the rule. There is no CV, so we have no indication of what her education and experience is. Your Honor, even in a DUI trial, I get a copy of a certificate that indicates that that officer went to a training course to learn how to use and operate the machine in that type of case. Here, we have none of that information has been disclosed.
Your Honor, Mr. Turner is familiar with demands for discovery. If this was truly an issue that he was concerned about for the past 3 years, that this witness, I have no idea what her qualifications are, he could have filed a demand for additional discovery. This is pure trial by ambush.
All right, I'm on anything else.
Unfortunately, Your Honor, that doesn't relieve the state of its obligation, the fact that I didn't demand it. It's the state's ongoing obligation to disclose the witness and disclose her as an expert properly, so that we can follow up.
You don't get a gotcha, and you know the law, and it does not give you a gotcha. This state's response to discovery was in response to your office's demand for discovery. I believe your office has been the original attorney from the very beginning, and the discovery response, the demand or notice of intent was filed on December 9th of 20.
January 15th of 21, give or take.
January 15th, 21, the state's response. The witness in question Stephanie Spiegel, Pensacola Regional Operations Center, Pensacola, Florida. And when was her report filed?
In that exact same response, Your Honor.
So I'm on, find there's no discovery violation. I'm finding the defense is not prejudiced. Had the report for over 3 years.
He was trying
and
for
the
a gotcha.
name of the witness for over 3 years. Regardless of how she was categorized, you knew that she was the expert witness who had tested the alleged contraband sent over there.
Is it too late to take the plea deal? He's like, sorry, I
To be honest,
tried.
if I granted the defense motion, this would be a good way for defense attorneys and state attorneys to lose all kind of discovery rights. But that's what would happen next, I believe. But there's been no the defense has not been prejudiced in any way by the failure to do that, and not in any way has the defense been prejudiced. All right, ready to call your next witness?
Yes, Your Honor.
I tried.
I'm going to bring the jury. Yeah.
Jury comes in the back door normally. Let's see if they're coming in. Let's see how many are deliberating.
Good.
They're the ones wearing the badges. 1, 2,
You need some time?
3, 4, 5, 6. That 6th one looks young.
No, that's okay. I just got a message. I need to take up something else. Let's go ahead and extend our break for 10 minutes and I'll be right back. I apologize, ladies and gentlemen. I'm back in the line.
And out go the juries.
Remember, don't discuss the case amongst yourselves or anyone else.
They didn't even get to take a seat. Like, man, the craziest case ever.
Yeah, leave your notepad here, sir. I'm sorry, I didn't tell you again. That's okay.
You're not going to need it on this one either. Defense is screwed, I think. That was their big play.
Everyone can have a seat. You need to have them in the interview room, or you can talk to them right there.
If we turn off the record, I can.
We'll go off the record.
No. Okay, so kid you not, he's now saying, is it too late to take the plea deal? Is it too late to take the plea deal? We did everything we could, and we lost. I thought we had that gotcha moment, and the judge denied us. So we're going to take a few minutes here and wait and see. Yeah, there's got to be a deal still on the table, right? The attorney, he said, I think this is his whole idea. Watch for what you don't hear. Remember what you don't hear. And he was going to say, you can see in his head, he's like, I'm going to get the expert witness excluded. That's the only one who can testify that the drugs were actually meth. And if you can't prove what the drugs are, you don't have one of the elements of the charges. And guess what? That means not guilty. And so he was using this as a gotcha. The problem is the gotcha is basically saying we were not told that the defense or that the state was going to bring in an expert witness. It was a really good plan. Really good plan. We were not told. Unfortunately, they were told. They received a copy of what the testimony would be 3 years ago, and the judge said, even though they didn't say expert witness by this, you knew what it was, and we're not going to give you this freebie. So you had 3 years. You were not prejudiced in any way on this, and maybe it'll come down to a question of appeal. And if the higher court, says, well, it's the spirit of the law or the letter of the law that we're going to honor here, I would err on the side of letter, but anyway, oh man, good stuff. So we'll give them just a couple minutes to get their act together and come back and see what happens, because this court might be over right now. There's nothing else I think that the defense can do. We've got the evidence already that came in of him admitting it was his through another police officer. So it's hearsay evidence, but that's admissible. We've got the recording of him taking the phone calls from Crank, setting up the buy, and even setting up the price and the location. And then he shows up at the location. So all that shows intent and everything else. Now we have the expert witness who's going to come in and say this definitely is meth and the weight is X amount, which is over the threshold, those meet the 3 elements that you're looking for, and they're not going to find anybody else that testifies otherwise. They don't have any expert witnesses. They never deposed anybody in this case. Defendant is screwed, really. Last time we were in this same courtroom, the defendant was pro se defendant on his own, no lawyer, also charged with drug possession, just over the amount that would lead to, I believe it was the distribution charges. He was caught with a bag of cocaine, like in his car and some in his pocket, and he beat the charges. The jury came back not guilty. The judge immediately deleted the live stream. Immediately, it was gone. Like the jury had not been dismissed yet, and he's like, "You're done. We're taking this one down." But that was funny. So we're going to see if that happens again. Apparently, it's not going to be as easy for this defendant, who had a much larger amount of meth instead of cocaine. Let's see, one pro se with a striped jail uniform on. Yes, wearing the jail outfit, gained his freedom. That was a good one for the record books for sure. All right, so let's continue to see. I'll keep checking here what we've got at 14th Judicial Circuit. Looks like they're back.
All right, Judge, I think we're ready.
Let's see, you want to just stay right there and,
Oh, sure. Sorry.
I understand. Mr. Attorney, you may proceed.
All right, Your Honor. At this time, Judge Turner here with Gregory Stutler in 204172. This time he wishes to withdraw his previous inter plea of not guilty and inter plea of no contest to trafficking meth more than 200 grams. Count one for first degree felony, punishable by a max of 30 years, and there's a minimum mandatory of 15. I have discussed that with Mr.
He's waving the white flag. His whole hope. Let the jury know they can just take the badges off and go home. We'll throw away their notepads.
Mr. Stutter, would you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am. All right, Mr. Stutler, state your name, please. Can you hear me, sir?
Yes, sir.
Okay. All right, you just heard the announcement of Mr. Turner, is that correct?
Yes, sir.
And are you under the influence of any drugs or alcohol today which would impair your ability to make this decision to enter an open plea?
No, Your Honor.
Has anybody promised you get less than 30 years in the Florida Department of Corrections? You understand that we're in the middle of a trial, and we have a jury and panel. They've already heard some of the evidence, and we're prepared for the state or the state's prepared to, I assume, to continue their case. And you'd have whatever defense you wanted to present. You understand that? You wish to waive all that?
Yes, sir.
All right. I've been handed a plea waiver consent form. There's the front page. The second page is a signature of the defendant line. Is that yours? Can you see that?
Yes, Your Honor.
Can you see it? I'll get Deputy Dexter. He can take it to you. He doesn't mind. See.
We've got all the time in the world before you get all the time in the world.
Oh, yes, Your Honor. Signature, yes, sir.
Yes, sir. You read? Did you have a chance to read that agreement?
Yes, sir, I did.
Have you had a chance to go over your case with Mr. Turner?
Yes, sir.
Have you had sufficient time to speak to Mr. Turner about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Do you understand that when entering this plea, you're waiving your right to go to trial?
Yes, sir.
Or you're waiving your right to continue this trial?
Yeah, because we're in trial.
You're waiving your right, and Mr. Turner cross-examine the remainder of the state's witnesses.
Yes, sir.
Contest the remainder of his evidence. And you're waiving your right to present any defenses that you might have to the cases.
Yes, Your Honor.
You're waiving your right to testify to remain silent at the trial.
Yes, Your Honor.
If you have any witnesses here, you're waiving your right to call those witnesses and have them testify.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence. Do you understand that?
Yes, sir.
Are you doing this of your own free will?
Yes, sir.
Mr. Stutler, do you feel this plea in your best interest?
Yes, sir.
Do you understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, not a citizen.
Okay. And Mr. Sullivan and Mr. Turner, is the state or defense aware of any DNA evidence that exists which might tend to exonerate Mr. Sutler?
No.
And Mr. Sullivan, you want to go ahead and complete the prima facie case? I mean, I've heard the evidence of the.
The only additional evidence is that the evidence tested that the substance that was taken from the backpack and it weighed more than 800 grams and was in fact.
Very good.
It was in fact.
All right. And let's see, we'll need also a cost sheet for the cost of the trafficking. I believe that would be $100,000.
I believe it's $250,000.
$250,000. And Mr. Sutton, you understand that the least the court can give you is a 15-year minimum mandatory, is that correct?
Yes, Your Honor.
You understand that?
Yes, sir.
Minimum 15 years for 2 bricks. 2 bricks in a Lowe's parking lot. This guy's gonna do 15 years. Should have thought of that before he took the call from Crank and set up a deal that was too good to be true. Value was $250,000. It was a Crank call. So what we have here is a defendant who went all the way to trial, jury trial, trying to fight some drug.
Mr. Turner,
charges.
You or Mr. Sutler wish to be heard prior to sentence?
Mr. Sutler wishes to be heard, Your Honor.
Mr. Sutler? Just take your time.
Your Honor, I am sorry for what I did. I should know that when this happened, I put it in one voice. I also want you to know I made myself available as much as I could to the full extent to the state and to try to do what I could to assist in removing some workforce from the street in whatever capacity that I could be used with law enforcement. I talked with them and I offered my assistance any which way in full cooperation. Wasn't taken, but I want you to know I'm sorry for what I did.
Okay. Mr. Turner, anything?
Judge has stated the offer's been 15 the whole way along, and I think with his attempted assistance, I think 15 is certainly fair based on his age. It's probably a life sentence anyway.
Mr. Sullivan?
Your Honor, I can confirm that Mr. Sutler at one point did offer to work with law enforcement. However, he then disappeared for 3 years, including failed to appear for I think the first time we had this separate trial. A couple of things I want to point out that were on that jail call, or not the jail call, but the recorded phone calls that I thought were significant. Not only did Mr. Sutler have to go to Pensacola to get the drugs to bring back to this community, but he specifically talks about, he made a comment about the Mexicans have procedures because people get killed for this kind of money. Nationwide, it's a problem with drugs coming across the border. We've got a huge problem with drugs coming to this particular area, especially methamphetamines ravaging the community. And Mr. Sutler had a very large quantity. Just that one exhibit that was tested by FDA, there were 6 that were sent, and one alone was over 4 times the amount of the highest trafficking threshold. Mr. Sutler has prior felony convictions, including, I believe, one for the sale of narcotics previously. So I'm asking for a sentence of 25 years.
Asking for 25, minimum 15.
All right, well, I'm going to find that
30.
Mr. Sutler's plea was freely and voluntarily made after consultation. First of all, I'm going to find there's a prima facie case. I'm going to find that Mr. Sutler's plea was freely and voluntarily made after consultation with his attorney. I'm going to accept it. How many days does he have time?
412, Your Honor.
412, he served a little over a year and a couple months already. So that'll be credit for time served.
At this time, he was adjudicated guilty of trafficking methamphetamine, 200 grams or more. He'll be sentenced to 20 years in the Florida Department of Corrections. He'll be given credit for 412 days time served. He's assessed fines and costs of $1,303. Those include discretionary cost of $2 of local law enforcement education, a $65 assessment of additional court cost, a $50 drug abuse trust fund payment, and a $700 discretionary fine. Those fines and costs are reduced to a civil judgment. Based on the trafficking amount that he's pled to, there's a $250,000 fine that's imposed at this time. That's also reduced to a civil judgment. There's no There's no restitution applicable in the case. Any items that were seized or forfeited, he's to have, if there was any co-defendants, he's to have no contact with them. If he's required to give a DNA sample, he must submit a DNA sample. Have I left off anything?
Thank you, Your Honor.
Mr. Stutler, you have 30 days to file a notice of appeal. If you wish to appeal the judgment sentence, you'd like to have an attorney to represent you, you can't afford one. One may be appointed to represent you at no charge. Good luck to you, sir. You step over your fingerprint. Yeah, oh, I'm sorry. Thank you, Madam Clerk. There's a 15-year minimum mandatory as part of that 20-year sentence, and that's by statute.
So the minimum he serves is 15.
Can we get a recommendation for Okaloosa CI or?
I'll recommend the Florida Department of Corrections and Mr. Stutler be housed at the Okaloosa Correctional. That's the only recommendation, but I'll recommend that.
So he's getting housed somewhere because of his CI status.
Let's go ahead and fingerprint him and then let's bring the jurors back in here and I'll speak to him, okay?
Let's hear what he says to the jury.
Yeah, no, go ahead and take him out. Go ahead and fingerprint him and then take him out. Can you do that?
Yeah.
Have a seat, sir. Drug laws in Florida are harsh, yet that's still one of the gateways where so many drugs enter this country. So much.
I'm gonna have Mr. Stutler fingerprinted, then he'll be taken back to that, and I'm gonna have the jurors come back in. And I'll just dismiss him at that time.
Judy, yes, mid-trial
Counsel,
after a
thank you for a
break.
well-tried case for that part. What was tried? If you release, you can release the evidence back to the state. There's
the evidence. Get rid of the meth. Take the meth out of here.
I'm glad of all assistant state attorneys.
Kind of. So I think Morgan and Nani are the only two that are actually
lawyers.
And
If you didn't know.
I apologize, Mr. Sugu, right? I don't, what was your first name? John. Okay, he's also an ASA.
Okay. I'm glad y'all are here. This is where, if you don't have, I know you got other things to do, but if you got time, you need to sit in these courtrooms and watch lawyers try and watch other lawyers try cases. If this is what you want to do with your career, is try cases. Other than trying your own cases, this is the best way to learn how to try cases. Come watch people try them. Come in and out of this courtroom as many times as you want to. If you got somewhere else to be, go. If you want to come back, you're more than welcome.
May I approach with one of them?
Sure.
So,
This one's my girlfriend. No, I'm not sure.
You're kidding. Well, no, you were a baby in Bluntstown. I remember right after you were born. My goodness, what are you doing now? Is that right? Where? Wow, I'm glad Frank. I saw your dad and Sam the other day. Oh yeah, he was. Yeah, he was. He's living the dream.
Okay, so
yeah, no. Every time I've seen,
I want to see what he says to the jury, and then we're going to bail on this.
He is just having the time of his life. That's great. Oh, anytime. Well, I appreciate it. I appreciate you letting me know who you are, because I think I've known your dad I've known your dad ever since he got on the bench and tried cases in front of him. I was his public defender and state attorney several times over the years. Back in his big last day, that's right. Hair parted down the middle, that's right. Nice to meet you too.
Yeah.
There you go. A little fun chat time with the judge. It's not what you know, it's who you know, apparently, that makes the connections. This is in Panama City, Florida or something. Is that right? Or does that not sound right? In the Panhandle.
It's good to have something to throw anyway.
Had to take a shot.
Yeah, it's good. It's good to have something.
I told him,
Bay County,
Josh
Florida.
actually texted me, and you made a good point. The fact that he came here prepared to argue that with case law proves that he knew that I was calling her as an expert witness.
I don't think that was into his discovery obligation, though.
Yes.
They're joking about
Actually, what I'm scared of, if there was a ruling like that, the way things are in Tallahassee, the next thing you do is that the ones who draft the rule, and who make the legislation.
There's already a rule.
I know, but what I'm saying is what they can do is, I tell you what, we just don't have any discovery anymore.
I mean, more like federal system. The rule actually doesn't say that. Like it puts.
They're arguing this still. The defense lawyer is standing by. The judge has an argument I don't agree with.
That's what I got to think about downstairs. I think they're always looking for something to and that might be the way to discuss. And you wouldn't have any problems.
Starting with the child abuse.
Yeah, exactly.
The judge is like, are we missing somebody? There was a guy by the big attorney. He was here earlier in the wheelchair. Should he be here?
They're getting late, so if you want to hang out.
Everyone have a seat. Ladies and gentlemen, you can have a seat just for a moment. Your jury service is open. Mr. Stutler made the decision to enter an open plea to the court to the charge he was charged with. He was sentenced to 20 years in prison. But you served, of course, just coming down here, you served a valuable service to your community. This case has been ongoing since 2020, October of 2020, almost 4 years. And it took 7 people, we had 7 people started with, to come down here and sit as jurors to get this case resolved. And a lot of these cases are only resolved when people make themselves available for jury service. And we have several more cases. Mr. Sullivan and Mr. Turner have several more cases that they need to start working on after today and get ready. But without good citizens such as yourselves, making yourselves available for jury service, our system of justice would come to a grinding halt. And people throw rocks at it all the time. There's no better system in the world. In a lot of places, you have 3 people just like I am sitting in judgment of citizens. In this country, you have people who are citizens themselves who sit in judgment. With that being said, that concludes your jury service. Leave your notes here. We'll destroy them. Make sure you have all your belongings. Have a good 4th of July week.
Take yours and pass it down. Yours and pass it down.
All right, that ends the case out of. I still can't remember. This is where Brandy lives, basically, Panama City, Florida, Panhandle area. Anyway, so let me explain what happened. We watched the jury selection for this trial, and it was really quick. Really, there wasn't a lot to it, but we watched the jury selection, and it's funny because this court does show everything. You see the jurors, you hear their names. It's sort of like a shock to the system. We're so used to them not being shown, which is more tradition than rule. But anyway, Pensacola, not Panama City. Thank you for the correction on that one. It's in Florida, up by Brandy Churchwell. That's where, I think she could hear the court from her apartment, her condo. Anyway, this was a drug case. This was a trafficking drug case where the defendant was accused of trafficking a large amount, 2 bricks worth of meth, which means a brick is a pound each, 32 ounces. He was going to sell it for $15,000. They had a confidential informant on the inside that they recorded the phone call. It was arranged phone calls. The cops were sitting with Crank, who was the informant, and they recorded the phone call and they talked it over, where they were going to do the deal, how much it was going to cost, where are they going to make the exchange, if they're going to bring the money first or everything at the same time, and it's going to be a weekly thing. The guy bought it hook, line, and sinker, went out, got the drugs, showed up at Lowe's parking lot, and the cops immediately blocked him in, brought the drug dog, searched, and found all the drugs. Okay. You'd think this would be an open and shut case, but he decides to take it to court and fight it in front of a jury of 6 people. He's facing up to 30 years in prison, $250,000 fine. So he fights it, and the defense lawyer, the only defense they have offered is the defense lawyer says, hey, they've got to prove the 3 elements of the crime. One of those elements is that the drugs are what they say they are, and the amount is what it says it is. They're going to prove that with this expert witness from the state lab. But guess what? When they filed the witness list, they forgot to mention that she was an expert. So it's a discovery violation. They didn't tell us in time that she's an expert. Had they told us she was an expert, we'd have got our own witness expert to counter this. We would have, we've had a defense for that. The judge says you don't get a gotcha because it's missing that word, because you had this information for 3 years. Okay, the 3 years that the defendant skipped court, the initial court date, and then went on the run. So he says, I'm not going to give you the gotcha. This is all on you. And as soon as the judge makes the ruling that this witness is coming in, the next witness we're calling is this expert, and she's going to testify and get that third peg in the required elements of the charge, they say, okay, we need a break. I need to talk to my client for a little bit. And he says, yeah, I'm going to change my plea from not guilty to no contest. No contest plea means I'm not pleading guilty, but I am acknowledging that the state has enough evidence that they could convict me on this. And so he makes that plea. It's a little bit better than being convicted, because then you can get the max sentence thrown at you pretty easily. But when you plead no contest, it's sort of shown as a good faith effort. And at that point, even after having started halfway through trial, the defendant wanted to speak to the judge and was very tearful, very apologetic about everything. I'm so sorry, about these decisions and the problems it's caused. And I've, just on the record that I told the police I would help them. I'd be a CI. I'd tell them whatever they wanted. I'd give up my guy. Okay. I don't know how much of that he said he was just willing to do and how much of that he did. But the judge did make a recommendation on the sentencing that he be housed in an area, in a facility that sort of caters to confidential informants, where you're with other confidential informants instead of with the people who are going to do you harm because you're a confidential informant. Yeah, the fact that he skipped court, was gone for 3 years, didn't look good. He ended up getting 20 instead of 30 and hit with massive, massive fines. And that's where it ends. We have one more similar trial that's tomorrow in this same courtroom. So now we've had the two last court cases we've seen with Judge Brantley Clark. We're both all three of them are going to be drug possession cases. The first one was drug possession, where the guy went pro se, had pocket full of drugs, baggie full of drugs in his car that matched, and was caught red-handed, literally, and won in court. He won. The jury came back not guilty. The second one, and he did that wearing jail stripes. It was hilarious. The second one, we have this case where it started halfway through court. The guy changes his mind because their one hope that he wouldn't be convicted was pulled out from under him. So he changes his plea to a no contest, takes the penalty from the court, gets 20 years. We have one more that's going to be tomorrow. I don't know what's going to happen with that one. It's lunchtime right now, but I'm going to just take a quick peek and see what other courts are doing to see if anybody is still up and about, sharing the goodness of true crime from wherever they're located. Give me just a second. Looks like Judge Cedric Simpson. Oh, that's Judge Fleischer. Not going to go to him. Let's see who else we have. Judge Boyd may be up. I think she is. Let's jump over there. Before we jump to Judge Boyd, let me just say, tonight we intend on having a fairly late stream where we go to the Canton Select Board meeting. I think it's scheduled for tonight. There's a possibility they canceled it this week, but I can't tell from the schedule. If it is live, we'll go live. So it's gonna be something to watch. But let's check out what Judge Boyd is doing here.
In the audience, you understand? All right. No talking, okay? All right. Thank you.
Apparently, we're not supposed to talk in the audience. Judge Boyd is in Bexar County, Texas. She has a great style. She has basically a different purse every single day out there by the flowers. The flowers are sent in by people that like her.
Natasha Morgan.
We have sent her flowers personally. And we got to see them actually delivered, which was really cool.
Peter Calderon. I'm standing in for Mr. Saldana. CALDAROLS.
All right. And this is for sentencing?
Yes, Your Honor. That's
Okay.
correct.
All right. Court is calling 2024 CR 1225, State of Texas versus Natasha Morgan. Can I have parties announced for the record for the state,
Andrew Harris Sadelman.
for the defense?
Peter Calderon standing in for Mr. Humberto Saldana for
Yeah.
Miss Morgan.
And are you Miss Morgan?
Yes, ma'am.
All right.
Yes, ma'am, Your Honor.
All right.
I got a little sore throat because the air conditioner over there in my dorm in 2 Bravo. It's freezing cold, and I'm sorry if my voice is low. I wasn't talking to nobody, Your Honor. I respect the judge. My mother was Air Force pilot, 97-286, even though I broke the law before her. I apologize.
Attorney's
Oh,
like,
your
"You can
apology is,
stop talking now."
your apology is accepted.
It's horrible conditions.
Yeah. All right, so here is my question. Defense, have you had a chance to confer with her? She said that she was hearing voices or.
I take medication. I take Giodon.
All right, and do you
Yes.
believe she's currently competent?
I do so believe, Judge. I did speak with Mr. Saldana, and he expressed that his intention to go forward with this plea and Ms. Morgan's intention to go forward.
All right, Ms. Morgan, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Natasha Elizabeth Malloy Morgan, Your Honor.
All right, so this attorney is standing in for Mr. Cabanas. Do you have any objection to this attorney standing in?
No, ma'am, Your Honor.
All right, have both parties had a chance to review the PSI report state?
No, Your Honor.
Yes, Your Honor.
All right, thank you. And we'll continue after the state has reviewed.
Yeah, they might cancel the meetings. I've seen on another website that they're canceling the meetings for the week of July 4th in Canton. So there might not be a meeting tonight. If there is one, we're gonna try to carry that live because they have been fire. They've just been hilarious. They usually end with the police ordering everybody out of the room, and then business going on as the board wishes.
All right.
Yeah, we'll stream if it happens. Normally it happens, I think around 6:30. Let's see. Let me go back to. I just can't tell right now. Their schedule's a little confusing. We've got the HD channel, the Canton government channel, the student station, and Canton's Massachusetts public community station. So I'm not sure which one.
Mr. Edelman, do you need time to review? Do you need more time?
No, Your Honor.
All right. Any objections to the PSI report?
No objections.
State any objections?
No, Your Honor.
All right. Anything you wish to say on behalf of your client?
None at this time, Judge.
All right. Ms. Morgan, if you were released, where would you be living?
I was gonna go to the Haney, while you was gone on vacation. I seen Judge Hahn, I believe her name is, on maybe 17th, Your Honor. And she had asked me the same question that you asked.
All right. That would probably be Judge Her.
I'm sorry, I knew it was
No problem.
age.
All right. So with regards to your mental health issues, do you have a doctor that you see when you're not in custody?
No, I'm gonna roll in the Medicaid Superior and Amcon Insurance. They have Central Meds up there, but they have Center for Health down the street that they have a psychiatrist there who will be available to give me my psychiatric medication. Release if you decide that it's in your favor, in your judgment, to release me on the 10 years of probation, plea bargain, bargain. Yes, ma'am.
All right. And state you may be excused.
Thank you, Your Honor.
All right. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's a $500 fine that will be probated. She's going to be on the MIC caseload
Yes, Your Honor.
And that's based upon the evaluation that the court has seen. I'm going to ask for a trauma assessment. And I'm asking for that based upon what's in the PSI report. There's to be restitution, if any, to Jerry, Jeri Brown. I'm going to do a referral to Esperanza Court based upon what I've reviewed in the PSI report. If she's not accepted into Esperanza Court, then we will, that'll be the first one. If she's not accepted there, then we'll try felony drug court. The reason why I'm suggesting these, now, here's the thing. You have issues going on with you. I'm reading the PSI report. I've read the PSI report. I've seen your diagnosis. Going to Haven Hope is not the best place for you. You need a place where one, and these programs that I'm recommending to you, they're all outpatient programs, but you are going to be in custody for the weekend. Felony drug court and Esperanza Court, they will send someone over to interview you Monday or Tuesday. And if you're accepted in those programs, you'll probably be released on Wednesday and you'll be released to be in their program. What I can tell you is Esperanza Court and Felony Drug Court, they'll be able to help you with housing. They'll be able to help you with any mental health issues, and that's what you need. You understand? All right. And they will do it by next week. It will be done. It's not going to be done. Well, there's still a strong possibility they may be able to see you this week, but because of the holiday, it may not be 100% this week, but definitely by the following week. And counsel, if it's not done by Tuesday of next week, just come back in and we'll have it brought over and I'll do something else.
Yes, Your Honor.
But you need to be open and honest with them. You understand? All right. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be proof of employment or SSI within 45 days of release. There's to be no employment as a home health care provider or with minors. Field visits, one time per month until proof of stable medication compliance. And a referral to Center for Healthcare Services. There's to be 200 hours of community service restitution. I'm going to order anger management. Once that's completed, the community service
Parenting
hours will be
classes.
deemed satisfied. Probation, is there anything else she needs?
No, Your Honor.
All right. Is there anything else you need from the court to be successful?
I want to ask you, am I allowed to speak?
Sure, yes.
I don't understand. I've been in psychiatric care since the age of 9 years old, state of Oklahoma and in Texas. And I just don't see how psychiatric, I mean, like everybody wants me to take medication, it seems like, for issues. But, you know, I did 20 years in prison, 12 years administration segregation. I hadn't been in trouble in 4 years. And 2 of them imprisonments was on false allegations. And then on this one, I mean,
well, here's the thing. Let me explain something to you. So with regards to medication, if the doctor says you don't need medication, if the doctor says, she just needs therapy, then that's what we'll do. But what I'm reading in the TAP evaluation, it states that you're on medication at the jail.
Yes, yes, ma'am. I do take the medication jail issues, but I do know within my rights as a state, I've been to South Showtown, Laurel Ridge, I've been to mental hospitals. Like I said, state of Oklahoma, my mother was military, I was myself in Post Oklahoma. That's court order. I mean, like medication, I don't use drugs or alcohol or anything
Well,
like
this is
that.
what I can tell you. Legally, with medication, if you choose not to take the medication, what's going to end up happening is you may or may not decompensate. If you decompensate and become incompetent, They are probably going to take you into custody because this is considered a violent offense. And then they will seek to help you regain competency. And if they determine that medication is what will make you become competent and you choose not to take it, it will go before a judge. And then when it goes before that judge, they'll have a hearing on whether or not medication is to be forced. And here's the thing, you're having an attorney to represent you at that hearing. I'm just giving you these rules, and I give people conditions. You have a choice. You can follow them or not follow them. That is completely up to you. And of course, there are consequences when we make certain choices. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, sir.
Did you review that with your attorney?
Yes, ma'am. I just must have signed this on May 17th.
All right. And did you understand it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, Your Honor.
All right. Good luck to you. If you need anything, just let the court know. All right. Could I see, sir? Thank you.
Might be excused.
Yes.
Have a safe flight, Your Honor.
All right. Thank you. Sergio Barrera.
Sergio.
Hello. Good morning.
How are you?
All
Other side,
right.
ma'am. Other side. Switch.
All right.
She's gonna make you
Mr.
switch.
Sergio
Oh, she's a
Barrera.
translator. She's
We're
right.
going to go on the record. Court is calling night bag number, excuse me, counsel. She needs to take a seat.
Yes, sir.
And no talking behind the court reporter. All right, court is calling night bag number 748802, State of Texas versus Sergio Barrera. Are you Sergio Barrera?
Yes.
All right, we have an interpreter here. Could you raise your right hand? Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Carmen Tarragona Nazais.
All right, and Mr. Barrera, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give would be the truth and nothing but the truth, so help you God?
We're in Bayer County, Texas,
All right, state your name for the record.
San Antonio area.
Sergio Barrera.
Sergio Barrera Cantú.
All right, Mr. Barrera, the court has received a violation report. This is the first violation report the court has received from you. This is what the court is going to order. You are to continue with no alcohol use. The ignition interlock will remain. And I'm adding DUI, DWI education course. I'm going to ask that the fees be waived.
Do they teach the course?
And
with the
I'm going to
translator?
order 120 sober meetings in 120 days.
What's the
All
cleanup
right, do
after
you need
Canada? Day,
anything
like?
else to remain
Was it a
clean
big
and
party,
sober?
Jen?
No.
All right, thank you. Make sure you report to your pretrial services officer, Miss Money Lawrence. Do you understand?
Okay.
All right, thank you. Thank you. It's always great seeing you. You're looking beautiful. All right. Have a good one.
Yesterday, we did have a pro se
Bye-bye.
defendant here with Judge Boyd. I think that guy is moving forward in the trial.
All
hearing.
right,
We've got it scheduled. I can look at the schedule.
Is
see
the
what it's at.
attorney who was
I
here
think we've got
going to stand in for Cabanas on Christopher Esquivel?
July 29th is his next date with Judge Boyd.
All right, Catherine Aguilar.
Aguilar, not Aguilera. There's a defense attorney.
All right. Were you able to get in touch with your client?
No, man.
All right. Court is
Bench
calling
warrant.
2024 CR 1212, State of Texas versus Catherine Sanchez Aguilar.
Yeah.
They're saying that she's an ISF, the
Oh.
East Wing.
Yes. Oh.
Well, I called them last week. They
She's in
said they
custody.
didn't have any papers on her for that, and I think you did the same yesterday. Or the probation officer, the court probation officer did that yesterday.
All right, so this is what we're gonna do. I'm being told that Miss Aguilar is in ISF. Miss Ferguson and State, I'm gonna want a bench warrant for
She
her
said
to
bench.
come back to court.
It was bench.
And
You
so,
misheard.
Norma, let's recall this for August 1st. So your client will be brought over by bench warrant.
Okay.
And if it turns out she's not where everyone is saying she is, it'd be good for them to know.
Yes.
That N is very subtle, but it was there, I'm telling you. Unless Texas just does things a little bit differently. Flights are crazy with cancels. Is it?
Thanks, good.
All right, thank you.
Is it
Yes.
because of the hurricane? What's causing
Frank
the
Ruiz?
cancellations?
Who's the attorney for Frank Ruiz? Good morning.
Come on, boss.
Are you all ready to proceed?
Yes, Your Honor, go ahead.
He's in custody, I think.
All right, court is calling 2020 CR 4844, State of Texas versus Frank Ruiz. Can I have parties announced for the record for the state?
Jason Garrett, Haney, Your Honor.
For the defense?
Alfonso Otero on behalf of Mr. Ruiz. Good morning, Judge.
Good morning. And are you Mr. Ruiz?
Yes, ma'am.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Frank Aaron Ruiz III who was placed on deferred adjudication in 2020 CR 4844 for the offense of possession of a controlled substance penalty group 1 less than 1 gram on October 6, 2020 for a period of 2 years? Is that you?
Yes.
State?
Yes, Your Honor, violating condition number 5, in Burlett County, Texas, the defendant Frank Aaron Ruiz III did in there failed to report to the supervision officer as directed for the months of April and May 2021 in violation of condition number 5.
How do you plead to that? True or not true?
True.
True? All right, state?
Yes, Your Honor, we'll waive the remaining violated condition.
Any objection?
No, Judge.
Did you understand by pleading true to a violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
6 hours,
Yes.
Vicky.
Court will find violation of condition number 5. True. Is there a proposed agreement?
There is, Your Honor.
Yes.
Is adjudicate guilt on revoke the individual's probation sentence to 10 months in state jail facility.
Is that the agreement?
Yes, Judge.
Mr. Ruiz, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes, I guess so.
All right. No, not I guess so. Either you are or you're not. Do you want the court to follow this agreement?
Yes.
All right, the court will find you guilty. The court is going to revoke. As previously stated, the court is finding violation of condition number 5 true. Court will sentence you to 10 months in the state jail facility.
Laura, there may be a Canton Select Board meeting tonight. If there is, we're going to
I
carry
give
it
you
live.
credit for any time served.
But they might have the week off
Did
because
you
of the
review
4th
the
of July.
document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
Oh, yeah, we can go off the record. You're going to find out in your life that the choices we make, sometimes they come back to haunt us. You had a chance on deferred adjudication, which would have meant no conviction. Now you have a felony conviction. You understand?
Yes.
Do better. Good luck to you.
Thank you.
You want there?
I have seen.
Who's here on John Paul Pena?
JP.
Good morning. Where's he?
Is he wearing
Come
Levi's?
forward.
So you got Levi's white shirt and a sport coat on. Is that the look he's rocking right now?
Kyle Simpson.
Well, his client's in Levi's too, so maybe it's a match.
All right, what
set.
is happening with this case?
Judge, we have an offer, he conferred, he's doing a couple things that I've asked him to do. We'd like to be able to move to the next setting.
All right, how old are you?
I'm 36 years old now.
All right, Ms. Ferguson, call this to at the end of July for a plea deadline date.
July 29th.
All right, your plea deadline date is July 29th.
That's going to be a fun
All
day.
right,
That's
once
going
you
to be the
sign the
pro se
reset
day.
form, your excuse. And Deputy Laura, is everything else taken care of? All right, thank you.
Under Armour. Yes, that's. He was wearing the T-shirt.
Who's here for Axel Ramirez?
The judge has a matching wrist with the purse, the bracelet. Where's your attorney?
Morning, Judge.
Good morning.
Um,
All right, so when will Mr. Maurer be here? No, I mean, it's going to be referred to Judge Mesa.
It's never good when your attorney doesn't show to court.
Yes. Just have a seat. All right, so what we're going to do is, Norma, find out if Robert Maurer can be here today. If he can, then it's going to be referred to Judge Mesa. Just have a seat.
okay.
And it'll be in the afternoon.
Yeah, you're going to be spending the day at the courthouse, sir, unfortunately, because of your lawyer. A B warrant for the attorney, please. Is there pro se in with Wolf right now? Let me take a quick peek. I've never seen him have a pro se before. That would be absolutely epic.
All right, could I see the file on Christopher Escobar, please?
Deanne B, are you seeing, is it the current case where he's live? Because he's in Chancery, Chancery right now.
All right, Christopher Escobar, come forward.
Braxton, I never saw the treehouse hearing. I don't know if that got streamed or not. I didn't hear what the end result
All
was.
right. All right, Mr. Escobar, thank you for dressing appropriately for court.
Thank you. Mr. Escobar, looking sharp.
Family violence is in impact court and jury trial. So we're going to recall you. What's your work schedule?
So I'm self-employed. I'm starting a big project this week. I can work around whatever.
All right, so we're going to recall you on July 8th to get a jury trial date for you, okay? So Ms. Ferguson, if you give him a reset for the 8th, please.
So we might be a week out for the
All right,
next
once you
Canton
sign the
Select Board
reset form,
meeting.
you're excused. Thank you.
Treehouse lawyer,
Audrey
Mr. Tucker
Bash.
is still going pro
Can I
se.
see the file on that, please? All right.
Sure, everything will blow over in Canton by July
All
9th,
right,
I'm
Norma,
sure.
on Audrey Bash, we're going to recall this for the 8th. And if you'll let Mr. Stateson know. And how is he doing?
Mr. Stateson?
Okay. All right, could I see the file on Brian Parker?
Just turning paperwork right now for all 4 cases.
Okay.
Vicky, Wolf is live right now. This is Wolf.
Based on your drive to and from Murfreesboro, how long?
All right, and what is happening with Renee Hernandez?
I'm waiting for him, Judge.
Okay.
They brought him up.
All right. Could I see the file on Sheila Garn, please? Oh, no problem.
Are you saying there was a pro se in this one? With Wolf? If there was, I'd like to find it. Is there a timestamp roughly? Like how many minutes ago in his live stream?
All right, Norma, on Sheila Garn, if you can recall her back for July 9th.
Sheila.
All right, what is happening with Roberto Cibrian? All right.
The one that has.
Okay. Esther San Miguel. Esther San Miguel. Could I see the file of Esther San Miguel?
Judge, I think that one was already read that, Judge.
Okay.
Just a second. She was-
Oh, it'll be in the file. Let me see. You don't see the file. Okay.
File is missing. Shady Lady, YSL is on hold until further notice. Because of the motion to recuse has been submitted to a second judge to review. Until that judge makes a ruling, nothing can move forward in YSL. It's a full stop. The jury is just held in limbo. Yeah, Vicky, just let me know what Wolf's doing as far as if it's a divorce proceeding. I'm not sure if I'm up for a divorce proceeding today. Thank you, Jim, for the extra votes. YSL should be dismissed. I think it should end in mistrial. I really think they should break it down. I know it's a pain in the butt, but they need to break it down to make it a little more manageable. These 6 at a time things is not going to fly. There's just too many attorneys involved and too many little differences in details. I have to admit, I stole this little comment from Popcorn Tycoon on Alexa. If you don't know what Alexa is, if you don't know what Alexa is, then you have a problem. If you don't know what Popcorn Tycoon is, it's an audio game that's played on a smart device with Alexa, where you pop popcorn by just sitting there and popping popcorn by telling it to pop popcorn. And it's a funny little exchange that my kids love. And one of the things in there, it says, "Please accept this gift as a manifestation of my continued faith in our rapidly deteriorating relationship." That's where I stole it from. I have to give them full credit for that.
In the notes.
If you want to know what it is, here, let me help you out. Alexa, play Popcorn Tycoon.
All right, could I see the file on Alexandria Alvarez?
Sir, said he's about 15 minutes away.
Yeah.
So now a lot of you are just discovering that you're playing Popcorn Tycoon.
All right, Alexandra Alvarez. Is she in custody or on bond?
Custody.
All right, Deputy Laura. Ms. Ferguson, that's going to be recalled for the 9th. You're welcome.
Oh my goodness. The sugar-free. You have to do the sugar-free. That's the
All
worst
right,
one.
could I see the file on
Yes.
John Maricama? Norma says that Alexandra Alvarez was in custody. No.
Just for the
let me see
record,
file back
don't
on
buy them.
Alexandria
Don't buy the sugar-free ones.
Alvarez. Thank you.
They
All right, could I see the file on Jean Maricama?
even moderate consumption of the sugar-free ones produces a laxative type effect with great effect.
Oh, really? I've been doing that for 30 years. I tell you every time. You do? No.
It's Caraquesco. Maybe it's under that.
Looks like the judge is getting to the
Jean
bottom
or
of
Jean
the list here of cases.
Murakami Carasquale.
Misty, we do watch some first appearance streams. We used to watch Nashville arraignments, which was hilarious. They stopped streaming those.
Are you Alexandra Alvarez? Your case is being recalled for July 9th. She'll give you a reset form. Just have a seat. They'll call you up. Thank you. Let me see the file on Guadalupe Alvarez, please.
Custody case. Yeah, we're gonna skip that one, I think.
All right, Norma, on Guadalupe Alvarez, recall that for July 9th.
Now you're a popcorn tycoon. That
Can I
game,
see the file on Rick Gutierrez, please?
kids love it. My kids have got to the point in the game where they're
Rick
in the
Gutierrez.
like in the top 30 in the or like in the game every week as far as how much they pop, how much popcorn they pop. In the game, the goal is to pop popcorn faster so you can sell it.
No, it's just Rick Gutierrez.
And you can use the popped popcorn as currency to buy new items like tumble dryers,
2024
microwaves,
6357.
To pop popcorn faster. Read another story. Stories are tough. Most of them are copyright and you cannot read them. But we can do court cases. We can do court filings. If there's a court that's coming up that there's a filing you'd like me to read, please send it to me. I'll see what I can do. There are some I won't do, like the Eccles v. Owens v. Eckers. I forget which one that was. I can't read that. It's terrible. I can't edit that much stuff out.
All right, Norma, on Ricardo Gutierrez, that's going to be recalled for July 8th.
Thank you, Vicky,
It's on
for checking
page
that out
6.
for us.
Could I see the file on Kelly Cotner?
You're free to go. Okay. You're welcome.
All right, could I have a prosecutor, please?
Just
Court is calling
prosecutor.
2024 CR 6359, State of Texas versus Kelly Michelle Cotner. Could I have the state announced for the record, please?
Andrew Verisato.
All right. This hearing was scheduled at 9 a.m. It is now 11:52 a.m. and the defendant has not made an appearance. Is there a request from the state?
Request to remain without file, Your Honor.
All right. Deputy Laura, did you make the announcement?
Your Honor.
All right. The court will grant the bond forfeiture remand without defendant makes an appearance. The court will reconsider. Thank you. You may be excused.
Okay, let me show you something. In this little window here. We'll keep listening to Judge Boyd. This is a courtroom. Judge Oakley. Look at the items he has. He has a timer on his desk, like an egg timer. I wonder if that's for show or if he honestly says you've got this long to respond. But just on his desk, he's got the gavel, the timer, a doorstop, a remote control. It looks like a mouse possibly, and a water bottle. So I'm intrigued. I'll keep an eye out and see if the Honorable Judge Brian A. Oakley, the presiding judge, comes back. Can we see anything from that courtroom? Meanwhile, though, let's go here. Why is this not jumping? We'll watch both for a minute. Okay. Braxton, what are you looking up for me? Debbie says Sarah Boone has written another letter since the 58-page one. She did. We covered that just the other day. It's a short one, just a few pages. She wrote it right before she found out she was not going to get another court-appointed attorney. It's not as spicy as the others. We do expect the next letter to the judge to be quite spicy and animated because Sarah Boone is finding out she's not getting.
All right,
away,
Norma,
she has to go
Samantha
forward.
Mendoza, if you recall that for July 8th.
Kathy. Yeah, sorry about that. Oh, thanks, Braxton, for looking up the updates on the Treehouse trial. I know that the case itself doesn't go back for retrial until 9/6, so later this fall.
Can I see the file on Ruben
late
Solano,
summer.
please? Everything else is. Norma, on Ruben Solano, if you recall that for July 8th.
It's back in court on 8/1. Day on the docket. Are you talking about?
All right. Could I see the
Treehouse?
file on Mario Herrera, please?
Because that's the day that Lori Daybell starts in Arizona, and just before Robert Tellis.
Norma, on Mario
gonna be
Herrera,
busy.
recall that for the 8th and let the defense counsel know he needs to be present.
Going to take a look at Sarah Boone's docket really quickly to see if there's anything new.
All right. Could I see the file on Natasha Morgan? So Umberto Saldana was that attorney. All right, great.
I don't see anything new on Sarah Boone.
All right, could I see the
We've covered all
file
that.
on Sergio Barrera? All right, yay. And Norma Axel Ramirez.
This courtroom Zoom has been on in the mini box.
Axel
for a
Ramirez, you need to
long time.
come forward.
It's been live streaming for 4.5
You need
hours.
to report
with
to your
nothing happening.
pretrial service officer. Do you understand?
Yes, ma'am.
And do not let me receive another violation report. Do you understand? All right, good luck to you.
That's all he gets. A slap on the wrist and go forth. Is Lori Vallow televised? I think it will be. It's going to be out of Arizona. Arizona's televised a lot of trials, so I think it will be. Looking forward to Tellis just for his ego. Greeners, do you want to break for lunch? Do you need time off from your heavy duty maintaining the internet? we're looking at the world of true crime. Please be mindful that down in the Gulf Caribbean area, we've got Hurricane Beryl, Category 5, barreling towards the Yucatan Peninsula, possibly going to make a right-hand turn. Looking at the spaghetti charts, it looks like it can make a turn and stay out in the Gulf and come up and hit Houston. That's a possibility. So it's a big one. It probably would weaken substantially going over land, but then it goes over water again, and there's a lot of warm water down there in the Gulf for it to strengthen again. So just keep everyone down there affected, and your thoughts and prayers would be great. Cat 5 is current, as last I heard as well. Is this Lori Vallow trial for her husband's murder? Yes, in Arizona. I think that's right. I think the death penalty is on the table in Arizona. It was taken off the table in Idaho because of a discovery violation by the state. But I think it's on the table in Arizona. Okay. Judge, you're a little quiet here. We might bail for just a minute on what you're doing and see if we can check out McBurney, maybe. Let's see. Chancery.
Good afternoon.
Good afternoon. I will move you both to a breakout room.
Sounds good, thank you.
Is that 3? Let's go to 3. I don't know who this is. Oh, this is the judge we were waiting for. It was this one. Sorry, I missed it. I watched it. You guys didn't get to see. They're in a breakout room anyway. Breakout room. Where's McBurney? Judge McBurney. There he is. Let's pop in with Judge McBurney really quickly. Oh, he's on lunch break. Looks like the menu hasn't changed either. Still got the looks like a mushroom Swiss burger. I think bacon mushroom Swiss on the left. Zucchini lasagna. I'm going in the middle. Vanilla ice cream for dessert, and I still don't remember what the Indian dish is off to the side, but. Valor trial Fox 10 and Phoenix is reporting pushed back to 2025. We've already got 2025 on lockdown for Koberger. B Weather Watch, show us a map. Weather Watch is much better at that. He has all the equipment. He also has the ability to just jump in this live stream without invite anytime he wants. Because he's an admin on StreamYard. So if he wanted to, he's obviously welcome to jump in and give a weather report. But I know he's working today. So Vicky says, scroll up. He's on lunch. Wanted to tell you because FOIA requests for the future. Yeah. February 2025 for Vallow. I don't think we have anything else scheduled February of 2025 yet. Was that a firm date? Can I change that in my calendar, or let's see? Let's do. Yeah, I've moved it out. Covering Baldwin next week. Yes, we are. Thurston County went live. Thank you, Josh. Let's portal over there right now. Let's see. Let's see if they're doing anything fun. If you haven't seen Thurston County, they're a hoot. Thurston County District 1. Okay.
Now this.
Josh, thanks for that tip.
The right one here.
Got several documents here. All right, Mr. Miguel Lopez, I have your guilty plea to the charge of driving under the influence. This is from September 7th of 2020. Have you reviewed this guilty plea with Ms. Collada?
Is Ruben inside a shipping container?
Yes.
You're giving up your legal rights in this case by pleading guilty to this charge. That means you give up the right to go to trial, to have the prosecutor prove this charge beyond a reasonable doubt to a jury, the right to call witnesses to testify in your defense, the right to hear and question the witnesses who would testify against you.
Ruben is in a shipping container.
You're giving up the presumption of innocence and the right to appeal your conviction to a higher court. Do you have any questions about those rights?
No, Your Honor.
The maximum sentence in this case would be 364 days in jail and a $5,000 fine. Regardless of what anyone recommends I sentence you to, I could impose up to the maximum. Now, there are also mandatory minimum penalties. And in your case, under these circumstances, it looks like that would be a day in custody. And there's also a mandatory fine of $991, but that can be waived if you're indigent. The Department of Licensing will also suspend your driver's license for a conviction for driving under the influence. Now, Mr. Miguel Lopez, did anyone make any threats or promises to get you to plead guilty?
No.
And the statement here in paragraph 11 says, on September 7th, 2020 in Thurston County, Washington, I drove a vehicle, and at that time of driving, I was affected by alcohol. Is that your statement?
Yes.
All right. I will accept that guilty plea.
So the next, the final conference for Lori Vallow is the same day as the Treehouse murder trial.
261. And that is a guilty plea to the charges of ignition interlock device and obstructing an officer. Have you reviewed this guilty plea statement with Ms. Collada?
Yes.
And the legal rights you're waiving by pleading guilty are the same as I described in the driving under the influence case.
Yes.
The maximum penalty for each count is also 364 days in jail and a $5,000 fine. There are no mandatory minimum penalties for these charges. And again, regardless of any sentence recommendation, I could impose up to the maximum sentence for each count. And did anyone make any threats or promises to get you to plead guilty?
No.
And paragraph 11, the statement says, on November 18th, 2023 in Thurston County, I drove a vehicle without an ignition interlock when one was required. On the same date, I interfered with a law enforcement officer's ability to perform his duties. Is that your statement as well?
Yes.
All right, then I will accept your plea of guilty on those charges. All right, then, Mr. Fortunato, can I hear anything further there is from the state with regard to sentencing?
Your Honor, I would just ask that the court follow this agreed recommendation. It's clearly quite involved. Would be my understanding that council, both councils have spent quite a bit of time negotiating this matter. And I would ask the court follow the agreed recommendation as presented to the court.
Ms. Colada?
Your Honor, we would also ask the court to accept the agreement of the parties. With regard to the case in which the court accepted the petition for deferred prosecution, part of the reason I forwarded to the court in hard copy form the progress reports is that it'd be my hope that the court would count his treatment beginning as of March 2024 instead of today's date. Mr. Miguel Lopez started treatment before he had the deferred prosecution evaluation,
We're hearing a Spanish
knowing
echo.
that the need was there. And I think the court should recognize that fact.
Both
With
of the same
regard
mic.
to the case ending 282, Mr. Miguel Lopez has 4 days credit in jail. I did pull the booking report this morning to confirm that information. Additionally, with regard to any fines and costs, Mr. Miguel Lopez currently makes about $1,800 a month, and he supports 4 kids on that income.
Ooh.
So he doesn't have a lot of extra, if any, at the end of any given month. So I would ask the court to waive all fines and costs that you're able to waive. Thank you.
I think the judge is fine with doing that.
There you go. Mr. Miguel Lopez, would you like to tell me anything before I sentence you?
There is an interpreter there.
No, Your Honor, I don't have anything to add.
All right, well, I'm glad that you're approaching this seriously. And I'm also glad to see that the Eugenia Center says that you're doing well in treatment. That's important. And if you keep doing that, you're going to get through this just fine. You kind of got yourself into a big mess here, but it looks to me like you're taking the right steps to do what it takes to fix the problem. And you've got a lot at stake, obviously. All right, well, this will be your sentence for the DUI. 364 days, 360 days suspended, credit for 4 days already served. As far as fines and costs, those are all going to be waived in this case. I know you have some substantial financial obligations with the deferred prosecution. And given your income and resources, I don't think you can afford any more. Your sentence is suspended for the next 60 months. The conditions are don't violate the law, don't drive without an interlock or a driver's license and insurance, don't go to bars or taverns, don't consume any alcohol, marijuana, or non-prescribed drugs, or refuse a breath test. And do the DUI victim panel and complete your treatment, but those are the same as the deferred prosecution case. You don't have to do those things twice. Do it once and you've completed the requirement for both cases.
Your Honor, may I make a additional request? Mr. Miguel Lopez has had a scram device on, I believe, since the second DUI. May he please remove that since he is actively engaged in treatment?
Absolutely. I will do that. Okay, so the scram that you've had for a while now can be removed. All right, and then I believe that the parties indicated that restitution may be appropriate in this case. The state has 180 days from today to request restitution. Correct. And if the state does that, you'll be notified and you have the right to a hearing before there's any restitution assessed. and then proceed to the sentencing on
Your Honor, I think we
261.
need to move ahead to Ruben because he's running low on air in the shipping container. We probably need to get a solution for him and maybe get somebody to let him out.
And in that case, in which you pled guilty to the interlock violation and obstruction, count 1, driving while suspended, is dismissed.
William, what's the
Counts
news?
2 and 3, there'll be no jail time imposed. There'll be no fines imposed, and the case will be closed.
You tell him to call back later. Psychosaurus Rex. That's awesome. Greeners. I'm not even going to click on that.
Teresa, I want to make sure that the order on 987 on the deferred prosecution also indicates remove this grant. If I have marked out.
He only slows down like this.
Case ending in 262,
on
which was the
translation.
original charge of obstruction, is dismissed.
Some of these conditions are really hard for. Are you eating cherries? Is she eating cherries?
The date of entry of the
Still
deferred
agrees?
prosecution will be today. I don't believe that it's appropriate to backdate a deferred prosecution.
Sugar-free
I know
gummy
that's not
bears?
a universal belief, but it's mine.
She's just licking them all and putting them back in the bowl.
All right, Mr. Miguel Lopez, I know we went through a lot there. Do you have any questions you'd like to ask me about anything that we did?
DSN, thank you for the super sticker.
Muchas gracias por todo.
Muchas gracias.
I don't have much to say, Your Honor, except to thank you very much for your patience in accepting all of these, and this won't happen again.
Yes.
All right, well, it's on you to do. It's on you to do the work, but it seems to me that you're capable of doing it. All right, good luck to you, sir.
Okay, Ruben, are you up? Let's go to the shipping container. Or interrupt some.
This morning.
She ate all the cherries off the branch to her right. Tish.
Your Honor, this time I would defer to Mr. Keelan. I believe he has a single case to call, and Mr. Kale has a case to call.
Okay.
I just wanted to.
We'll just print up Mr. Miguel Lopez's documents first.
First, Your Honor.
Headphones in, or are we going for earwax? I'm not sure. I think it's headphones.
Good morning, Mr. Vila.
I'm appearing on behalf of Mr. Martinez Sanchez today. And I'm substituting for his attorney, Justin Huxford. It's one of Mr. Huxford's public defense cases.
I'm sorry, I'm.
Yeah. Oh, yeah, that's right. Yeah, that's right. I didn't address that. Just mitigate the speeding ticket down to 95. As low as I can go on those.
Thank you.
Yeah, sorry, I missed that.
Got to find a nice place where I can hide in the corner here. Maybe up here. Lawyers can substitute. Yes, as Miss Bumpus found out. Ooh. What's in the jug? I'm thinking water. Substitute lawyers assign less homework. Can you use one of the judges' squares?
Yeah, that's the deferred.
Did Ruben get out? Or is he falling to the floor?
So Mr. Peelan, we'll restart with Mr. Martinez Sanchez.
Thank you, Judge. So in this case, I believe Mr. Huxford came on board a little over 2 months ago. He received this case as a conflict. I believe, based on what Mr. Martinez Sanchez has told me, it's his third attorney on this case. At least his second attorney on this case.
That's right.
I'm sorry, what?
4 and 5 on the 9:30 calendar.
So I had a discussion with Mr. Huxford this morning. I've been in touch with him via email. And I also met with Mr. Martinez Sanchez. Mr. Martinez Sanchez is frustrated with this process. This case has been going on, he says, for over a year. And even though this case is new to Mr. Huxford, it is not new to Mr. Martinez Sanchez. He informs me that there may be a potential defense. I know nothing of this case other than what's been explained to me. There may be an issue with the validity of the protection order at the time that Mr. Martinez Sanchez was contacted by law enforcement and arrested. Regardless, there is still no offer from the state. Mr. Huxford indicated to me he received a response from the prosecutor yesterday evening, but they have not had an opportunity to sit down and negotiate a settlement. Mr. Martinez Sanchez is opposed to any additional trial continuances. We're on for confirmation today. Mr. Huxford requested that I discuss with Mr. Martinez a waiver, moving the trial out and setting a new hearing, a new pretrial hearing in about 2 to 3 weeks, at which point he would negotiate with the state and see if there's a possible settlement.
Okay, this is not terribly exciting.
At the very least, I know that Mr. Huxford needs to have time to prepare for trial if indeed that is where things go. So I have advised Mr. Sanchez Martinez about, or Mr. Martinez Sanchez about his speedy trial rights. At this point, he's not willing to waive that. I'm going to ask that the court allow a good cause continuance. I'm not asking for a long continuance. I'm asking a 1 to 2 week continuance of the trial date to allow Mr. Huxford to have that conversation with the state, have a conversation regarding a settlement with Mr. Martinez Sanchez. And if all fails, then it will give Mr. Martinez Sanchez's attorney time to prepare for trial and provide an adequate defense. Mr. Huxford's only had this case for about 2 months, and it sounds like there may be, if I listen to what I've been told by Mr. Martinez Sanchez, there may be a legitimate argument regarding the knowledge element of the protection order. But that's going to need some time to verify. So that's my request today.
Mr. Fortunato?
Your Honor, there's no objection to that. Or I guess at this point, there's a good cause, but there's no objection from the state. I'll relay to the DPA side of the case that Mr. Huxford wishes to negotiate this case and see what I can do from my end.
Miss Dela Cruz had too many cherries. She's
Well,
now
Mr.
in
Pilon, you've certainly
a
given
cherry
me a couple
coma.
of reasons that I could independently find good cause to continue the trial. Clearly preparing a legal defense, as you described, to the underlying protection order is one that I think by itself would justify a continuance. Mr. Martinez Sanchez, I know you don't want this case to continue any further. I know you want your trial. But your attorney has an obligation under the rules, the government attorneys, and his obligation to you as his client to be able to be prepared to go to trial and defend you. And those two things don't always coincide smoothly. In other words, you want your trial quickly, but if you get your trial quickly, your attorney's not ready to properly defend you. This is one of those times.
His attorney is arguing against his right to a speedy trial.
And in that situation, I'm going to give your attorney the time that he needs. Even though I understand that means your trial's going to be delayed a little bit longer.
The right goes to the defendant, not to the attorney.
But not very long. I'm sorry, go ahead.
I understand.
Yeah, it's not going to be very long.
And thank you, Your Honor. And I'll add for Mr. Martinez Sanchez's benefit, Mr. Huxford's a very good attorney. And I know if he has a little bit of time to prepare, if this ends up having a good trial, I know he can do a very good job for his trial. But he does need some time, obviously, to prepare a case. So I think this is definitely to his benefit.
All right, so looking at the calendar and the need for a relatively short continuance, I'm looking at trial for August 14th. It'd be August 14th and 15th. And we can put it on the calendar for confirmation on August 6th.
Cherries do have a natural melatonin for help for sleep. Well, I think she ate the whole bowl.
No. All right,
I'm still
the next
seeing
court date will
grading.
be August 6th at 9:30 for trial confirmation.
Thank you, Your Honor.
Ruben's audio was getting a little loud there.
Thank you, Your Honor, for your time and your
Ruben's
patience.
out. He's
Yeah,
escaped.
if you would like, we can print a notice.
Cancel the search party. Attorney Carl is here. Welcome, Attorney Call. Ruben enjoying the fresh air. You can see the open shipping container behind him. He's looking behind him, make sure nobody's following him. He's made his escape. This is wonderful news. Ruben is on the run. Freedom. Nothing like blue sky and green trees to make you feel alive again, eh, Ruben?
Mr. Kale.
No. Did you go back? Did you get back in? Do you need help? He went from one shipping container to another, or maybe he's hiding behind one. Okay, I'm here for Ruben. I need to know what's up with the shipping container. Also, Miss Dela Cruz, sleep on. Yeah, sleep on. Get that rest you need. We can always reschedule the court date anyway. We know you're good for it. You're here. That should count for something. Tug at your right ear if you need help. Ruben, that's for you. Are they watching you right now? Blink once if they're watching you now. It's not blinking. I think he's good. I spent all day in a tiny room, and it shows. All right, so we're who do we have left in court? No more translators, I think. So we might be on to English. Got attorney call here for something.
Okay, Mr. Kale, you're up.
Oh, Kale, sorry.
Good morning, Your Honor. I'm here on behalf of Hezriel Vega Rivera. The last case is on the 9:30 calendar. Mr. Vega Rivera is on for confirmation. He's waiving his appearance today and appearing through counsel pursuant to Rule 3.4. Mr. Vega Rivera and I have been in good contact. He's not able to be here today because he's having surgery, and for that reason, defense is not prepared to confirm for trial next week either. Instead, we're asking the court to reset trial to the either July 29th and 30th or July 31st, and if that's possible. The reason for that, Your Honor, is because he's going to have about a 4-week recovery process from the surgery, and having it so close, where it's currently said it's very close to, it's very early on in that recovery process, and I think we need him sort of at his best for him to be able to assist in his defense and fully participate in trial.
Maybe he's at storage units.
Fortunato, does the state have any objection to that?
That looks like a storage unit.
Mr. Kale, to be safe, why don't we go to the July 30th and 31st settings?
That's a Tuesday and a Wednesday.
Oh, I'm sorry. Did you say the 31st and August 1st? Okay, yeah, that's what I got wrong. Okay, let's go to that one, July 31st. Trial. And confirmation on July 23rd.
Ruben, I know this is a more comfortable
At
seat for
9:30.
you than the shipping container, but the cell signal is terrible here.
That should work.
That works, Your Honor. Thank you.
All right, thank you, Mr. Kale.
He's in HR. That's the employment poster.
Okay,
On
Ms.
that.
Colada, I think we're back to you.
May we please call numbers 11 and 12 on the 9:30 calendar? Ruben Torres Montes, he's appearing via Zoom.
Ruben, you're up.
All right, good morning. Good morning, Mr. Torres Montes.
Buenos días, señor Torres Montes.
Your Honor, may I-
¿Escucha bien?
Ruben,
No, did he freeze? Okay.
Ruben, you were solid all morning.
All right, I can call
And now
something
we've
else
got
in
nothing.
between.
Antonio de la Cruz, maybe?
You know how it works.
Oh, there he is.
¿Escucha?
Sí, sí escucho.
Okay, you can hear.
Your Honor, may I have the court's indulgence to remain seated so that you can see?
Absolutely.
And Your Honor, if I may approach, I have a substance use evaluation and a victim
Tengo
impact.
aquí una prueba de la evaluación de sustancias.
Today, Mr. Torres
Hoy el
Montes
señor Torres Montes.
will be entering a plea to an amended charge of negligent driving in the first degree.
A un cargo reducido.
And it's my understanding the infractions will be
Entiendo que la
dismissed.
infracción se le va a desestimar.
Fortunato, state's motions.
Yes, Your Honor, at this time, the state is making an oral motion to amend to negligent driving in the first degree.
Sí, sí, señoría, estamos de acuerdo. Rebajarle el cargo a manejar de
Negligent
forma
driving in the
negligente.
first degree. They agreed to drop it down a little bit.
12 on the 9:30 calendar. All right, I'll grant the state's motion and amend the charge to negligent driving first degree.
Ya, acepto la petición de la fiscalía y le rebajamos el cargo a manejar en forma negligente en el primer grado.
Mr. Torres Montes, have you reviewed your guilty plea with Ms. Colada?
¿Usted revisó la declaración de culpabilidad con la señorita Colera?
Sí.
Yes.
And you're waiving your legal rights by pleading guilty to this charge.
Renunciando sus derechos legales al confesarse culpable de este cargo.
You're giving up the right to take this case
Está,
to trial. Oops, he's trying to talk.
está renunciando a tener el derecho a un juicio.
The
No, no la
right to
escucho
call.
muy bien.
Okay, he's having trouble hearing.
¿Me escucha ahora?
Sí, sí la escucho.
Ok. Usted, al confesarse culpable de este delito rebajado, usted está renunciando a ciertos derechos legales. Está, por ejemplo, renunciando al derecho de tener un juicio.
Right, the right to call witnesses to testify in your defense.
Renuncia al derecho de llamar a testigos y que testifiquen a su favor.
The right to hear witnesses testify against you and question them.
El derecho a escuchar a testigos que testifiquen en su contra, a interrogarlos.
You give up the presumption of innocence and the right to appeal your conviction.
También renuncia usted al derecho de que lo consideren negligente y de apelar, perdón, inocente y de apelar a su condena si lo encuentra culpable a través de un juicio.
Do you have any questions about those rights?
¿Tiene alguna pregunta sobre esos derechos?
Solamente quiero pedir disculpas por lo que hice.
Yeah. No, I only want to apologize for what I did.
All right, Mr. Torres Montes, the maximum sentence is 90 days in jail and a $1,000 fine. And no matter what anyone recommends, I could impose up to that maximum sentence.
La autoridad que tengo es darle lo máximo que prescribe la ley.
Did anybody make any threats or promises to get you to plead guilty?
¿Alguien le hizo alguna promesa o alguna amenaza para obligarlo a confesarse culpable?
No, señor.
No, sir.
And the statement written on your plea form says on March 26, 2024 in Thurston County, I drove a vehicle in a manner that was both negligent and likely to endanger property,
con la posibilidad de que podía poner en peligro las propiedades ajenas.
and I exhibited the effects of having consumed alcohol.
Los efectos de haber consumido alcohol.
Ms. Del Cruz
Is that your
completely,
statement?
REM 3, I'm thinking. She is out.
Yes.
I will accept your guilty plea.
Acepto su confesión.
Mr. Fortunato, can I hear from the state
Entonces,
first?
el fiscal, quiero escuchar lo que dice el Estado primero.
Your Honor,
Su señoría.
I was the DPA assigned to this case.
Continue.
Oh, ok, el abogado fiscal que estaba al frente de este caso.
I had the chance to negotiate this with Ms. Collada.
Tuve la oportunidad de negociar esto con la señorita Colara, la defensora.
And I do think this is an appropriate resolution,
Y me parece que es una resolución adecuada.
noting that some of the affirmatives, including the victims panel and evaluation, have been completed beforehand.
De que él tomó la evaluación, hizo la evaluación y también la clase de impacto a las víctimas.
I would ask that the court follow the agreed recommendation.
Pido a que la corte esté de acuerdo con la petición del acuerdo.
Ms. Collada?
Señorita Colara.
Your Honor, we would
Su
also ask
señoría
the court to
también le
accept the
pedimos a la
agreement
corte que
parties.
acepte el acuerdo de los participantes.
This is a relatively
Este
quick
es
resolution
una
in a case
resolución
like
rápida
this.
en un caso como este.
Mr. Torres
El
Montes was
señor Torres
accused of DUI
Montes
in late March.
se le
and it's
acusó
just the
de
beginning of
borrachera en marzo y esto es solamente el
Been
comienzo de
proactive and
julio.
quick to take
Él,
responsibility.
él ha sido muy proactivo en tomar responsabilidad.
I would ask the court
Le pido a la
to reduce fines
corte
and costs in whatever way you're able.
de que le minimice los costos de todas maneras que usted pueda.
And invite the court to inquire about Mr. Torres Montes' ability.
Y le invito a la corte de ir a preguntarle al señor Torres Montes su capacidad para poder pagar.
Mr. Torres Montes, would you like to say anything before I
¿Quería usted
sentence
decir
you?
algo antes que lo sentencie?
Igual que lo siento mucho por lo que he hecho. Me ha
Me ha costado mucho no tener mi licencia con la enfermedad que tiene mi esposa y pues acepto mis responsabilidades.
Just to say that I am very, very sorry that I did this. And this has costed me a whole lot, since it has affected me a great deal, not having the driver's license being that I need to take care of my wife who is ill.
All right, Mr. Torres Montes, I will follow the sentencing
Voy a
recommendation,
aceptar la recomendación de sentencia.
and your sentence will be 90 days with all 90 days
Sentencia
suspended.
va a ser de 90 días de cárcel, todos suspendidos.
The only cost will be a probation fee of $120.
El único costo que le voy a cobrar es el costo de probatoria de $120.
For the next year, the conditions of your
Año,
suspended sentence are
condiciones de
these.
sentencia suspendida aplica.
Don't violate the law and don't drive without a license and
No
insurance.
maneje menos que tenga licencia y seguro válidos.
Don't go to bars or taverns or consume any alcohol,
Consumo
marijuana, or
marihuana,
non-prescribed
ni
drugs.
sustancia que no sea recetada por un médico.
And turn in proof to the court of your evaluation. We have that. Your victim panel, we have that now as well.
La evaluación y la clase de
And
impacto a las víctimas.
your treatment until you complete the recommendation of
Y
the
también sigue el
evaluation.
tratamiento que le esté recomendando la agencia de la evaluación.
Do you have any questions about your sentence?
¿Tiene alguna pregunta sobre su sentencia?
No, muchas gracias y otra vez vuelvo a repetir lo mismo. Me siento arrepentido de lo que hice.
Yeah. No, thank you very much. And again, I reiterate, I am very, very sorry and regretful of what I did.
All right, thank you, sir.
Gracias, señor.
And the infractions
We're in
for
Thurston
no
County,
insurance and
Washington
failure to
here.
stop are dismissed.
La infracción de no
Phil,
tener
Twilio
aseguranza y
Toys.
de que no paró,
Frog was
se le
frayed.
desestima.
Good to see you, my friend. Welcome. If you
All
don't
right,
follow
Mr.
him on
Torres
Twitter, you need
Montes,
to.
you're good to go, sir.
Todo el monte ya se puede ir.
Is he in a
Gracias.
car? Is he in a car now?
Thank you.
I think he's driving.
Mary, next, please call number
that's
2 on the
that's
9:30
Fidel
calendar.
Lopez.
Until Lopez Morales, who's appearing via Zoom.
He is in a car,
Yes.
possibly
Mr.
the prison
Lopez
bus.
Morales. There he is. Good morning, sir.
Señor López Morales, buenos días, señor.
You're muted.
Yeah, you need to unmute your microphone.
Ya, tiene que sacarle de mudo al micrófono.
Your Honor, this case comes on for a compliance review,
Mhm,
and Mr. Lopez Morales has completed outpatient treatment
mhm.
as well as his victim impact panel.
Ya, el señor López Morales cumplió el tratamiento interno, como también la clase de impacto a las víctimas.
The probation department did not accept his victim impact panel because they said it was online.
El departamento de probatorio no le aceptó la clase de impacto a las víctimas porque la hizo en línea.
And despite a certificate of completion of treatment, we have not received a substance use evaluation.
Y aun cuando se dice que cumplió,
And Your Honor, I'm passing forward some hard copies for the court's review.
estoy pasando las copias para que las vea la corte.
The certificate of completion.
None of this has woken up Miss Dela
treatment
Cruz yet.
program is from Bridgeway, which is a treatment provider in Everett, Washington.
Ya, eso, el comprobante de la prueba es que de una agencia que se llama Bridgeway, que es una agencia que está en Everett.
I have not been able to obtain a copy of the substance use evaluation.
No he podido obtener una copia de la evaluación de sustancia.
However, I'm asking the court to waive that requirement because I'm not aware of a treatment agency in the state of Washington who would allow an individual to participate in outpatient without an evaluation.
Yo le pido de que desestime ese requisito porque no conozco ninguna agencia en el estado de Washington que sencillamente le permita hacer ese tipo de evaluación.
And it looks like he completed that a year ago.
Eso fue hace un año atrás, dice el juez.
All right, we'll mark that condition as complete.
Voy a marcar esa condición como que la completó.
That's yours.
So, Your Honor, I otherwise think
De otra
Mr.
manera, su
Lopez
señoría,
Morales
el
is in
señor López
compliance.
Morales está cumpliendo.
Now I'm not familiar with this online panel here.
Yo no estoy familiarizado con
Is
este
this,
clase en línea.
Is this a live panel, so to speak, or is this like one of those click-through, excuse me, a click-through class?
No sé
Your
cómo es
Honor,
la
it is
clase.
not a live panel.
No es una clase en vivo.
We do not currently have a live panel
No
in Thurston
tenemos
County.
en un contador
And the other panels are some
una
distance
clase
to
en
travel.
persona, el otro
There is
de
a
otra
not
manera les
regularly
requiere
scheduled
viajar.
Spanish
No
Zoom
hay clases en
panel,
español en Zoom.
that I've struggled to arrange for clients because it's not actually on set.
Programar eso para los
So I've been using this
clientes,
as an
así que he
alternative.
estado
So
usando
there's
esto
just
como
nothing
una
else
alternativa.
available.
Correct, and given the status of most people's driver's licenses, asking them
Puesto
to
que la
drive out of
situación de
county
las
is not
licencias
equitable.
de
Yeah,
mi
I'll
gente
accept it for
no le
Mr.
permiten
Lopez.
viajar fuera del condado.
I'm tired just watching Miss Dela Cruz enjoy some
And
peaceful
his,
rest.
let's see, when's his probation up? Like he has until 2 of 26. Okay, Mr. Lopez, I'm finding you're in compliance currently with your probation and you're good to go.
Con todas las condiciones y se puede ir. Escuchó.
Mr. Lopez, you're good.
No, I'm sorry.
They sent him a collection notice.
Nobody's managing this
We'll just
Zoom.
have to deal with that. All right. Anybody else?
Señor Fidel López, ¿escuchó?
Sí, sí escuché. Entonces yo ya cumplí con todo o qué me falta.
So I comply with everything. And
Yes.
The judge
sí,
knows
sí, cumplió
Spanish.
con todo, ya se puede ir.
Yo lo único que sé que no le he pagado porque no tengo ahorita la suficiente cantidad, no tengo mucho dinero porque tengo mi familia, pero sí les voy a pagar en estos
A lot of
días.
money. Mucho
Yeah, the
dinero.
reason I haven't paid yet because I don't have any money and I do have my family, but I will pay as soon as I am able to.
Yeah, it looks like they sent you a letter just a couple days ago because you hadn't paid the $43 that was assessed at the beginning of the case.
Parece que le mandaron una carta hace un par de días cobrándole algo de $42 que era la factura inicial, el cargo inicial.
Ok, pero yo el día que tenga yo lo voy a pagar todo completo.
Okay, so the day that I get enough money, I will pay for all of it.
Okay, and when you get that notice, if you haven't got it already, you'll need to reach out to the collection company right away to make arrangements to
Póngase en
pay that.
contacto con la agencia de colección inmediatamente para hacer arreglos con ellos y no les sube el interés.
Oh, ok, muchas gracias por decirme eso. De por sí no tengo dinero y pagar colección.
Yeah. Thank you very
Stella
much for
Cruz,
letting me
just in
know
time.
that, that
Just
I
in
don't have
time.
enough money and now in collections. Okay, ahorita se puede ir, señor Morales.
Gracias. Gracias.
Thank you, thank you.
Still have
More cherries. She's back for more cherries.
Well, it doesn't think he requires a non-interpreter.
Mhm.
He also speaks Spanish and English.
Oh, I
believe we waived non.
think we established that before because I remember being impressed that he speaks all three of those languages.
And Your Honor, this case comes on today for compliance review.
Este caso está aquí para una revisión de cumplimiento.
He has a new matter still pending in
Tiene
Mason
un
County.
asunto pendiente
Somebody
en
bring in a new
Mason.
branch of
I
cherries
have
for
been
her.
in contact with the Mason County attorney.
Mhm.
And it sounds like she's hopeful of a
Así
resolution
que
soon.
ya tiene esperanza.
Looks like they have a hearing on July 31st.
So we're just asking to continue this to give them time to work that case so that we know how to respond.
All right. Any objection to that, Mr. Fortunato?
Les pregunto al fiscal, ¿acaso está de acuerdo que lo pongan también? A ver,
No, Your Honor.
no se opone, está de acuerdo.
Let's go to September on that. I see they also have a jury trial scheduled in August. Sure, 10th will work. Okay, 10 o'clock, September 10th.
I think Miss Dela Cruz just polished off that plate.
At 9 o'clock or at 10 o'clock?
10 o'clock.
10
A las 10, yeah.
This is like when you eat a bag of Cheetos and you're all done and you've got like orange on your fingers. You can rub them together and get the bonus Cheeto. I think she's Cambodian interpreter, also speaks Spanish and English. I don't think we have, I'm not sure if Dela Cruz is here for her own case or not. It's finger looking good. Just like KFC. Need to lower the text so that you can still see her.
Thank you, Mr. Amir.
Enjoying the crumbs.
Yeah.
Your Honor, may I next please call number 2 on the 10 a.m. calendar, Francisco Pablo Jose? Yes.
Good morning, Mr. Pablo Jose.
Okay, these translation
Here
ones
today
are
for pre-trial.
difficult. I might try to find something else. They're so noisy. Let's actually do
It's
this.
like arraignment was
Let's
on
jump
June
over
10th.
to something else from today, also from Thurston, Washington. Different court. This is a trial.
So September 9th is the expiration of time for trial.
Note, folks in the courtroom, these proceedings are being live streamed on YouTube.
Get the case set
public
within that.
access.
This is also Thurston, Washington, different courtroom.
Start
This is motions
Brandon
in limine
Bach.
for a jury trial. These are when they make rules about what can and can't be.
Good morning, Your
allowed in
Honor.
Court.
Murphy, good morning.
Good morning, Your Honor.
Kale, good morning.
Kale, you're back.
We are waiting on Mr. Bach to log in, Your Honor.
Say that again.
We are waiting for Mr. Bach to log in. I spoke to him about 45 minutes ago and sent him a Zoom link. I think he must be having technical difficulties right now.
Has somebody been trying to log in? All right, we haven't noticed him trying to log in yet. And are we anticipating pleas in that matter?
We were going to ask for continuance, just so we have an opportunity to really discuss the offer.
Okay, their audio is even worse. That is terrible.
Thank you. And Mr. Kale, you're in on one of the matters, is that correct?
Two, Your Honor. The 223 DP cases are assigned to me, and then the 22 DP cases, Mr. Murphy.
Okay, all right, thank you.
This is so bad. We're gonna find.
And you're in the same position on your matters?
Yes. It's we're going to be resolving them all together, but we're asking for 2 weeks. That way we can go over this in a little bit more detail with Mr. Bach and make sure we're all on the same page.
Okay, we're gonna jump. We're gonna go to Mr. McBurney's courtroom. See if we have anything going on here.
23 SC 188280.
All right.
It's a singular count of possession of a firearm by a first offender probationer.
Uh-oh. Pew pew.
Okay. Ms. Rivers, are you ready? Okay, we're going on the record in 2 matters involving DeMonta Williams, who is here in court with his lawyer, Ms. Wood. Mr. Hiles will be handling things for the state. We have 17 SC 156244, which was on for a probation revocation hearing. And my understanding is that I will be resentencing Mr. Williams no longer as a first offender, but as a felon in that case that relates to participation in criminal street gang activity. And Mr. Williams is prepared to enter a guilty plea in 23 SC 188280, which is possession of a firearm by a first offender probationer. Is that what you think we're doing today, Mr. Williams?
Yes, sir.
Okay. You seemed hesitant to answer. Was it because what I said wasn't clear, or you're not sure what you want to do today?
I'm just discombobulated, sir, but I'm clear.
Okay. Well, those terms don't really go hand in hand. What you are about to do, assuming you want to go forward, is plead guilty to what I'm calling your newer case, where you allegedly had a gun while you were on first offender probation. That's number one. Number two, as a result of these new charges, I'm revoking your probation in your old case way back from 2017 when, and resentencing you. I think it's going to be the same sentence as what you're getting with your plea. But either way, you're pleading guilty in one case and you are having your first offender status taken away in the other case. Does that make a little more sense?
Yes, sir.
Okay. Mr. Hiles is going to put you under oath in just a moment and ask you some questions. You should answer the questions, assuming you understand them. But if at any point you become discombobulated, let Ms. Wood or me know so we can uncombobulate you, okay?
Yes, sir.
All right?
We'll combobulate you.
When you're ready, Mr. Hiles.
All right, and Judge, I would ask that he is here today. We were to determine whether or not we were going to go forward with an actual evidentiary hearing. We've decided to resolve this. A formal petition to revoke first offender probation has not been filed. However, we have come to an agreement, and I would just like a waiver of that right to a petition on the record from the defense.
So I bet Ms. Wood will say I waive that, but if there is a probation warrant and petition, which I think there is, that's how we got here. I don't know that there has to be notice given that you run the risk of having your first offender status taken away, but better safe than sorry. I think we're here on proper notice, more appropriately, I think we're here on sufficient notice, but let's just double dot our I's. Ms. Wood, do you waive any, I don't know that he has any, but any due process notice rights that Mr. Williams would have concerning my decision, if I decide to do it, to not only revoke probation, but revoke Mr. Williams's first offender status and resentence him in the 17 SC case?
So waived.
Okay, great. Thank you, Mr. Hiles.
Okay, Mr. Williams, will you please raise your right hand the best you can? Do you swear or affirm that the matter you are going to testify before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down.
Does he have to read that?
Will you please state your true, correct, and legal name?
DeMonte Keith Williams.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Can you repeat that, sir?
Are you at this time under the influence of any alcohol, drugs, or medication?
No, sir.
Is there any medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
I'm 26. I graduated from high school.
Where'd you go to high school?
Life Christian Academy of Performing Arts.
Where's that?
Located in Forest Park.
Are you a performer?
No, I'm not a performer.
Did you focus on some type of performing arts while you were there?
No, I actually just played football. I had a scholarship, but I had got arrested.
All right.
Performing Arts they've got a football team.
And an indictment 23 SC 188280. Are you aware that you're charged with a singular count of possession of a firearm by a first offender probationer?
Yes, sir.
Okay. Are you aware that that particular charge carries with it a sentence of 1 to 10 years?
You say I'm aware?
Are you aware that the potential sentence range of that particular charge, possession of a firearm and first offender probationer, is a 1 to 10 year sentence.
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
And what's your highest level of education?
High school.
Okay. Did you complete high school?
Yes, I did.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, sir.
Have you had time to review the waiver of rights forms and discuss all the rights that you are waiving with your counsel?
Questions that we talked about.
Oh, shoot. We should have talked about that.
So the answer is yes.
Yes.
Have you had enough time to speak with your attorney, Ms. Bullitt, about all the facts and circumstances known to you regarding these charges in this accusation, including potential defenses?
Yes, sir.
Do you need any more time to discuss this case with your attorney?
Can I have 5 minutes with her, if that's okay?
You can have as much time as you need.
Thank you.
Okay.
She's like, we already went over this. What's up now? All right. Where are we? Do we want to jump while they do that? They get 5 minutes. We can jump to
orally or in writing can be used against you. You have the right to have an attorney present during any questioning. If you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. You have the right to a preliminary examination. In this case, it would be scheduled for July 18th. It would be at 11 a.m. with Judge Stepka. Also, on July 12th, you would have a probable cause conference at 2 p.m. So now, Ms. Ali, that you have the other information, Mr. Southford is currently being remanded till the time of that probation violation hearing, which has not yet been set. He was just arraigned on it yesterday. Do you have any other information that you'd like me to know regarding bond?
Well, there is. So Mr. Southford, he is a so-called local boy, born and raised in this area. His family's all in this area. There is a child support order as to his 2 oldest children, for which he's responsible for paying $372 a month. His 4 younger children, he and the mother have an arrangement worked out, purchases some items, and also provides cash. It is my understanding that he is welcome back to work at LT Builders as a carpenter, where he's previously done work for a year or thereabout. Held pending the hearing. So for that reason, Mr. Southford, do not want to, have you released or given a PR bond on one case if you're being held on another. That's something you and your attorney can address. So Mr. Southford and I had discussed that, perhaps with the CAM unit, the court may get him to be released at a PR bond. But that is an issue that would be more appropriately scheduled in front of the judge, Mr. Southford.
Oh, thank you.
Did you see him? Besides, I wasn't sent an email and I don't have the action court in my queue.
all right, they're back in the other one. Let's check and see what's up here.
Yes, I do.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Can you inform that for me?
So you understand that this guilty plea, if you are to commit other crimes or charged with other crimes, either in this jurisdiction or the jurisdiction of counties of Georgia or any other
state in the country, the sentence, the conviction in this case can be used as aggravation or sentence enhancement in other crimes you may be charged with in the future. Do you understand?
Yes, sir, I'm aware.
And do you understand that if you are currently on probation or parole, your probation or parole, we were both on during this case today. You understand that now your status as a convicted felon, you will not be able to possess or use any firearms unless and until your rights are fully restored. Do you understand?
Yes, sir.
Do you understand that if you're placed on probation, you cannot violate any criminal law, any criminal unit, or any special condition of probation without being subject to the revocation for the balances? Do you understand?
Yes, sir.
Mr. Williams, are you a United States citizen?
Yes, sir.
Okay, and you understand that neither the court nor the district attorney's office has anything to do with parole, Department of Corrections, or Board of Corrections parole. And no one can guarantee parole, no matter what anyone has told you to understand.
Yes, sir.
And do you understand that there may be other adverse or unfavorable consequences as a result of Bill's guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, and the ability to obtain employment. You understand?
Yes, I do.
You understand that you waive any and all offenses, including any mental health offenses, by entering a plea of guilty.
Yes, sir.
Do you understand that if you have the trial, you would have the right to trial by jury, the right to speak, your witnesses, all to testify against you, and the right to testify or to remain silent and not incriminate yourself? You understand?
Yes, I do.
Do you understand that by pleading guilty, you are giving up the following rights? I'm going to go over these one by one, okay? You understand by pleading guilty, you're giving up the right to trial by jury.
Yes, sir.
Do you understand by pleading guilty, you're giving up the right to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you're giving up the right to confront witnesses against you?
Yes, sir.
Do you understand that you're giving up the right to assistance of counsel hired by you or to court appointed counsel without afford an attorney at a trial of the case?
Yes, sir.
Do you understand that you're giving up the right to the presumption of innocence?
Yes, sir.
You understand by pleading guilty, you're giving up the right to testify on your own behalf and to present other evidence?
Yes, sir.
Do you understand that you're giving up the right to subpoena witnesses and compel the production of evidence?
Yes, sir.
Do you understand that you're giving up the right to have charges against you proved beyond a reasonable doubt?
Yes, sir.
And you also understand that by pleading guilty, you're giving up the right to appeal the conviction of these charges after trial.
Yes, sir.
Has anybody forced, threatened, or promised you to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charge of possession of a firearm by a person under probation?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, sir.
And do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness or constitutionality of this guilty plea? Do you understand?
Yes, sir.
And you understand that you have only until the end of this term of court to file a motion to withdraw your guilty plea. Do you understand?
Yes, sir.
Your Honor, were this case to go to trial, the facts would show that on May the 9th of 2023, Officer Jay Skinner of the Atlanta Police Department responded to a call of a potential individual with a firearm. He went to the location of 445 Cleveland Ave, which is the Fairway Gardens apartment complex. And upon arrival, he spoke with a security team who advised that a black male wearing all black with red hair lifted his shirt and revealed that he had a firearm on him as he was involved in a verbal dispute with another party. The security team then informed the officer that the male does not live within the apartment complex, and they would like to issue that individual a criminal trespass warning. The officer Skinner then spoke with the male who identified himself as Mr. DeMonta Williams. He admitted that he was carrying a firearm. Mr. Williams advised that he was carrying a firearm because he was not sure whether or not the person he was engaged in a dispute with was armed himself. And upon confirming that the defendant was on first offender probation, officer then placed Mr. Williams under arrest. A .40 caliber Taurus G2C handgun was recovered from Mr. Williams. That would be the basis of the
40
state
cal
case
Taurus.
should this have gone to trial.
Okay.
Cheap gun.
And did you have conditions of, I got the 10 served 2 balance probated. I missed them if you shared them. Maybe you haven't shared them yet, and maybe you have none.
So because it's sentencing under the Gang Act, the mandatory conditions are.
That would be for the first offender sentence, but how is this under the Gang Act?
So I guess it would not be.
Okay.
The conditions I would be referring to, well, I would ask the special condition be no firearms, obviously.
Okay. Obey the law.
Obey the law.
Yeah.
But for the
That's a special condition.
under.
We'll get to those conditions in a moment. Okay.
No, I didn't have any special conditions.
Mr. Williams, is there any reason you would need to be at 445 Cleveland Avenue?
I was there with family.
Okay, I didn't ask that well. I didn't mean to say, why were you there that day? Going forward, because one condition I could think of would be, hey, let's just keep you away from 445 Cleveland Avenue, because if there's someone who lives there that you've got a beef with, let's just not go back there while you're on probation. But if your aunt lives there, then maybe you have a reason to go back there.
Well, I do not have a reason. It was just a barbecue that day, and I was there.
Got it. And to be clear, you're generally free to go where you want to go, but I'm going to have as a condition of probation, special condition in this case, that you stay away from 445 Cleveland Avenue. What apartments?
It is the Fairway Gardens apartments.
Fairway Gardens apartment. Okay, that'll be it for the 23 SC. Let me cover a couple other things, and then I'm going to hear from Ms. Jackson. I believe that in light of the guilty plea that I'm about to accept, but that you've tendered, Mr. Williams, you violated the terms and conditions of your probation in 17 SC 156244. That is a case that you pled guilty to in front of me in May of 2021. Mr. Shepard was your lawyer in that case at that time. He's since withdrawn from representation. And you were sentenced to 10 years to serve 1 year with a balance on probation, so 9 years probation, plus an additional 5 years suspended because of the gun count in that case. And that was a first offender plea. Because of your conviction in this May 2023 gun case, I'm going to revoke your first offender status and resentence you in the 17 SC case. Okay?
Yes, sir.
And I'll tell you what that sentence is in a minute. I need to finish with your plea in the 23 SC case. Ms. Jackson, could you share with us, please, the criminal history information you have for Mr. Williams?
Yes, Sean.
How long
He
is
has
this gonna
4 cycles. The last arrest was May the 9th, 2023 with the city of Atlanta for possession of a firearm by a convicted felon. There was no conviction listed for that arrest. He does appear to be on first offender probation. That case number is 17 SC 156244 for aggravated assault. That disposition date was May the 11th, 2021. The term is for 9 years. He does have one misdemeanor conviction that was in 2017 for theft by shoplifting. Nothing in addition, Your Honor.
Thank you, ma'am. Appreciate it. Mr. Williams, anything you want to add about any of the things we've discussed?
No, sir.
Any questions?
No, sir.
All right. Ms. Wood, anything you want to share about Mr. Williams?
Briefly, Judge. So he has served 27 days in custody for this case. I would ask that be included on the final disposition. He did have a number of family members here earlier today. They had to leave. They did just want me to share with the court. He was
We're going to support him,
in
but
the
they left.
Construction Ready program, getting some job skills prior to this arrest. And he also has a letter of recommendation from Pastor Frederick Dyer with Grace Covenant Ministries, recommending or letting the court know that, you know, even though Mr. Williams has had some struggles, he really is a good person and really does want to get back on the right path.
This is Judge
Otherwise, Judge,
McCree.
he's 26. You've heard he's a high school graduate. He has a child on the way, and he is eager to get this behind him. He is accepting responsibility. He wanted me to ask the court, I know you have no control over it, if you could recommend to the Department of Corrections a transitional center or whatever the terminology is. Judge.
Sure. Okay. Mr. Williams, the child who is expected soon, will that be your first child?
Yes, sir.
Okay. Do you know boy or girl?
Not at the moment, sir.
All right. Okay. Mr. Williams, I find there's a factual basis for your plea. That's to the May 2023 gun case, and that your plea is knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to enter this plea. Do you agree with that?
Yes, sir.
Ms. Wood, do you authorize someone on my staff to sign the indictment in the 2023 case?
Yes, Judge.
Mr. Hiles, can we sign for you?
Yes, Your Honor.
And Mr. Williams, we now tend not to spread so much paper around and just get approval to sign electronically. Is it okay if we electronically sign your name to the 2023 indictment?
Yes, sir.
We'll do that. I'm sentencing you in both cases because it's a resentencing in the 17 SC case pursuant to the Probation Options Management Act. And all that means is that while you're on probation, which you will be in both these cases going forward, if you have a technical violation, maybe you have one positive drug test or you miss a meeting, that's something you and probation can work out. But if you're arrested again for anything, that will come back to me for my consideration. In 23 SC 188280, there's only one count, and I sentence you in that one count to 10 years to serve 2 years with a balance on probation. You'll get credit for the time you served, and it will be a special condition of your probation in that case that you stay away from the Fairway Gardens apartments at 445 Cleveland Avenue. As a result of this conviction, I am going to revoke your first offender status in 17 SC 156244 and resentence you. In that case, there are only 2 counts that you received a sentence on. The state dismissed all the other counts, some felony murder counts, armed robbery, some serious stuff. And you pled guilty to participation in street gang activity. Your sentence, and then you pled guilty to possession of a firearm during commission of a felony. Did you share with me or Mr. Williams what the sentencing range is for that gang count?
I did not, but the sentence range for the gang count is 5 to 20 years.
Okay, that'll make the math easy here. Your sentence on count 1 of that old indictment, now that I'm resentencing you, is 5 years to serve 2 years with the balance probated. And then count 11 will be 5 years consecutive to count 1, but that'll be probated. So the total sentence is 10 years to serve 2 years with the balance probated, just like we discussed. There are going to be some different conditions there. And I'm going to have Mr. conditions of your probation. I'm going to have Mr. Hiles describe those. They're required by law.
So the required by conditions are no contact with criminal street gang members and no participation in criminal street gang activity. Your Honor, it is a generally required that there's no contact with the listed victims. However, the listed victim is deceased, so it's not necessary.
Right. Okay. All right. Let me find out if Officer or Ms. Culler from probation needs to give you any reporting instructions. Mr. Williams will not be released right away, Ms. Culler. So my thought is he will get information about reporting to probation upon his release, but I don't mean to speak for you on this.
You are absolutely right, Your Honor.
Okay. Then I think we've covered everything. Ms. Wood, anything else on behalf of Mr. Williams?
No, Your Honor, thank you.
Thank you for working with him today so he gets closure today rather than we bring him back in a few weeks. Given what I understand about now the 2023 indictment, this seems a lot more efficient than having an evidentiary hearing in a month where Officer Skinner could say, hey, I talked with Mr. Williams. He told me he had a gun. I saw the gun, and he's a first offender probationer. Mr. Hiles, anything else on behalf of the state?
There is not, Your Honor.
Okay. Mr. Williams, when you get out, you're going to have a little one to take care of. My hope is you focus on that and not whatever was going on with your beef with this person at the Fairway Gardens apartment complex. And that things go a little bit better for you. All right. Good luck.
Thank you, Judge.
You're welcome.
All right. With that, we're going to break here for just a minute and probably take some lunch because you guys deserve it. Just saw in the news that's going on. Oh my goodness. Let's see, where was that? Was it Susan Smith back in 1994? Do you remember the lady that drove her car into the river or into the lake off the side of the bridge with her two kids strapped in the back seat? Did it intentionally. It turns out she first blamed it on some black guy or something. I think was her alibi, but then it's a long time ago. It's been almost 30 years. Okay. Anyway, she's got a parole hearing coming up, and she might be getting out. She thinks she's getting out. But back in 1994, that happened. I was in high school. I was a junior in high school, or junior or senior, I forget. Probably junior. And so she's about to come out. She's in South Carolina. Apparently, the reason she did this was she was in a relationship with a gentleman who did not want to have kids, and so she got rid of hers. Well, what's happening now is she's been in jail, and South Carolina jail phone calls are public. She's been having phone calls with men, about a dozen of them. And these phone calls have been, yes, thank you, Greeners, content warning, spicy to say the least, quite spicy. Yeah, she's ready to come out and start a relationship or 12, apparently. Yeah, they're so spicy that most of the news agencies that are reporting on them are not sharing much of them, but they are public record out there. I know. I think they've been on a couple. I think did STS talk about this a while back? Fox News is running with this today. Yeah. It's bad. It's really bad. Anyway, I don't know if they're going to come up in her parole hearing. I don't know if the parole hearing is going to be streamed, but coming up here, she's going to hit that 30-year mark and be eligible for parole. She thinks it's time to get out, and yeah, we'll keep an eye on that one. Susan Smith, 1994, South Carolina Lake. Yes, Karina, that's the one. I'm not going to dig too hard to get a copy of those phone calls because they're bad. They're really bad. but we'll see. She might be getting out. So that's on the radar. Just keep that in mind. Let's see. We're going to take a lunch. It's late. I'm not sure. Honestly, I'm not sure if we're going to come back. Courts have gotten a little quiet. We've got a few things going on. Let's see. Let me check and see who else is up. I don't see any good trials happening right now. Chisholm may be live. Let's see. He's got another fill-in. William Urick is filling in. That's this guy here.
Premises so that she couldn't come back in. So
Very well.
allowing her to stay there.
So Greenfield will continue to be a solid address.
It's a good one, yeah.
Okay, thank you. So Mr. Zemiak, keep an eye on the mailbox there at apartment 19. You'll get a notice directing you when and how to appear for a pretrial. In advance of that, Ms. Miller's colleague, Mr. Angot, will be assigning you new counsel so they can team up with you and together act in your best interest related to how you want to manage this case. The court must now set bond in this manner. That's not intended to prejudge or punish you, Mr. Zemiak. You're presumed innocent under our constitutions. However, the court must set bond in order to ensure your reappearance and afford any necessary protection for the public. Ms. Miller, as you may or may not be aware, there's a fairly lengthy criminal history that Mr. Zemiak has been challenged by over the course of some years, and it appears as though there is a ongoing case, undetermined as to whether it's in bond status or it's post-conviction in Macomb County, which would be for what appears to be a third felony drunk driving. Ms. Miller, what would you like to share with the court related to Mr. Zemiak's bond and his prospects?
Your Honor, the Macomb case is post-conviction. He's awaiting sentence. It's gone on for a little while because his attorney was working with him to prove some sobriety to the court prior to sentence. My client's been sober for 2 years. He's been working with a sober link. He was sober. There's no allegation that he was drinking on the date of the offense. With regards to the particular offense, without getting too much into the facts, I believe that there may be some defenses here and some questions with veracity to the victim. He is on bond conditions or, awaiting his sentence. He was supposed to meet with a probation officer today to discuss his sentence. The sentence is scheduled for the end of the month. So I think he has some oversight that's in place right now that he's adhering to, with the exception of what's going on with this case, which obviously he's presumed innocent on. I am asking for a personal bond on his behalf so that he can get out of court and assist in this defense and take care of the matters in his other case. My client is a resident of Royal Oak. He is employed. He works for the apartment complex that he lives at. As I stated, he has been sober for over 2 years. I understand he has a criminal history, but I think that he's trying to put that behind him to some extent. With regards to the victim, I do not think there's any concern with contact. Obviously, he understands that there would be no contact. She is not somebody who he's in a current relationship with or who has any ownership interests whatsoever with his apartment.
Thank you very much. As suggested previously, Mr. Zemiak is presumed innocent. However, he does suffer from a criminal record that goes back to when George Herbert Walker Bush was in office. So he spanned the course of multiple presidents. And there is great cause for some concern. In this particular instance, there is a suggestion of strangulation, and upon Mr. Zemiak's person was located a 10-millimeter Husky socket in his coin pocket of his pants, right side, filled with burnt chore boy. It was suggested apparently that he was hiding this on behalf of Ms. Wood.
Whoa,
that may or may not be so, but that also causes the court some significant concern. These following conditions will apply to Mr. Zemiak's continued release. He will appear as directed for all his future dates. Mr. Zemiak, you will abide any valid order or judgment entered in this case. You are not to leave the state of Michigan without permission of the court. Please don't commit any crimes while you're on release status. Notify the court in writing of any change of address, telephone, or email. Ms. Miller, until his compliance with his 16th Circuit bond can be verified in writing, the court is going to require supervision, so he will be making reports to pretrial services unless and until such time as it can be proven in writing that he is on similar bond conditions to Macomb County and that he is in compliance with same. There will be no use of alcohol, marijuana, or any other controlled substance, and you will be submitting to a substance abuse and alcohol testing regimen here in Oakland County until further order of the court. You will not purchase or possess a firearm or other deadly weapon. You will not assault, harass, intimidate, beat, wound, or threaten one Sandra Wood. Nor will you have any direct or indirect contact through a third party or otherwise with Sandra Wood. And again, with the proviso that there needs be no duplication or overlap of services. As of right now, there will be 4 SoberLink samples per day. There will be an initial drug screen. If that is negative, you need not test for controlled substances again until further order of the court. So perhaps the theory with respect to the Husky socket and the Troy boy and Miss Wood will ring true if it is positive. Given the nature of the controlled substance, there'll be 4 controlled substance screens per month. And Ms. Miller, given the
4
fact
per
that
day.
there was everything to lose and not too terribly much to gain by getting into a certain scenario with police contact again, the court is quite constrained under these circumstances. So at this time, the court will set a $5,000 cash or surety bond with a 10% provision. So that's going to be $500. And additionally, he is to contact pretrial services within 24 hours of release. And again, I will once more reiterate that if he is on a protocol substantially similar to the one that the court just ordered, there is not the necessity of a duplication of services, but until that is made plain by Judge Meineke and he agrees in writing, those will be the conditions of release. Mr. Zemyak, do you have any questions for the court or your lawyer?
Yes, Your Honor. You said that my bond was $5,000, 10%.
That's correct.
I currently have $495 in my possession here at the jail. Is there any?
It sounds like it's time for a phone call. Okay.
Oh, okay. So then I can call and have somebody else.
Absolutely.
$5 is all they would need to bring.
That's right.
Okay.
Anything further, sir?
No, sir.
All right. Thank you.
Thank you, Your Honor.
Stay on the path.
Thank you.
Sounds like it's time for a phone
You
call.
have a young man, Nicholas Sierra.
Okay.
In 2. And he claims that his phone is dying. So we'll see what happens there.
Okay. All right. Has he ever been arraigned or no?
I don't know that. Where did he go? Soliciting.
Yeah, that's what I
Just
saw.
to fail to appear on June 6th.
Okay.
Thank you.
Thank you.
Judge, are you going to leave us too? Oh, we get Tyler.
Hi, I'm sorry.
You're fine. Calling case number 24, B like Berkeley E 02157. This is people of the city of Berkeley versus Jemiah Erlene Johnson. That's you?
Yes.
All right. Ms. Johnson, the court apologizes for the delay. There was an emergency call in the city of Berkeley, which required PSO Tyler's attention. And then the court has had in between time in custody arraignments, which must take precedence because of their security nature. So you recall a little bit ago, the court explaining to you the nature of an informal hearing. Is that true?
Yes.
And at that time, the court also explained that you would be required to make a selection from one of three options related to your own rights, correct?
Yes.
Ms. Johnson, the citation before the court indicates that on June the 4th of this year at 20 minutes of 9 in the morning, you were operating a 2015 Chrysler white in color southbound on Coolidge Highway, pardon me, at or near 12 Mile Road in the city of Berkeley. And at that place in time, you were speeding a minimum of 6 to a maximum of 10 miles over the posted speed of 30. Officer Tyler's detail note, which appears on your ticket, indicates southbound Coolidge estimated speed of 60 plus in 30-mile-an-hour zone. Late for appointment, polite / cooperative. So
yes.
With that, Ms. Johnson, you have three options related to speeding 6 to 10 over, which is the citation, versus 30 miles over the speed limit. You may admit responsibility in this matter. You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take testimony. What would you like the court to do for you?
Admit.
Okay. So you wish to affirm to the court that you were operating a motor vehicle in the city of Berkeley that place and time, correct?
Yes.
And secondly, that you exceeded the posted speed limit by at least 6 miles an hour.
Yes.
Thank you. The court appreciates and accepts your plea. The court avails you every opportunity to explain, in addition to apparently being late for an appointment. What, if anything, would you like this court to know?
The appointment wasn't actually for me. It was for my boyfriend. He has severe sickle cell hemophilia, and he had to go get a transfusion. So that's the only reason why I was speeding like that. I work at the Beaumont. I'm a phlebotomist, so I had to drive all the way back to the west side. So that's really the only reason why I was speeding. I don't have no problem paying the ticket because I know what I did was wrong. But I'm really asking not to have points on my license if that's possible, because I'm also finna join the police academy, and I really would not like anything bad on my license.
I understand what you're telling the court. The court does observe, however, its complete neutrality, and it minds its own lane in terms of the separation of powers. So the court can't do anything to affect those points, but perhaps Officer Tyler can share some thoughts with the court.
Okay.
Magistrate, I'm not sure how the driver record looks like, but I know the Secretary of State does send a letter if this is her first offense. Is that the case?
Yes. I've never been pulled over before.
Yes. Born in 2005, and a driving record is clean as a hound's tooth, so to speak. So there's nothing on there.
I would be fine with impeding traffic.
All right, the officer is making a motion to amend this to impeding traffic, Ms. Johnson, which is a 0-point violation and will never appear on a master driving record. That is an acceptable outcome to you, correct?
Yes, thank you so very much.
Very well. Your original plea to speeding 6 to 10 will subsume a plea to impeding traffic, and it will be so amended on the payment of $175. That's payable through the pay portal on the 44th District Court website, or you can walk a cash, check, or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's going to be due within 14 days. The only advice I can provide, if any, in terms of how you found yourself in this situation is, the court is very sorry for the challenges that your husband appears to be experiencing, but if this were ever to occur again, either better planning, setting alarm clocks earlier, or even having friends or family or even a medical transport company take care of it would be a better option.
Yes.
If something were to happen to you because you were in a big hurry, then that would really leave him in a tough spot, correct?
Right, right. Yes.
Mr. Johnson, so 175 within 14 days, you take care. Good luck to you.
Okay, thank you.
So, all right, so. Don't think it does help, even if nothing is mentioned. All right. You should not observe that. The stairs here or like.
One step.
Calling case number 24, be like Berkeley E 01849. This is people of the city of Berkeley versus Kalia Monet Starks. That's you, miss?
Yes.
Ms. Starks, you were present earlier this afternoon when the court explained the nature of an informal hearing, correct?
Yes.
And at that time, the court also explained that you would be required to make a selection from one of three options in the protection of your own rights, correct?
Yes.
Ms. Starks, this citation is of a prohibited parking nature. It is indicated that on May the 12th of this year at approximately 2:30 in the afternoon, a 2019 Chevrolet Equinox blue in color registering to you or a member of your household was parked at or near Wakefield, or strike that, on Wakefield at or near Catalpa in the city of Berkeley in a prohibited space in as much as it was parked too close to a stop sign, within 3 or 4 feet of a stop sign, versus the standard 30 feet. So with that said, Ms. Starks, you have a right to admit responsibility in this matter. You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take testimony. What would you like the court to do for you?
I guess I parked too close.
Okay, so you admitted to the court that on the date in question, you were in control of, or there was a vehicle from your household parked as stated within that short distance to a stop sign. Is that correct?
Yes.
Thank you. The court appreciates and accepts your plea. Any input from the people through Officer Tyler?
I don't know what you could possibly do, maybe as far as payment.
That would be it.
All I can really,
You wish to perhaps leave that to the court's discretion?
Yes.
All right. Ms. Starks, this is usually a horrifyingly expensive ticket. At this time, the court is going to reduce that fine to what is the standard overtime at meter fine. So the court is fining you $20. That is payable through the pay portal on the 44th District Court website, or you can walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 14 days. The reason you have to have that distance to a stop sign is all about sight lines and safety for other people. Okay?
Yes.
Just keep it on the square in the future. Good luck to you. That completes your hearing. Take care.
Okay, thank you.
I want to know how much the horrifying amount is. It's like a $500 fine or something. Peso Tyler, what else you got?
Oh, it's true.
Anything else, Judge?
Hello.
Hey, Elizabeth.
Calling case number 24, be like Berkeley E 01584. This is people of the city of Berkeley versus Elizabeth Amy Sackley. That's you.
That's me.
Ms. Sackley, you were present earlier this afternoon when the court explained the nature of an informal hearing. True?
True.
And the court also explained that you would be required to make a selection from one of three options related to rights, correct?
Correct.
Thank you. So the citation before the court indicates that on April the 26th of this year at 3:02 in the afternoon, you were operating a 2016 Jeep Cherokee gray in color on Beverly at or near Bacon in the city of Berkeley. And at that place and time, you disobeyed a stop sign. Officer Tyler's detailed note, which appears on your ticket, indicates went through stop sign at westbound Beverly Bacon in front of elementary school, slowed slightly before quick left turn. So the citation before the court is disobey stop sign.
A rolling
You
stop.
may admit responsibility in this matter. You may admit with an explanation, or you can deny responsibility. We'll swear the parties and take testimony. What would you like?
I admit responsibility. I will admit responsibility.
Very well.
I want the
So you
explanation.
made it a point that on the date in question, you were operating a motor vehicle in the city of Berkeley, correct?
Correct.
And at that place and time, you did disobey a stop sign, correct?
I did.
All right. The court appreciates and accepts your plea. Perhaps the more troublesome feature here is the proximity to a school. What would you like the court to know, Ms. Sackley?
I was in a very huge hurry to pick up my daughter from said school, and that was a misstep on my behalf.
Okay. So you seem like a very squared away woman, intelligent. You understand why there's a motor vehicle code, correct?
Yeah, correct.
It's like a big global safety regulation.
Absolutely. I work for the city of Ferndale. I know.
All right. I appreciate that. I don't need to lecture any further. Officer Tyler, what, if anything, would you like to say?
Hit it with a
If there's
maximum
anything
penalty.
we can do with maybe payment.
Okay, very well. Disobey stop sign is historically
Officer Tyler's a pushover.
$150 fine. The court is going to reduce that to $100.
Okay.
Ms. Sackley, that will be payable through the pay portal on the 44th District Court website, or the court, like that, or you can walk cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's going to be due within 14 days. Okay.
Ivan, that
Okay,
global
great. And so
parking
no
code.
points?
The court can't do anything about the points. That is purely a function of reportage from the clerk. This court is neutral. It does not have the statutory authority to erase the points. Is there anything?
That's it.
All right. Thank you.
So you get points.
Thank you.
Global parking
Bye.
code. It's part of the New World
Bye.
Order, apparently. Global parking code. Okay, so Tyler, are there any other lame tickets you wrote in the last week that you'd like to lower the charges on?
I'm not either. I'm sorry, say that again?
Mr. Sear.
Mr. Sierra is the Samsung.
Oh, great.
Oh, great.
So I think this might be
Oh, great. It's a
Officer
Samsung.
Tyler's last one. Individual on the telephone, 5686. What's your name?
Yes, Joy Tyczynski.
What?
Say the name again slowly.
Joy Tyczynski.
Tyczynski? Don't ask me to spell that.
Do you see that, Miss Rebecca?
I'm sorry?
Why are
Can you
here?
spell your last name nice and slow and loud, please?
Of course. C, Z for zebra, A, I, C, Z for zebra, Y, N, S, K, I.
C,
Stand by, please.
T, D, E, D,
Officer
T,
Tyler, that would appear to be
C, T.
it for you. The last gentleman, Mr. Arnold Lawrence, will be marked as an FTA.
All right. Thank you very much.
Stay safe. Have a nice holiday.
You
See
too.
ya-
Thanks.
See you, Officer Tyler. Good to see you again, though, bud. It's the second time we've caught him on here. Let's see if there's any other officers who need to step in. Or are we done? I was saying we've been planning to show the Canton
Can you
Select
spell
Board
it one
meeting.
more time?
Of course. C, Z for zebra, A, I, C, Z for zebra, Y, N, S, K, I.
We got it on
Stand
our
by.
end, Your Honor. DMB secondist nailed it first try.
You?
Oh, you're welcome.
They're still looking for the case. Anyway, we were going to show the Canton Select Board meeting tonight.
And,
It looks
while
like it
the
might not be held today. It might be
Court
1 week
reporter
out.
is looking that up. Do you have a case number, miss?
I can look it up on my email, but I don't have any of that documentation with me, sir.
All right. Miss, you're scheduled for July 30th at
You're
at
a
2:01.
little bit
So
early.
you're here plus or minus
a month early.
28 days early.
It must have just happened.
Okay?
Okay.
All right, we'll see you.
The
on July
paperwork
30th.
said today, I'd rather be early than late, so, okay. Yes, sir.
That makes sense. We'll see you in exactly 4 weeks. Take care.
You too, thank you. July 3rd, hello?
July 30th at 2:01 p.m.
Confirming again. Thank you so much. Have a wonderful
2:01.
afternoon and holiday.
You as well. Happy birthday, America.
Thank you, sir.
Happy birthday, America. That's how he
So-
signs off. And they're done. They killed it. All right. We've got a couple things going on. A lot of people have been asking questions about what is happening with what is happening now with the Karen Reed case. Because of that, there is an upcoming live stream that I'm going to redirect to that is, I believe it's Surviving the Survivor, that is starting probably in a little while. It's not starting right now, but we're gonna portal people over there so you can click the like button. This is the Karen Reed trial, a jury divided, and Trooper Proctor's reassignment. That's going to be their subject matter. They're going to go into this a little bit. I realize there are some other people who wanted to redirect to different ways. I'm sorry, I can't redirect to everybody at the same time. But they're going to talk about Trooper Proctor's reassignment, so it'd be interesting what they have. Also, if there's probably a juror that's talked, that might be on there as well. Then that might not be everybody's cup of tea, but in the meantime, go to Vicky's. Do the Vicky's. All right. Anyway, I thought it would be interesting to hear that. I personally like to see different perspectives, even from sides that I may not agree with, and sometimes I don't even agree with the way it's presented. But I can only open one portal at once. If there's a new way to do dual portals and let you choose, I would do that. That would be awesome. But Vicky Mack's going to be live here in a little bit to give you some more entertainment here this afternoon as well. So make sure you sub to her. She's doing well. Ada K. Brown is approaching. Ada K. Brown, I think it's alternate juror. Ada K. Brown, alternate juror, is approaching 1,000 subscribers. I think she's about 230 away from hitting 1,000. She'd love a follow if you care to go over there. She's covering some of the Karen Reed stuff as well. Lawyer begins at 3. Yes. I don't know if we have a Friday Night Frenzy this week or not, but I am really looking forward to Rob's take on what happened in the Young Thug developments that we've covered in some of the documents and have his explanation. So yeah, there's a ton. Vicky, don't wait. Overlap. You're fine. Runkle said he might do FNF. That would be awesome. I'd like Runkle's take on it as well. That would be really cool. I think Rob said he was off this week for some reason. Proctor fired, alternate juror speaking out. Yeah, I'm gonna read a little bit more about that. We're still gonna keep track of documents. We've got a few things we're watching specifically out of Orange County, Florida. We're waiting for that first letter from Sarah Boone to the judge now that she is her own lawyer. That's gonna be quite spicy. I think that will come very soon. She has very little time. She needs to act now if she wants to get anything in front of the judge. So we're looking for that correspondence probably within the next week or so. Rob is off. Her uncle said last night he might do something. That would be great. Lawyers like taking the week off. It's because it's the holiday week. And honestly, no real courts are starting on the 4th of July week. So it's just court hopping this week. Next week, we have big cases starting again. We've got both the Alec Baldwin trial, which we're going to be following, and the is it Benefield? Is it Ashley Benefield? Why am I thinking Ashley Benefield? It's Black Swan, I believe. Both of those going on. Let's see. If he's not going to do an FNF and Rob's not going to do an FNF, I don't know. We might look at doing something to give somebody something to go to. But it's a holiday weekend, but I know a lot of you are looking for that entertainment even on a holiday weekend. I think we all drive to RA's house for a big July 4th party. I was planning on going somewhere else, Lois. That's the problem. I was planning on going to Little Washington and watching the fireworks on the river there. But PSA, don't get arrested Wednesday. You won't get bond till Monday. This comes from someone who knows. Don't ask why. Everyone needs a bit of a break after KR. This is the end of the trial session too. Like the trial windows, they seem to rotate and go in spurts, and it will. Sometimes it's a drought and a famine, and sometimes it's a feast. And the feast is coming up. It starts next week. Could do a Friday night panel. We could. You can go to your house, free beds. We finally got an Airbnb, somebody to clean our Airbnb, which is great because they agreed to do it for the same price that we charge the people who come to the Airbnb, which is, believe it or not, the cleaning fee costs more than renting it for a night, but good stuff. Are you going through Missouri on I-44? I thought we were going to take the high road because there are three ways we can take to get where we're going. I think three main roads. There's like a low road that goes through Tennessee, and then we can like split up. We could even go up through Ohio. I think we were going up through Ohio. We might take a different one on the way back. I'd have to check and see. I don't remember. So you need to catch up with the most current barrel wobble. I think the wobble keeps wobbling or curving north, which has everyone in Texas a little concerned. They're on the Gulf Coast. Highway 72. I'm just following Siri. If the phone dies, I'm not getting there. That's how my vacation is going to go. Yay for Ohio, says Ohio Jen. Till the next chat. Yes, we'll do that. All right, we're going to take a break. Vicky Max starting up right now. I've still got the link to SDS. If you want to watch that, I'd click the remind me thing. They're going to talk about Trooper Proctor a little bit, which I'm going to listen to. Aussie Insider has a new video out. There's good stuff all over the world of true crime. LawTube and LawTube adjacent. I thought you told Carrie you were coming through Missouri. I think we are. I don't know. I don't remember. This is RA. Of the three routes that we could take, there is a 15-minute difference. Like one of them takes us up to the Great Lakes, and the other one practically goes through Texas. And it's a 15-minute difference on the total trip. So anyway, well, I'll figure it out, and I'll try to let you guys know where I'm going. I don't know right now. Originally, I think it was going to be Missouri. I think we are going through Missouri. That sticks in my head like that was one of our choices. Brandy's on Ada K's channel right now. That is awesome. We might pop in there as well. I can't link to Ada K's. I tried that as well. She was one I wanted to link to. I'm not able to do that yet. She has to turn that on. Guys, tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again tomorrow morning, 8:45-ish. More court hopping fun in this break between big trials. We'll see you then, unless something big happens, and then we'll see you before then. So thank you all. Appreciate it. Thanks all the mods. Thanks to all of you for making this community the great place that it is, and so welcoming for everybody else. Welcome. Everybody, be good to each other. We'll see you tomorrow. Have a good one.
Shame on you, sir.